Zapraszam wszystkich Państwa do zajęcia
I would like to ask everyone to take their seats.
Dzień dobry.
Good morning, ladies and gentlemen. I'm pleased to welcome all of you here
na
at the
9.
9th
Seminarium
Warsaw
Warszawskim
Seminar
organizowanym przez
co-organized by the
Ministerstwo
Ministry of
Spraw
Foreign
Zagranicznych
Affairs
i Krajową Szkołę
and the National
Sądownictwa
School of
i
Judiciary and
Prokuratury.
Public Prosecution.
Proszę Państwa,
Ladies
tylu
and
świetnych
gentlemen, we have
gości,
so many
niech mi
eminent
będzie jednak
guests, but let me
wolno,
first
tylu świetnych i znamienitych, niech mi będzie wolno wymienić kilku
name
gości,
a few
których
guests
bardzo
that
serdecznie
I would like to
w pierwszej kolejności
welcome,
witam
especially I would like to welcome
pana
first
Stanisława
Mr. Stanisław Trociuk, who is the Deputy Ombudsman.
Równie gorąco witam
Warm
prezesa
welcome
Najwyższego
to
pana Lecha
Lech
Paprzyckiego.
Paprzycki, who is the President of the Criminal Chamber of the Supreme Court. Let me also extend a warm welcome to the co-host of this conference, Under Secretary of State, Minister Artur Nowak-Far, Under Secretary of State in the Ministry of Foreign Affairs. I would like to extend a warm welcome to Representative Deputy the Chairman of the National Judiciary Council, Mr. Krzysztof Wojtaszek. Warm welcome, although the weather may not incline us to be so warm. Let me welcome Professor Lech Garlicki. I would like to extend a warm welcome to the Director of the Council of Europe's office in Warsaw, Ms. Hanna Machińska, Dr. Hanna Machińska. I would like to welcome Judge Wojciech Hermeliński. Good morning to you, Honorable Judge. I would also like to welcome Professor Nina Półtorak, representative of the Supreme Administrative Court. I would also like to welcome Director Plenipotentiary Justyna Chrzanowska, the co-organizer of this event and the initiator of this event, which first looked a bit risky, but I hope that after the seminar it will be certain that we will move the seminar from Warsaw to Lublin. Maybe not permanently. Interesting postulate. I don't know whether we are so vociferous, but we will share that honor. I would also like to extend a warm welcome to Luisa Sałata, who is the Plenipotentiary of the Minister of Justice. Here with us is also Director Representative of the Highest Chamber of Audit, Zbigniew Wrona. Let me also extend a warm welcome to a representative of Ombudsman, Mr. Mirosław Wróblewski, who is the Director of the Group of Constitutional Law. With us are also representatives of the Justice Administration System. I would like to extend a warm welcome to Judge Jacek Czaja, and Judge and former Undersecretary of State in the Ministry of Justice. I would like to extend a warm welcome to Judge Cezary Wójcik, who is the Deputy Chair of the Appellate Court in Lublin. I would like to welcome Appellate Court Judge Mr. Pogoda. I would like to welcome Prosecutor of the Appellate Prosecutor's Office in Kraków, Janusz Śliwa. Also with us is the regional prosecutor's prosecutor, Mr. Cezary Maj. Also with us are representatives of our wonderful panelists, representatives of the academia. I would like to extend a warm welcome to Professor Mirosław Wyżykowski. I would also like to extend a warm welcome to Professor Dariusz Dudek. And I would like to also extend a warm welcome to Professor Flączak Wątor, who is from the Jagiellonian University, Constitutional Law Chair. I would also like to welcome Bogdana Słupska-Łódkiewicz, who is the representative of the National Bar Association, a member of the Human Rights Committee. If I fail to mention someone, please excuse my fault. I think if I were to continue this list, it would take too much of our precious time and leave less time for discussion. Again, a very warm welcome to you here at the National School of Judiciary and Public Prosecutors in its Lublin division. I'm very happy that this seminar is taking place here because, ladies and gentlemen, the building itself has a very interesting history, and in a sense it has also been part of history. That's part of human rights. It struggled for human rights in 1989. Here the civic, not club, but committee of solidarity had its seat here that was later transformed into a parliamentary club, a club that fought so strongly for the freedoms and civic liberties, thanks to which we can meet today. Let me also mention that briefly that during coffee break or lunch break, I would like to invite you to take a tour of the building. In 77, this building was first built. For many years, it was a bank. It used to be a commercial's office. The first bank was here in 1896, and we have some interesting remnants of the banks. We have an original treasury box from the interwar period, and the safe that I think most of you have seen, and the Wabank siebie, and this safe featured in a famous Polish movie. And this safe is still closed. Maybe some of you will take a chance and try to open this safe because it hasn't been opened so far. Ladies and gentlemen, I would like to note that the National School of Judiciary and Public Prosecutors that trains judges and prosecutors, it's been operating since 2009. From the very beginning, the school began to operate very intensely when it comes to training of the justice system staff. The Lublin Center is training active judges and prosecutors and also other members of the judiciary. We focused our activities on three areas: national activity, international activity, and cooperation with other entities. And let me tell you briefly, there were many stages, and we are very thankful for the support that we have already received. And let me also thank Professor Lech Galicki, again, Renata Degener from Strasbourg, who's not here. They have really helped us to prepare this training program. Since 2012, every year the school has a special point system training on human rights protection. The assumption of this training is for every interested judges and prosecutors to be able to participate in this training. It's a very practical way of training, so it's not just not only references to losses. It takes care. We are going through cases, human rights cases that deal with Poland. This program was modified in cooperation with the Ministry of Justice. Right now, ladies and gentlemen, we put emphasis on having courts that have many failings in human rights judgments to have trainings about failings of specific judges in this field of justice system. In my opinion, this is a very important and modern approach because so far a Polish judge, this first-line judge, he was a bit sort of detached from the facts and he was not able to receive feedback, only the feedback received to the what meant to the court, to the judge that issued the ruling. So again, we would like to thank the Ministry of Justice for its support, for the fact that it also supported us with our staff, and we are conducting joint trainings. Of course, international activities, thanks to this, Lots of Polish judges and prosecutors had a chance to participate in different forms of exchanges, visits, on-the-job trainings, thanks to which they were able to familiarize themselves with the standards of this very interesting issue. Ladies and gentlemen, yesterday I had a chance to participate in the inauguration of a conference co-organized by the Catholic University in Lublin on computerization of the justice administration system as well as courts. Today we have the Warsaw Seminar. Tomorrow, also in Lublin, as a ceremony of handing Zbigniew Hołda award, and the President of the Constitutional Court will be present in Lublin. So for those 3 days, Lublin has become the capital of Polish jurisprudence, and we are very happy that this is so. But it also leads us to a reflection, especially on the margins of yesterday's conference. So much was spoken about computerization, automatization processes, even in adjudication. I do hope that today's conference will relate to some a bit different rules, because the subject matter of the different presentations and the whole conference itself, for me, brings to mind something that we studied as first-year college students, use as ad boni effecti. So our law is a good, is art of good and equality. I'm very happy that the presentations of the speakers today will refer, in my assessment, to this rule. It would not be good if we were only to focus on this modern infrastructural form, which is of course necessary, but in the focus is human being, individual, and his or her rights. So I do hope, ladies and gentlemen, that the conference will give you a good inspiration to remember the basic form of civilized laws. So with this, I would like to wish you a fruitful debate, and see you later.
Ladies and gentlemen, it gives me great pleasure to extend my welcome to you to this year's 9th seminar, Warsaw Seminar, which has been co-organized by the Ministry of Foreign Affairs and the National School of Judiciary and Public Prosecution. This edition is particular for that particular reason, given the venue in which we accommodate the conference. This is the Warsaw Seminar held in Lublin, and also due to the subject matter under discussion, it is devoted to the dysfunctionalities of the Polish law. Here, in the edifice of the National School, people who participate in the administration of justice improve their qualifications, and we are gathered here to answer the most fundamental question: how to improve the legal system in Poland in order to allow it to serve better all citizens of Poland and all entities that find themselves within the boundaries of Poland, even if they would not be Polish citizens. What to do in order to enhance the real effect of the Council of Europe standard on the rule of law, especially with regard to observance of human rights. And I think that the National School of Judiciary and Public Prosecution is an ideal place to put such a question and to try to find an answer to this question. The answer to this question will not be easy. For 2 decades now, Poland has been functioning within the Strasbourg system of human rights protection, and many changes have been put in place to improve the standards of remedies and safeguards. Nevertheless, further discussion is needed, since Strasbourg standards tend to change in time, and the European Convention, according to the definition of the European Court itself, is a living instrument, and its interpretation follows the social changes all across Europe. The provisions and standards provided by the Court until 1990s of the 20th century, now in the eve of the second decade of the 21st century, will no longer be sufficient. In spite of streamlining and reform, year in, year out, the Polish government is notified about incoming complaints, which are like a litmus test to show where our national law and legal practice does not fully comply with the human protection standards as defined by the court. Today we will have many prominent representatives of the academia and practitioners, and such elements of the national remedy system will come under discussion, which, due to the specificity of proceedings before the court, will require further deliberation. The panelists will present their own views and sentiments on the issue. Is it necessary to amend law in every and each case or not? They will also visit the subject of the general remedy. They will also share with us their reflections on the role of the legislator in the constitutional courts, universal courts of laws, and administrative courts and public prosecution in securing effective remedies in situations of violating the rights and fundamental freedoms as guaranteed by the Convention. I hope that those very valuable insights will be a very important point of reference for the future discussion, which will be ongoing not only in this very edifice, but also in the communities from where you come, because I do believe that you come from various corners, from various walks of life, but you are very important in your respective communities when it comes to knowledge and application of European standards. Welcome, and I wish you very fruitful deliberation. proszę, ale to na przerwę już poproszę o podgłośnienie. Thank you very much. First and foremost, let me thank you for inviting me here. I'll try to live up to the expectation and the proud traditions of this edifice. And Dean Dudek mentioned it to me that also the edifice hosted evening classes of the Communism, Leninism and Marxism University. Now, coming to the mainstream, speaking about the model way of application of a convention, preassumes a general convention and general approach to the convention. If we speak about the convention, we mean in fact the jurisprudence of the European Court, as much as it is the case with long-standing constitutions, old constitutions. The text is general enough and without any more precise construction. The text itself, the wording itself, will not be able to play a real role or be a benchmark for application. So when we speak about application of the convention, what we have in mind is the application of jurisprudence of the court in Strasbourg and the national jurisprudence, which has been somehow confirmed, developed or questioned by the court in Strasbourg. Another issue that must be taken into account is who is the addressee in the application of a convention. In this very circle, I will try to focus on the role of the court and the prosecutor's office, and we may somewhat brush aside the importance of the legislature, which is also important. My third point, as regards the situation, we must draw a distinction line between the situations which precede any cases of violation of human rights and decisions of a court in Strasbourg, and the situation where certain cases are determined and examined on the national level. And this is indeed the vast area for having convention applied on the ground, and this is what really happens in civilized countries like Poland. And finally, we have follow-up situations where the convention has been violated, infringed upon, and when there is a decision from the court in Strasbourg, and the decision must be enacted. But these are very rare situations, because in real terms these situations do not constitute such a majority. Well, let me start by saying that the convention is the binding act of law. It is an international agreement. It is binding on its signatory states parties. And just to recall the German case Golnilub, where the Strasbourg court was adjudicating in a very routine case of giving the right or providing the right to contact a child for divorced parents who no longer were together, and the rulings of German courts which excluded such an opportunity for the father of Turkish origin were deemed to be in violation of the convention. So the applicant filed new cases before German courts of law asking for the case to be re-examined, and the German courts one by one issued their decision denying him the right to see the child, and they stated that the convention is binding on Germany as a signatory state, but does not bind them as courts directly when they adjudicate in this particular case, because there is no direct effect of the convention, and the effect of a convention is only relevant to international relations. The case landed in the European Court, and the court gently tried to persuade to the German courts that this is absurd and that the convention is binding upon all institutions of a state that is applying the convention, and that all courts of law are absolutely obliged to play by the letter of the convention and the jurisprudence of the court in Strasbourg in all cases that have been filed to the courts and where convention may be relevant, unless, and this was just a small irony, unless there is a collision with a German constitutional order, but this is another case which doesn't have to be examined right now. So this lesson that was taught by the court in Strasbourg to German courts of law was a very strict lesson, clear-cut lesson, and certain things were called by the name. And if such a situation should arise in Poland, in any Polish institution, and should it be examined by the Polish Constitutional Court, the position of the Polish Constitutional Court would not be different and divergent. And this brings me back to the first point, speaking about the model application of the convention, that is the ex-ante application of the convention before any instance of human law violation is really found. Application of the convention by all state institutions which are confronted by various situations. This includes courts of law. And even if this is universally known and to be derived directly from the Polish Constitution, the Convention is the international agreement ratified in a very difficult way under Article 91 of the Polish Constitution, and in the light of the Polish Constitution, it is a part and parcel of the internal Polish law, which is of direct application and is not in collision with the Polish Act, but should there be any collision, it will precede over the Polish acts of law unless there is any conciliatory construction possible. So it is extremely important to make sure that any court of law, any prosecutor, should treat the convention as part and parcel of binding law and not just a document that belongs to the exotic platform of international relations relevant only to the Minister of Foreign Affairs. No, this is part and parcel of binding law to be applied on the ground, and any reasonable judge or prosecutor, while applying a Polish code, this or another code, applies also the jurisprudence of the courts of law, and while applying the convention, he or she will also refer to the jurisprudence, to the explanatory rulings that have been issued by the court in Strasbourg and by the Polish common courts of law, especially the Supreme Court. In other words, if there is no way, or let me put it differently, if there is a case, a situation which in a way has bearing on human rights which are safeguarded and guaranteed by the letter of the European Convention, the best way to apply the convention is just to reflect on it, whether a case, a situation in question could be resolved in a way that would be compatible with the standards imposed on us by the convention. Does it mean that in any and every case the convention should be directly quoted and applied? No, of course not. We have also Polish jurisprudence, Polish tradition, so once we have mentally checked if the result obtained is compatible with the Convention, we do not have to quote the Convention for decorative reasons. However, where there is any problem concerning the construction, the interpretation, then the application and quoting from the jurisprudence of the Polish law may require additional quotation of the Convention, referral of the Convention, which is an option available to a judge. Very much the same way, the judge can also refer to the Polish Constitution, where the mechanic application of certain lower level provisions may lead to unconstitutionality. The same goes for the Convention and the jurisprudence of the court in Strasbourg. But there may be also an option to quote from the decisions of the Supreme Court of Justice and the Constitutional Court, and with the exemption of some courts who will rather support themselves by the jurisprudence of the Constitutional Court in Poland. But the founding fathers of the standards have also provided their jurisprudence, and the choice belongs to the judge. So even if this convention may not be visible, it must be present at the back of your mind, just to give you this option.
Jak się nie da przyjąć takiej wykładni przepisu, która zapewni rezultat wymagany przez standardy generalne, standardy ustalane przez Konwencję i orzecznictwo strasburskie, no to wtedy jest problem. Ale znowuż wydaje się, że sędzia nie jest wtedy bezbronny i sędzia nie jest skazany na obowiązek mechanicznego stosowania prawa polskiego, bo z jednej strony, jeżeli ten problem wątpliwej zgodności z przepisami konwencji pojawia się w odniesieniu do przepisu ustawowego, no to sędzia w sposób oczywisty ma prawo zwrócenia się z pytaniem prawnym do Trybunału Konstytucyjnego i tego oczywiście nie trzeba przypominać. Natomiast pytanie jest też takie, czy sędzia może sam odmówić zastosowania przepisu ustawy, który jego zdaniem jest sprzeczny z przepisami umowy międzynarodowej, konwencji, jako aktu przecież mającego rangę wyższą od ustawodawstwa zwykłego. O ile ja jestem bardzo stanowczo przekonany, że sędzia nie ma takiego uprawnienia w odniesieniu do badania konstytucyjności ustaw, o tyle gdy chodzi o badanie zgodności ustaw z prawem międzynarodowym, to już sprawa nie jest taka zupełnie oczywista. Przecież pamiętajmy, że gdy chodzi o prawo europejskie, jest z kolei oczywiste, że każdy sędzia ma takie uprawnienie. Więc to można się zastanawiać, czy w tym zakresie stosowanie konwencji przez sędziego nie mogłoby również przybrać charakteru takiego, że sędzia odmawia stosowania polskiej ustawy jako sprzecznej z konwencją, tak jak ją rozumie orzecznictwo Trybunału Konstytucyjnego. W sposób oczywisty dotyczy to aktów również podustawowych, no ale tu jak wiadomo sędziowie mają tą kompetencję w sposób generalny. Od sędziów rzecz jasna nie można wymagać za wiele, zwłaszcza w obecnym kształcie niektórych procedur sądowych. Wydaje się, że tą siłą sprawczą, zachęcającą sędziego do dostrzeżenia, podjęcia i rozwiązania problemu konwencyjnego jednak powinni być przede wszystkim pełnomocnicy stron. I to też trzeba sobie przecież wyraźnie powiedzieć, że nawet później dla postępowania przed Trybunałem Strasburskim jest rzeczą niezwykle istotną, czy strony w postępowaniu przed sądami polskimi podnosiły argumenty konwencyjne,
Conventional arguments are raised, how they were raised, and to what extent these arguments were accepted or disapproved by a Polish court. So all these in turn remarks reflect the prosecutor and the court role, because they take the decisions, but they also refer to a large extent, to a very large extent, to the role of
tutaj
the
jest
aid
kwestia
of
zachęcenia
the lawyer who
podejrzenia
represents his client before the court, and it's up to him or her to suggest
I to jest ten model
an option. So this is an ideal option model, as I said, an ideal model where the decisions of certain cases or situations are decisions that do not raise objections when it comes to the standards of the Convention. Again, in this ideal model, the European Convention, like the Constitution, usually is hidden somewhere deep in the thinking of a lawyer, because there's no need to take this argument openly as the basis for a decision, but he has to have it in the back of his mind, in a way. And in situations when there's no simple solution, in the context of the Polish case law or Polish law, and this convention should, and it really not only could, but it should, under Polish law, should be applied. And this is one group of problems, in a way, which in practice is very important, maybe most important. But there's also another group of problems, and they deal with situations where the European Court had to issue judgments on some situations. Of course, this is individual cases, and in their rulings, the European Court held that the Convention was violated. So, in a sense, this, in certain extent, this ruling is binding on Article 46 of the Convention. The state has to implement the judges. The state is not only Director Chrzanowska, but the state is all the bodies that are affected by the European Court ruling. So if we set aside the problem of Article 46 of the Convention and just satisfaction, which is another issue, and here the bodies except the Ministry of Foreign Affairs deal with it on exceptional basis, then remains the problem of eliminating the violation. Sometimes it's too late because the violation has already happened, so it cannot be reversed. But in many cases, a violation could be sort of redressed based on actions done by different bodies, including courts. As we know, one of the basic reactions in this issue is to resume proceedings in one another form, and as we know, reopening proceedings under Polish law as well as other laws. Are not entirely clear on all issues of procedure. I think the situation is pretty clear. I'm talking about this under the control of President Kaczyński when it comes to criminal law, because here Supreme Court is very consistent, it's very pro-conventional, and the Supreme Court has been regularly accommodating the Strasbourg rulings. So it's a rule, but this is also a sphere where the Council of Europe clearly demands that cases are reopened. The issue becomes much more complex when it comes to civil procedure, and as we know, the position of the Supreme Court is characterized by a certain reserve, which is of course understood, or can be understood, because once again we have to stress, as I said, as I mentioned the German case, resumption of proceedings in civil cases is risky. Reopening of proceedings also when it comes to the protection of third-person rights in situations which were sort of finally adjudicated. We have to go back to that. So again, here, I believe, to a much more extent, one would expect from the lawmaker to create an effective mechanism of damage liability when it comes to civil cases, but when it comes to the right of reopening proceedings, it should be regulated in a more cautious way when the other party is the state treasury, that is not a public entity, then the problem is not so big. But when it comes to third parties, we need to be more cautious when it comes to administrative courts, again, we're in the middle. We're now treading the middle ground because the judgments can also involve third-party rights, but I think that these issues require much need to be carefully looked at by the lawmaker. And this leads me to my final remark, what we should expect from the lawmaker. Again, this depends on the issue that we're talking. When we're talking about the specific judgment and the execution of a specific judgment and the process, this is a matter that is related to procedures of reopening and of damages, and the lawmaker will not need to intervene. But we also have to be aware that European Court of judgments are very often precedents, and their legal meaning will go beyond the specific case it affects. On the one hand, it can involve other issues which are identical issues. We have a lot of cases that are similar in type. That is judgment on one case is de facto a decision regarding similar cases, as reflected by the present current draft of the criminal court procedure. But if there are Polish cases, and on those Polish cases there is a European Court judgment concerning case A, and cases B to X are identical, then this obligation to execute the judgments is very obvious. And this is just like the obligation to implement individual judgments. But whether in situations when we have many similar cases, against this background, we can also assume there's a more model problem. And that problem may require the lawmaker to intervene. Nonetheless, I think that the judge should not look too optimistically towards the lawmaker and believe that the lawmaker will react and address the problem and additionally regulate the problem adequately, because as we know from experience, the way Parliament draws law is not fully coordinated, and the law is not fully consistent. So I think that as long as a judge can improve the law thanks to his or her own decisions, this is a much safer solution than a solution whereby we expect the Parliament to do something with the law. And the most recent example, a judgment of the United Kingdom High Court on assistance to persons who are terminally ill, when the Supreme Court said, yes, Convention would require ensuring immunity to persons who have assist person who is terminally ill. But this is so complicated that lets the lawmaker solve this problem, because there's a bill, and the lawmaker rejected the bill, and again we're in the point of departure, and we'll see what the Supreme Court will do. And I think this is a very stabilized jurisdiction, and it should do something. And finally, the final issue is that if we treat European Court judgments not only as judgments that point to the obligatory way of solving a specific issue which gave rise to the judgment, but as something that has a broader context, so there's no reason to not to give authority of precedence to all the judgments that do not affect Poland, but are issued in cases affecting other countries where this is more relative, and this always requires the court to examine whether the court has not limited the scope of its adjudication to a specific case, but everywhere where there's a general standard formulated by judgment, This general standard has a legal meaning for a Polish judge or a Polish prosecutor, and as such judgment has to be taken into account in exercising the role of judges and prosecutors. So this is all when it comes to reflections addressed to judges and prosecutors in line of this spirit of university of Marxism-Leninism. I try to sort of motivate you positively this and in the way Nova Gitka and the way Marxists did, so I hope that I have fulfilled my role in some modest respects. Thank you very much. Thank you very much, then, Professor. I think that you've raised a number of interesting issues. From my point of view, what I find very interesting is the reopening of proceedings in civil cases, and I personally do agree with you, Professor, that reopening of proceedings in civil cases should not take place in an automatic way. It requires reflection, but we need also to protect the rights of third persons. So this is not a simple relation between a state and a citizen, but we often have another sort of party to this dispute, which did not take part in the proceedings before the European Court of Human Rights. It seems to me that a very interesting issue that you raised, Professor, is the damage liability, where in civil cases the European Court of Justice saw that the convention was violated. I have seen Polish judgments made that said it was a prejudicial and under Article 417 prim, so this was a basis to construe redress for damages. So perhaps our judgments here have not been fully developed, but it seems to me that we can achieve this effect, and in this way we sort of easily flow into the next subject that will be presented by Professor Dariusz Dudek, whether a change of law is always the necessary remedy for every human rights violation. Thank you very much, everyone. I would like to thank the organizers for inviting me to participate in this seminar. This is an undeserved honor, and there's no reason. Maybe it's because I'm from Lublin, that's why I was invited. The subject of this paper that I'm to deliver, whether every time a change of law is a necessary remedy for every violation of human rights, this title was formulated as a question, but this is a question of it.
Na tak postawione pytanie logicznie można odpowiedzieć tylko w dwojaki sposób.
Two answers logical to such a question,
Tak
yes
lub
or
nie,
not.
twierdzący lub przeczący.
Affirmative or negative.
Trzecia
The
możliwa
third
odpowiedź
positive
jest wymieniająca, to
is
zależy.
depends. The third
Takie
answer, it
odpowiedzi
depends.
często używają, czy udzielają prawnicy praktycy pokładający
Practitioners
relatywizm.
or
Ale
relative
nawet wystąpienie
say that,
profesora
but even
Galickiego,
Professor Galicki in his
którego fakt wystąpienia i obecność mnie nieśmiela nie z
I'm
powodu tego,
very
że to był
much-
kiedyś bubnut, tylko z powodu tego, że to mój
he's my
recenzent
his
i to
reviewer
w czasie mojej
during
ścieżki
my academic
kariery
career,
naukowej.
quote
Ale
unquote,
nawet pan
but
profesor
Professor
też
Galicki was also
pokazywał, że
showing us that
sytuacje
the
mogą być
situation may differ
zależnie od
depending
tych
on
sytuacji. Różne też są działania. Proszę
and
Państwa,
depending on
uważam,
the
że
situations,
postawione
we act
pytanie
differently. So
to nie ja je
the
sformułowałem.
question was not formulated by
Nawet
me
bez bliższego wglądu
without really
sytuacji
looking too
intuicyjnie
much into it,
ewokuje czy
by
prowokuje odpowiedź negatywną.
intuition.
Nie.
We are provoked
Nie
to
zawsze zmiana normatywna,
negative
zmiana
answer.
stanu prawa
No,
obowiązującego jest
not
właściwym,
always a change of
skutecznym,
law
adekwatnym
is
remedium na każde
effective
naruszenie
remedy for every human
praw
rights
człowieka.
violation.
Więcej, z
What's
doświadczenia
more,
naszego
we
wynika,
know
że
from experience that
jeśli nawet zmiana wydaje się
if a
normatywna,
change seems
konieczna, to
normative
nie zawsze dochodzi do skutku.
is necessary,
Mówił o tym również pan profesor Gardycki, pan
it does
sędzia.
not always
A
happen.
jeżeli nawet
And
dochodzi,
if it does
to nie w takiej
happen,
postaci, jakiej byśmy
then
oczekiwali.
the shape of it's
No,
not what we
wreszcie
would expect or had
Trzeba też
expected.
powiedzieć, że
And last but not
chyba
least,
odrzucamy
I think we
taką
reject
pokusę fideizmu prawniczego, czy
legal
myślenia, że
fidelity
jeżeli jest jakikolwiek
attempt
problem najlepszą
that
reakcją jest
if there's a
reakcja
problem,
prawodawcza czy
the best
ustawodawcza.
reaction is to change
Taka
law.
dyrektywa jest problem społeczny czy inny. Uchwalając ustawę
If there's a
byłoby to
problem,
rzeczywiście przejawem
let's
skrajnej naiwności.
draft a law that
Nie
would
jest
be
prawo, które
extremely
wróci do
naive.
szkoły, jakimś
This
panaceuszem na
law
wszystkie
is not
problemy życia
panacea
społecznego,
for every
także na różnego
ailing of
problemy
social or
życia
political
człowieka.
problem.
Dodam jeszcze, że tytuł zleconego wystąpienia zawiera
The
pewnego
question
rodzaju
of
pułapkę.
the presentation I was
Naruszenie
commissioned
praw
to do
człowieka może, tak mówiąc,
has a
powodowo
trap
nastąpić w różnych
because
sferach.
human
Czyli w
rights
sferze
violation
stanowienia prawa,
can
kiedy
happen in different
wchodzące
spheres
prawo niejako
when
bezpośrednio samoistnie godzi,
law is
ingeruje w sferę praw
created and
człowieka,
then it
albo w
can
sferze
interfere,
stosowania, to
but
są umowy
also
określone
when the law
prawa,
is
na
applied
przykład w orzecznictwie
in
sądowym,
court
albo jednocześnie w jednym i w
decisions
drugim.
or simultaneous in
Oczywiście
both
tę
areas.
sytuację spotykamy w praktyce jeszcze
Obviously,
bardziej skomplikowane i
practice
złożone,
is even
kiedy
more
przy
complicated
właściwym
when
stanie prawa
a
dochodzi
law is
jednak do naruszenia
proper
praw
and still
człowieka
human
przez organy
rights
stosujące i odwrotnie.
are violated, and vice versa, as
Kiedy
Professor
pomimo ułomności
Terlicki
prawa
mentioned,
organy
despite the
stosujące
failings of law,
potrafią znaleźć właściwą
adjudicating
interpretację czy
bodies can
właściwą
find the
ścieżkę dla
right
uniknięcia
interpretation or
takich
right
naruszeń
path to avoid
bez
such
uszczerbku dla
violations
praw jednostki.
without harming the
Wreszcie,
rights
proszę
of
Państwa, samo
individuals.
pojęcie
The
tytułowe zmiany prawa
title,
można
The
rozumieć
Change of
wielorakie.
Law, in my presentation,
Takie, które nam się narzuca
can be
intuicyjnie, to
interpreted
jest
differently.
zastąpienie
Intuitionally,
jakiegoś
it's like
wadliwego
changing
przepisu
a bad law
stanowiącego
with a
wartości
good
ochrony
law
praw człowieka,
when it comes to human
regulację
rights.
nową, lepszą. Ale
But
też możliwe jest po prostu
change of
derogowanie
law is also
wadliwego przepisu czy
derogating
aktu,
a faulty
który był
or bad law or legal
nieadekwatny, gdy
provision
chodzi o
when
ochronę
it
praw
comes to
człowieka,
human
lub
rights
też
protection
jeszcze
or
coś
something
innego,
else,
wprowadzenie
or
zupełnie nowej regulacji,
introducing completely
takiej
new
interwencji
regulation
ustawodawczej,
or
kiedy
legal
brak było, kiedy
intervention
zachodziła
when there
pewna
was a lack
luka
or
w
deficiency
prawie.
in law.
Czymś jeszcze
Something else
jest
is
zachowanie stanu prawa
preserving the
obowiązującego, ale
static
przy radykalnej
course of
zmianie
law,
jego wykładni,
but
interpretacji.
radically changing its
Przykładem
interpretation.
są z naszej
A case in point
spotykane w Polsce także
is
wykłady, przepraszam, wyroki interpretacyjne
the
naszego Trybunału
interpretation
Konstytucyjnego.
judgments of our constitutional
Wreszcie, proszę Państwa, kolejne
court.
zastrzeżenie takie z
Another
prawa remarks
reservation
wstępnych
as
powinno
part of my
dotyczyć
initial
tego,
remarks
że powinniśmy nieco
is that we
zniuansować
need to
sytuację naruszenia
nuance
praw
human
człowieka,
rights
gdy chodzi o
violations when
kategorię
it comes to
prawa bądź wolności.
categories
To nie jest
of
tylko
rights
akademickie
and or
rozróżnienie.
liberties. It's
Nie
not an
będę Państwa
academic
zanudzał definiowaniem,
difference.
ale
I would not bore you
generalnie
with
powiedzmy,
this,
że
but
istota
generally
różnicy
speaking, the
sprowadza się do
essence
tego,
of
iż
the difference is that
wolność nie jest kreowana,
liberty is
przyznawana
not
przez
created
prawo państwa,
by
czy nawet
law, a
prawodawcę
state or
międzynarodowego.
international
Jest
lawmaker.
potwierdzana,
Liberty
uznawana.
is
Tak,
affirmed
wolność ta
and
pozytywna
recognized,
wolność, to jak i wolność negatywna wolność
both
od.
for liberty for
Prawa
or
zaś,
against.
o ile
When it
nie
comes
mamy
to
do czynienia
rights,
z prawami, tak zwanymi
we're
prawami
not
wolnościowymi, mają troszeczkę inną
dealing
naturę.
with freedom
Są
rights,
uznawane
they
bądź
may be
przyznawane,
recognized
przy
or
czym ten
or
prawodawca
accorded,
specyfikuje
but
treść,
the lawmaker
określa podmiot,
specifies the
określa,
subject,
co się
the
komu i od kogo należy,
object
jakieś
who
świadczenie.
is entitled
Oprócz
to
tego
a
podobnie
right
przy wolności musi
or
ustanowić ten
benefit,
prawodawca pewne gwarancje
and also sets a certain
realizacji,
guarantees
efektywności
that these
realizacji
rights are
tego
effectively
świadczenia.
guaranteed,
A zatem,
these
proszę Państwa,
benefits and
zachodzi
these
też
rights. So
różnica
there
w
is a
zakresie
difference
owych
when it comes
ingerencji
to the
i
interference and
możliwości
possibilities
eliminowania w
of
drodze normatywnej
eliminating
naruszeń
in a
wolności i
normative
praw. W
way
przypadku
of the
wolności
freedoms
niekiedy
or
wystarczy
liberties of
sama
rights.
eliminacja
When it comes to liberties,
owej
sometimes we only
ingerencji
need to
prawnej czy ograniczeń nałożonych przez prawo stanowione.
eliminate
W
the
przypadku zaś
limitations when
unormowania
it comes
praw jednostki, praw
to
człowieka czy obywatela,
normative rights
konieczne
of
bywa niekiedy
individuals,
sformułowanie
then we
pozytywnych
sometimes
warunków
need
dla
to
ich realizacji.
positively formulate
I aby się nie
the
zagubić
right
w tym
for
gąszczu możliwych
is
jurydycznych
implemented.
i
In order
faktycznych
not to
komplikacji,
get lost in the
przyjmijmy w
legal
uproszczeniu, że chodzi
woods,
nam wyłącznie o takie przypadki
we're
naruszenia
only
praw
dealing with
człowieka
such
czy
cases of
rozumianych,
human rights violations
które bezpośrednio
which
lub
directly
pośrednio
or
wynikają ze stanu
indirectly
prawa obowiązującego. Z jego wadliwości.
originate
No,
from
powtórę,
this
załóżmy, że w skrajnej postaci,
legal
ale wcale
system.
nie tak często, nie tak rzadko, przepraszam, spotykanej, istota tej wadliwości
sometimes the
polega na
defects,
hierarchicznej niezgodności unormowania prawa
due to the
prawowego polskiego z
hierarchic
naszą konstytucją bądź z konwencją
discrepancies
europejską.
of our internal
takim
law
właśnie
or our
przypadkach
law and the
Potrzeba
European
zmiany
Convention.
prawa
Then we
wydaje
need a
się mieć
change of law,
racjonalne
and
i
that
zasadne zastosowanie.
seems rational.
Proszę Państwa, zachodziłaby
So
zatem
there
potrzeba
would be a need to
skrótowego opisania
briefly
normatywnych środków
describe the
zaradczych
normative
związanych z naruszeniami
remedies
praw
when it
człowieka
comes to
na co
human rights
najmniej kilku
violations and
płaszczyznach
elimination of them on the
konstytucyjnych, ale zważywszy, że
constitutional
większość podaje referatów w ramach
and
konwencyjnych
conventional
dotyczy tej
levels,
sfery
but because
konwencyjnej,
most
mogę
of
się
us
chyba
I
ograniczyć
deal with the
do sfery
conventional levels, I think
konstytucyjnej.
I'll
Jeszcze jedno zastrzeżenie
limit myself
ważne,
to
gdyż
the
tematyka
Constitution.
tego i innych referatów
One more
ma
thing.
tak ogromny, trudny
This
do
is a
ogarnięcia,
very
być może
difficult
niemożliwy do
or
ogarnięcia
even
dorobek
impossible
i orzeczniczy, i
to
naukowy, także
address
z
all
udziałem
the works
Państwa
of
referentów
all
i
the
panelistów.
panelists and
że proszę
speakers,
Państwa,
then
powiedzenie czegoś
Saying
nowego
something
wydaje
new
się
here
bardzo
seems
trudne.
to be a very
Zwłaszcza
difficult
w
task,
obecności pana
especially in the
sędziego
presence
Trybunału
of the
Konstytucyjnego czy Europejskiego Trybunału Praw Człowieka i innych
Constitutional
znakomitych
Court
państwa.
judge.
Pozwólcie Państwo jednak, że wspomnę
Let
o
me
jeszcze
also
jednej
mention one
osobie,
more
która przez
person
wiele
who
lat
for many
była
years
współorganizatorem seminarium warszawskiego,
co-organized
dzisiaj
the
nieobecna od
Warsaw
paru
seminar,
zaledwie
absent
dni
today.
pełni funkcję konsula
He's the
Rzeczypospolitej
consul of
Polskiej
the Polish Republic
Toronto
in
w Kanadzie,
Toronto, Canada,
pani magister
Magdalena Borowska.
która to poza wkładem w
In
organizację
addition
tego
to
wydarzenia
contributing
także
to
niedawno
the
zakończyła
seminar,
przygotowanie świetnej rozprawy
she
doktorskiej,
also prepared a
mówię
very good
pod tytułem
doctoral
Wpływ standardów
dissertation
strasburskich
on
na
the
proces
impact of
stanowienia
Strasbourg
i stosowania prawa w
standards on the
Polsce.
process of
Jeszcze do tego
making and
opracowania
implementing
się
the
odwołam,
law in
ale ponieważ
Poland.
nasza
I
konferencja
will
jest
refer to
prawdopodobnie
it,
dostępna
but
online
because
w
this
internecie, to
conference
proszę
is
pozwolić na
online,
przekazanie
so
kilku
let me
odniesień dla
extend
Państwa, szczególnie
my warm
pozdrowień i dobrych
greetings
życzeń
to
dla pani profesor.
the consul
Proszę Państwa,
Magdalena
przygotowałem jakiś
Borowska.
tekst pisemny,
I
ale nie
prepared
będę do niego
something,
nawiązywał, powiem tylko, co by
a
mogło się
draft,
znaleźć
but
na
I
tym
think
referacie. To
let me
charakterystyka
just mention
wszystkich
some points. I
konstytucyjnych
think
środków
the
ochrony
nature
wolności i
of
praw
all
człowieka.
constitutional measures of human
Powiem
rights.
to jest za dużo tego i są to rzeczy dla Państwa
The problem is that there are too many of them,
chciałbym
and
zwrócić
you know
Państwa
it
uwagę
full
na
well.
jedno.
But I want to
Mianowicie w
highlight
tym
one
katalogu
thing.
środków,
In
który
the
Konstytucja
spectrum
zawiera
of remedies, the
pewien podrozdział,
Constitution has
raz, dwa,
a
trzy, cztery, piąty
chapter
podrozdział w rozdziale drugim,
for
środki
that
ochrony wolności i
is
praw.
remedies for
Nie są to
protection
jedyne
of
środki w tym
rights and
miejscu pomieszczone
freedoms,
w
not
artykułach
only there in
77 do 81.
1 to
Powiem znacznie
77.
wcześniej w kontekście
Also
wolności praw
previously,
osobistych
speaking
jest
about
to prawo
personal
do sądu.
freedoms, there is the
Nie ukrywam swojego
right to
przekonania, że uważam
trial,
ten
and
środek
I
za
think that
podstawowy,
this is the
fundamentalny,
fundamental,
wręcz
basic,
najważniejszy. Inne,
underlying
takie jak, proszę
remedy.
Państwa,
Others,
kolejno
like
unormowane w
the
artykule
provided
77
for in
prawo do
77
wynagrodzenia
right
szkody
to
wyrządzonej przez
redress
organ
for
władzy publicznej.
illegal operation of public
Czy połączony z
agency
tym
or
zakaz
the
zamykania,
ban
podstawowego zamykania
on
drogi sądowej dochodzącej naruszenia
closing
wolności
any
i praw. Czy
paths to
kolejny
access
przepis,
to
artykuł
court, and
78
78 the
postępowania
instances of court proceedings confirmed by Article
Proszę Państwa,
176 and the
instytucja
institution
artykuł 79
of Constitutional
instytucja
Complaint
wniosku i pomocy udzielanej przez
79
Rzecznika
and
Praw Obywatelskich.
finally assistance
Te
of a
wszystkie
civil rights
środki
ombudsman. All
wiążą
of
się
them,
jakoś
all
z
the
prawem do
remedies
sądu.
are somehow
Zakładają jego uprzednie,
connected
równoległe
to the
bądź
right to
następne
trial,
wykorzystanie. Ale
and
wszystkie one też,
they have
to jest
bearing on
może
the
najistotniejsze, co chcę powiedzieć,
enjoyment of a right
wiążą się
to trial,
ich
and
działanie
this is
ze stanem
also
prawa
related to
obowiązującym.
the condition of a
I tak,
binding law.
prawo do
As
wynagrodzenia
it
szkody
stands, the right
obejmuje
to
w szczególności
redress
przypadki
includes
bezprawia
especially
legislacyjnego, kiedy źródłem szkody
the
jest
cases
fakt
and instances
wydania
of
kierowniczego zgodnego
lawlessness
przepisu
of
w jakimś akcie,
public
bądź
agencies
przypadek
or
tak
the
zwanego
cases
zaniechania
of
prawodawczego. Tu na marginesie tylko powiem, że nasz
failure
Trybunał
to
borykał się przez lata i
take
to nie jest
up
zakończone
action
z problemem
on the
jego
ground of
kompetencji
law,
dotyczących właśnie w tym
and many
przypadku.
cases
Na pewno nie ma
pertain to
kompetencji
such
do
a
orzekania
situation.
o
There are no situations where we need to adjudicate about the legal loophole, absence of certain provisions. No, rather the provisions which have not been put in practice. But we have also cases of omissions, but I'm not going to quote them. Nevertheless, the justices of courts of law and the Supreme Court adjudicating right to redress or indemnity in the event of failure to apply certain legal provisions, certain may not take into account this situation where something exists in theory but has not been practically applied. And is it easy to adjudicate on such cases, or is it easier to adjudicate about the hierarchy of law? And of course, laws cannot limit one's rights to legal remedy and trial throughout various instances, and complaints filed with the Ombudsman may also pertain to the faulty condition of the existing legislation, and also unbinding positions of Ombudsman may somehow indicate to the faulty condition. And finally, incompatibility of legal basis underpinning opinion, a decision, a ruling, or a verdict of a court, and this incompatibility with constitutional rule and guarantee of individual liberties and rights, well, this is a major potential for introducing amendments into the Polish law to stem the situations of human rights violations. Of course, we may investigate the legal effect of rulings issued by the Constitutional Court here. It is not an easy question, but it is often under discussion, and very often it is easier in vertical application of negative decisions. But when the Constitutional Court confirms the compatibility with law of a provision of law, provided that certain conditions appear, the situation tends to be much more different and much more difficult. But under such circumstances, the provision will be unconstitutional, and unconstitutionality will not have bearing on the wording, but on the application. So then we have a follow-up text prompted by such an adjudication, and then the author may theoretically claim that the provision has lost its binding force in this and that context. And here we have a statement or the decision of a constitutional court, which is rather about the spirit of the adjudication and decisions taken by the court, and not by, and it does not really go in the direction of individual decisions. Then, hierarchical compatibility of laws which are no longer binding. For instance, laws adopted under martial law, the decree introducing martial law in Poland. So the change in the year 2000 is barred with certain conditions. The court may also decide on constitutionality of international agreements or formal agreements if this is necessary for the protection of rights, and then such decision will have no bearing on the destinies of an outdated legislation, but may be a basis for individual claims and reivindication claims, which of course has appropriate implications for the public at large and for individuals. I have many instances to quote to you, but time is running mercilessly. So, for instance, inheritance of funds, the ruling from 2001 provided about the situation, December 2001, and unconstitutionality of Article 418 of the Civil Code, which is an example of a situation where an amendment, a change was needed to improve the human rights situation, and the intervention of State Treasury was deemed to be unnecessary. The court really found it difficult to handle the case, and after Article 418 has been repealed by the decision of the court, there was a legal loophole which was only removed in 2004 with a new amendment and with introduction new Article 417 1 and 2. So for a period of time we had a loophole. We had a loophole in the Civil Code without any provision to rely on, and in answering my title question, I wish to tell you that there were courts which were somehow handling the situation, adjudicating only on the basis of the article of the Constitution 57. And it allowed to have certain indemnification paid to a World War II veteran, a person who hold bonds of pre-war Poland. Another case where intervention was needed was the decision in 2003 where a child was born out of wedlock, and the criminal code was somehow involved in this particular case. And in Article 156 of the criminal code, a new change needed to be introduced. Then European arrest warrant 2005, and the first historical change of the Polish constitution, which will be 18 years in force as of tomorrow. Then the extension of the pre-trial detention and recovering of defense lawyers' expenses, and decisions of assessors who have been removed from the Polish judiciary, introduction of a new school of the judiciary, very resonant case 2007 on renegade aircraft, which has been subject to kidnapping by terrorists, hijacked by terrorists, and the most recent decision of December 2014, right slaughtering of animals in the context of freedom of religion and conscience, and the right to refuse to provide certain medical services if they are incompatible with the doctor's conscience. So not in every case it was necessary to amend legislation in order to implement legal effect of those decisions. It is difficult to say what kind of conclusions we can draw from those rulings, but the Constitutional Court is not only the guardian of constitutionality in lawmaking process, no, also when it visits legal questions on constitutionality of courts and courts' decisions and proceedings, and constitutional complaints, which is also an institution, and ex definitio is related to safeguarding of rights. Well, through its jurisprudence, the Constitutional Court also safeguards the constitutionality of application of law, ex ante and ex post, the later by the institution of constitutional complaints. So coming back to my initial question, to change or not to change, this is a question. We will have next year a conference of chairs of constitutional law hosted by my own home university, so we will visit this question again. On the eve of celebrating 18 years of the new Polish constitution, I wish to say that one of its assets was the appropriate safeguards for the protection of rights and liberties, but also it invented profound changes to amend the jurisdiction possibilities available to Polish courts. So the constitution was a necessary qualitative change to protect human rights, but this change was only the beginning of a sequence of changes that have been ushered in. And what is very important is that the two amendments of the Constitution 2005 and 9 accordingly both applied to human rights. In 2005 it was precisely after the ruling of the court in Strasbourg in 2005 disqualifying the implementation of the framework decision on the European arrest warrant. By its decision of April 2005, this legal provision has been deemed to be unconstitutional in line of a ban of extradition of a Polish citizen, and the court adjourned this decision and the derogation, and in the period of derogation the legislator amended constitution, introducing certain exemptions from the general rule banning extradition of Polish citizens. So this was also related to persons personal rights of a human being, including the Polish citizen. And the new amendment 2009 political rights, clause 3 in Article 79, which provided for the indignity, electoral indignity, or ineligibility. We had such questions concerning the elections of Polish MEPs or councillors in territorial government. This would not apply to members of Polish parliament and senators, so this was incompatible. And for instance, we read that a person who has been condemned on the grounds of a crime for imprisonment cannot stand in parliamentary elections. This goes also for presidential elections because Article 127 provides for such a situation accordingly. So, this was a kind of a limitation of political eligibility of citizens, political electoral rights, and infringement on individual rights. But this led to the reduction of the level of protection and not enhancement of the protection. Several proposed amendments of the Constitution under debate only ended in the two amendments, 2005-2009. Back in 2007, the Parliament examined draft amendments to the Constitution on the fundamental issue of conventional and constitutional protection of the right to live. As you may remember, one of the suggestions was to complement Article 38, which provides that the Republic of Poland safeguards to any human being legal protection of life, and it was suggested to add from the conception to the natural death. This fades through. Article 36 continues in unamended version, and the question is, would it be a necessary remedy to afford protection of individual rights in various difficult situations, not so much about the capital punishment, but the protection of life at its very beginning or the very end. And I would say that this change would not be necessary. It may not be popular, and here I may be at odds with Justice Garlicki, remembering the ruling of 28th of May 1997 on anti-abortion law, and the ruling on K/26/96, but this normative value is contained by the provision of Article 38 now, because the construction of the Article 38 may be a legal basis for such an extended understanding of provision. And of course I have many instances to quote, like general remedies where constitutional changes will be needed, especially in the lengthiness of court proceedings, excessive lengthiness of court proceedings in Poland, and also the expectation that a case should be heard and decided in a reasonable time. And we know that in Polish cases pending before the court there was a pilot judgment delivered, but this was on another issue, and we are not going to speak about any changes that were introduced by virtue of complaint against excessive length 2004, and when it was decided that the ruling was to be fully enforced, and then the European Court rightly decided that the Polish courts of law have not taken into account the length of proceedings in its full extent, only adjudicating part of damages for the lengthiness, and the situation improved in 2009, but not fully, since even nowadays we have fresh cases pending, and the third pilot decision.
This is a pilot project on excessive length of proceedings. Let me only quote one thing. This critique of the court ends with a conclusion
Rzeczpospolita musi poprzez odpowiednie środki prawne i innego rodzaju zapewnić zgodność praktyki sądów krajowych z odpowiednimi zasadami wynikającymi z artykułu 6 i 13 Konwencji. W ramach wystąpienia, gdyby mogło być dłuższe, powiedziałem Państwu o przykładach, kiedy Trybunał stwierdza niezgodność regulacji konstytucyjnej z Konwencją Europejską. To przykład m.in. praw wyborczych osób przebywających w zakładach karnych, który jest wyrok przeciwko Federacji Rosyjskiej, czy jest wyrok dotyczący praw wyborczych, jak ich ograniczenia po stronie osób ubezwłasnowolnionych. Znany wyrok przeciwko Węgrom. A przypomnę, że nasza konstytucja w artykule 62 odmawia
Article
prawa
62 of our
wybieralności,
Constitution
prawa wybierania i wybieralności osobom, które są ubezwłasnowolnione prawomocnym wyrokiem sądu. Problem, proszę Państwa, czyli zmiana konstytucji stanowi odpowiednie remedium dla respektowania standardu konwencyjnego jest bardzo złożony i to pominie.
European Convention of Human
Wydaje mi
Rights.
się,
This
że
is a
zakończę
complex
to w ten
issue, and
sposób,
let me
proszę Państwa.
just put it aside. Let me
Szczególną
conclude by
satysfakcją
saying
mnie
that I'm
sprawia
especially
nowa
happy
filozofia
to see
procesu
that
karnego
there's a new
wynikająca z
philosophy
założeń
of the
z treści
criminal
nowelizacji, tej
code
wielkiej nowelizacji kodeksu
that
postępowania
results
karnego, jaka
from
weszła w
the
życie
new
1
criminal code
lipca.
that entered into force on
Jest
the
rzeczą
1st of
niezwykle
July.
istotną,
It's very
iż
important that
projektodawca,
the
czyli
lawmaker, that is
rząd,
the
to
government,
wnioskodawca tej
that
ustawy,
drafted this law,
podkreśla, jakie są
stresses
cele
the
tej nowelizacji.
objectives of this
Powiada się, jeśli chodzi o
amendment.
kształtowanie na nowo
It's to reshape
pewnego
a certain
modelu procesu
model of
karnego,
criminal process,
także w sferze stosowania
also
środków
when it comes
zapobiegawczych,
to preventive
dla
measures
lepszej
to
ochrony
better
gwarancji
protect
procesowego skarżonego.
and
W pewnym
guarantees
fragmencie
of the
uzasadnienia
accused. On its
ustawodawca,
grounds, the lawmaker,
projektodawca
the
powiada,
government says
iż chodzi
that
tu o
it's
kolizję.
about a
Z jednej strony
collision.
efektywność
On one hand
postępowania,
we have
z
the
drugiej
effective
i to
proceedings, on
decyduje
the
o
hand
konstytucyjnie
it's
chronioną
about the
wolność człowieka.
constitutionally protected
Proszę Państwa,
liberty of
pozwólcie na
man
pewien
or individual.
osobisty
Let me
wątek. Kiedyś, 15 lat temu,
speak on a
zajmowałem się tym
personal
problemem.
note.
To była praca pod tytułem
I
Konstytucyjna
wrote
wolność
on
człowieka, a tymczasowe
constitutional
aresztowanie. Miałem zastrzeżenia co do
liberty of man
przepisu
and
artykułu
arrest, and I had
258 paragraf 2.
reservations about
Ten został
Article
zmieniony między innymi poprzez dodanie
258
małego
paragraph 2,
słówka także.
and it was changed
To
by
małe
adding
słówko
the small
także w
word
ten sposób zmienia
also,
sens
and
normatywny
this word also
tej
changes
podstawy
the
tymczasowego
normative
aresztowania
sense of
tymczasowego,
this
jakoby
interim or
iż
pretrial
przesłanki
detention
inne,
than
między
other
innymi
premises,
prawodawstwa, ukrywania się,
hiding
wchodzą w
or
rachubę,
obstruction
mogą
of
być
justice.
dodatkowo
This could
wzmocnione
be
przez surową
reinforced
grożącą
by
oskarżonemu karę, a ta
this
surowa
very
grożąca kara nie może już być samoistną przesłanką
severe
tymczasowego aresztowania. Pan
punishment,
profesor
and it may
ma
not
być
be
może
a
wątpliwość. Rzecz, proszę Państwa, polega zatem
presumption or
na
the
tym,
grounds on which a person may be
wolność człowieka, mam nadzieję, będzie
taken
chroniona lepiej
in
za
pretrial
sprawą tej
detention. So
zmiany.
I think the liberties will be
Ale
better
trzeba
protected
zadać
thanks to
pytanie,
this
czy
change
ta
of law, but
zmiana
you may
również stanowiła
ask the
konieczne
question
remedium na
whether
ochronę
this change
wolności
of
człowieka
law
w
was
procesie
also an
karnym,
effective
wolności
remedy
człowieka
for the protection of
korzystającego z domniemania niewinności.
human rights
Otóż, proszę Państwa,
for benefit from the
powiem i tak, i
presumption
nie.
of innocence.
Wielu polskich
Yes and
sędziów
no.
karnych
Many
doskonale
criminal
radziło sobie z
judges
tymi przepisami i
did very well
potrafili ci
with the
sędziowie
existing
wychodzić z
law, and they
sytuacji,
could really
interpretując przepisy
interpret
ustawowe w
the
duchu
law in
zgodności z
accordance with the
aksjologią, zasadami
axiology
konstytucji oraz
and
konwencji.
convention and
I
the
stąd już ostatnia
constitution.
konkluzja.
Hence my conclusion, the
W
last
działaniu
one.
właściwie wszystkich krajowych środków
All
ochrony praw człowieka, a także skargi do Trybunału
Our
Praw Człowieka na
laws
gruncie
also when
konwencji,
it comes to the
przed ich
applications
zainicjowaniem,
before the
w trakcie albo
applications
po,
are lodged to the
znajduje
court or
zastosowanie
in the
prawo do
middle
sądu
or
stanowiące środek
after
podstawowy,
we need
najważniejszy
to
dla
take into
praktyki
card
ochrony
the
praw
right to
człowieka. To jest poza
trial
dyskusją.
to protect one's rights. This is
Niedoskonałe, nawet złe prawo nie jest w stanie zmusić prawego sędziego do tego, aby ferował złe wyroki z
So
naruszeniem praw
every judge
człowieka.
can judge
Sędzia współczesny nie jest
rightly, of
oczywiście
course,
ustami
a judge is not.
ustawodawcy, jak kiedyś twierdził
As
Montesquieu w dziele
Montesquieu
duchu
said,
praw.
he can judge.
Dość wskazać, jakie
Let us
ślubowanie
just
składa
see what
dzisiejszy polski kapłan
Polish
Temidy przy powołaniu
judge
przez
has to
Boga
swear in
stanowisko
when
na urząd
he
sędziego.
becomes a
Stać na
judge,
straży
to
prawa,
guard the
obowiązkiem
law,
sędziego wypełniać sumiennie
to
sprawiedliwość
be
wymierzać zgodnie z
diligent
przepisami
and
prawa,
to
ale
be just
bezstronnie według
and to
mego
be
sumienia.
impartial according to my conscience. The
Sędzia,
judge,
i to nawiązuje, jak się okazuje, do
let me
zdania pana
refer
profesora
to what
Garlickiego,
Professor
iż sędziowie nie
Garlicki said,
powinni z nadmiernym
judges should not be
optymizmem
too
patrzeć w stronę
optimistic when it
ustawodawcy. Ja to
looks
ujmę nieco
towards
inaczej.
the lawmaker.
Sędzia
I
nie ma
understood this right,
konstytucyjnego
and
alibi.
the judge
Nie ma
has no
możliwości, że
constitutional
gdzie
alibi.
indziej niż w jego kompetencjach tkwi problem,
He cannot solve the
czyli że to
problem
właśnie
outside
wadliwy
his
stan prawa
competences. He cannot
obowiązującego zmusza go do
put the blame
dokonywania
on
albo
faulty
akceptowania
law.
dokonywanych przez inne podmioty naruszeń praw i wolności człowieka.
Thank you
Dziękuję
very
bardzo.
much.
Dziękuję
Thank you very much,
bardzo, panie
Professor,
za referat,
for your
ponieważ
paper,
już jesteśmy
because
mocno
we are much
opóźnieni,
behind
to ja
schedule.
ograniczę się
Let me
do
just
bardzo
limit my
krótkiego
remarks
komentarza na temat dylematu
to a
zmieniać
dilemma whether
czy nie
to change or
zmieniać.
not to change.
Wydaje
It
mi się,
seems to me that
że takim pierwszym i podstawowym
first and
sposobem
foremost
ochrony
way to
zarówno
protect
Europejskiej Konwencji i
the rights
Konstytucji
under
to
the
jest
European
wykładnia prawa w
Convention
duchu
of Human
Europejskiej
Rights and
Konwencji i
the
Konstytucji.
Constitution is to
Dopiero
interpret
wówczas, kiedy
the law
drodze
and the
wykładni
spirit,
prawa
and only if that is
dokonywanej przez sąd
by the courts.
dojdziemy do takiego
And
punktu, że
if we come to
stwierdzimy,
a
że
point
ta
where
wykładnia jest środkiem
this
nieefektywnym ochrony
interpretation is
konwencji też
ineffective way
konstytucji,
to
no to się
protect
pojawia
the rights
problem,
under the
prawda,
Constitution or
albo
Convention,
dokonania zmiany
then the issue arises
poprzez
whether to
legislację,
change
albo
it through
dokonania
legislation
zmiany
or
poprzez
whether to
uzyskanie
change it
orzeczenia
through
Trybunału
a
Konstytucyjnego.
constitutional court
Zapraszam Państwa
decision.
na przerwę.
Thank you very much. I would like to now invite you for a coffee break.
Państwu. Ja pozwolę sobie już zaprosić do zajęcia miejsc witam Państwa serdecznie na już panelu pierwszym po wystąpieniach wstępnych.
First
Przede wszystkim
panel
dziękuję
after
Ministerstwu Spraw
introductory
Zagranicznych,
words.
pani Pewności
Thank you.
za
I
zaufanie
want
i
to
powierzenie
thank the
roli
Ministry of
moderatora
Foreign
tego
Affairs
panelu,
and Madam
który
National
zapowiada się
Agent
niezwykle
for the
interesująco.
honor of moderating
Ja może
this
krótko
panel.
przedstawię
Let me
naszych
introduce our
panelistów.
panelists,
Pani
Professor Monika
Florczak-Wątor,
Wątor,
pani doktor
Agnieszka
Dębczuk i pan
Dębczuk,
profesor Michał
Doctor,
Balcerzak.
PhD, and Michał Balcerzak,
Jeżeli chodzi o ten
And
panel,
as
niestety
for this
nie mógł
panel,
wziąć udziału pan
unfortunately, Professor Bronisław Sitek
z uwagi
could
na
not attend it due
pilne
to
spotkanie,
very
które musi
necessary,
odbyć się
very
dzisiejszym,
urgent
także,
meeting that has been
niestety,
scheduled for him.
nie będzie
So
dzisiaj
unfortunately
z nami.
today he will not be able to
Natomiast
attend.
ja
That
bez
being
zbędnych
said,
wstępów,
without
zważywszy
any further
na to,
ado,
że panel pierwszy odbywa się pod presją
since
obiadu,
we are under time pressure
poproszę pana
and we
profesora
cannot
Balcerzaka
disturb
o
our lunch arrangements,
wystąpienie.
let me hand it over
to
to
Koncepcja
Michał
ogólnego środka
Balcerzak,
ochrony
who will
prawnej w
speak
orzecznictwie
about the
Europejskiego
concept
Trybunału
of
Praw
the
Człowieka i
general
perspektywa
effective remedy in
polskiego
the
porządku
jurisprudence
prawnego.
of the
Panie
European
profesorze,
Court
bardzo
of
proszę.
Human Rights and the perspective of a Polish legal order. Professor. Thank you very much, Chair, ladies and gentlemen. It is a tradition of such meetings to express the words of appreciation for organizing such an event, and I want to do the same and thank the Ministry of Foreign Affairs and the National School. We are visiting very exciting subjects. It is not wonder that we are meeting in Lublin. The first one was not hosted in Warsaw either. The first one was in Strasbourg, 2005. I have a program booklet from 2005 from the initial Warsaw seminar. It was called workshop. It also visited the subject of repair of national remedies. So it is coming back to the same good tradition. It has always been the meeting of practitioners and theoreticians, and we were mutually learning from each other, and I found this booklet from the original first conference. I read it thoroughly, and I must say that the issue itself is as topical as it was 10 years ago. If we read out papers that were delivered 10 years ago, we would see the same important topics. 10 years ago, I was very shy. I was speaking after President Wilhaber. Unfortunately, he needed to leave soon after, so I could relax, I could let my hair down, and that occasion was very agreeable. But coming back to the mainstream, the discussion about general effective remedies is likely to stay with us for good, because effectiveness of remedies is not to be taken for granted. It is not something that once given will stay with us forever. And the basic and underpinning idea of the Strasbourg system is the idea of subsidiarity. And Strasbourg expects that national remedies will be effective enough and broadly applicable, and we know that subsidiarity under Protocol 15 should be entered as one of the preamble motives, and also the role of exhausting national remedies will be inscribed in Article 13, which speaks about the right to effective legal remedies. What is a general effective remedy? This is not a notion derived from the Convention, from the treaty. It is not well defined. It is not cited in the treaty. It only speaks about effective legal remedy and the obligation to set it up on the national ground. So, the notion of a general effective remedy is the notion that has been conceived in intergovernmental cooperation, in a dialogue among the court and governments, and it started emerging from 2014, and Protocol 14 was drafted, and recommendation of Council of Ministers was issued. One of them from 2004/6 spoke about effective remedies and support to be given to effective remedies, and there is an encouragement issued there to the member states to improve the effectiveness of remedies, not so much recalling the obligation, because there is no verbatim obligation of a signatory state to the convention to secure such general effective remedies. However, this is suggested and this is recommended if we want to secure higher effectiveness of national protection. So, in the course of intergovernmental work, this notion started being more and more often mentioned. The court has also written extensively on the subject without providing a definition and a general standard for the general effective remedy. So what the court does is case-by-case verification of remedies, and the governments which are sued try to defend themselves and indicate that the party has not exhausted local remedies before applying to the European Court. So after the recommendation from 2004, there is a follow-up process in place when we investigate and examine general remedies available in member states, and this started in the middle of the first decade of the 21st millennium, and the follow-up process has been followed by the Council of Ministers. A guide to good practice in respect of domestic remedies has been compiled as a juxtaposition of the domestic practices, national practices, both general concerning general remedies. We have Article 13, we have soft law, but maybe there is an additional component missing of further standard setting in this area. And to my mind, there are many obligations and standards to be observed in terms of procedural remedies and protection. Some 7 or 10 years ago, we were wondering if it would not be appropriate to amend Article 13 of the Convention or create a new dedicated protocol for remedies. But this is a very courageous suggestion. It's extremely difficult to change convention and to adopt new protocols because the states are encumbered enough. So academically speaking, we may come up with new ideas, but it will be very difficult to defend them in practice. So the concept of the general effective remedy has a dozen or so years standing by now, and it has been also mentioned in the course of the 4 big intra-governmental conferences as of 2010, when the governments decided to meet regularly: Interlaken, Switzerland, Izmir, Turku, Brighton, and finally Brussels. And in Interlaken, in the initial intra-governmental conferences, an action plan was adopted calling upon states to come up with effective remedies, also by means of introducing new general or detailed remedies into their system. And here we see a situation where there is no imposition on states from the Council of Europe. No, it is rather a suggestion to modify and to monitor the effectiveness of existing remedies. In order to set this problem of general effective remedy into order, we could divide general effective remedies. What kind of general effective remedies there may be? Well, constitutional complaint in various shapes, or additional procedural path of the ability to invoke European Convention with legal effect, and this is an option available to anyone, so you can invoke the Convention, which is also a remedy, sensu stricto. And some member states went in the direction and opted out for constitutional complaint. The others decided to quote the convention in proceedings before national courts of law, and there are pros and cons of both such solutions. I'll try to speak very briefly, not to encroach on the following papers to be presented. However, I have taken down the following question, preparing for a reflection on the subject of whether the ability to invoke the convention before the court, because you can really invoke the convention before the court, is it a general effective remedy or not? Because as stated before, the convention may be invoked, and it is good that it is invoked, and the courts realize this option full well. We've been working years and years to make sure that courts know the letter of the convention, and I hope that this is a positive assumption. 50 years ago, Ludwig Henry, the professor of international law, stated that the knowledge of international law may be only presumed in the case of an appellate court and upward. Now it can be rightly assumed that each and every judge and justice knows international law in its basic rudiments, but the ability to invoke the European Convention in the Polish Court of Law, does it constitute a general effective remedy? I don't know. Maybe yes, maybe no. It is an important remedy in procedural terms, but is it a general effective remedy? Well, no, I think not necessarily. I'm just interested what kind of opinions you might have. Maybe we have a general effective remedy in place in Poland, undiscovered, unveiled. And the other area of constitutional complaint here, I will just restrain myself to very few comments, because there will be a paper dedicated to the Polish constitutional complaint, and also when you have the Convention of Chairs of Constitutional Law in Lublin, you will probably visit the subject as well. Well, Polish constitutional complaint is as it is. As of 2003, we realize that it is excellent that we can challenge the constitutionality of a Polish provision of law, but when it comes to application, when it comes to constitutionality or unconstitutionality, there may be a problem. But there are other orders where constitutional complaint is a general effective remedy, like Germany, like the Czech Republic with certain exemptions. It is the case of Spain, also with some exemptions. And wherever the court has verified the availability, effectiveness, and chances for success of suing party, it really functions well. It will not be effective if it is only available to a narrow circle of entities, or where the national judge can file the constitutional complaint, as in Italy, and correct me if I'm wrong here, because we have excellent constitutionalists here in this room, but in Italy, a natural person cannot possibly file a constitutional complaint. So this is down to discussion, and I enjoy this panel, and maybe we should really sit together and look into the possibilities of changing the institution of a Polish constitutional complaint. Let me quote the Turkish example in this instance, because the Turks have rolled out the constitutional complaint recently. 2010 they amended their constitution, 2012 first complaints started being filed, and this is a very interesting illustration of how the court in Strasbourg checks the effectiveness of general effective remedy. Hassan Uzun decision 2013 shows us a very thorough analysis of the effectiveness of remedy, looking into the scope of the matter and the parties involved, and this is a very interesting examination. In conclusion, the court gives creed to the Turkish legislature and believes that the Turkish legislator wanted to create such a procedure where first the Constitutional Court needed to verify if Constitution has been violated or not, and then the case could be further referred to Strasbourg. It only costs 75 euros, such a verification. The scope of eligibility for the Turkish Constitutional Court is here equal to the eligibility or competence of European Court of Human Rights. And now a handful of very realistic comments to end with. Not everything that proves the test in other legal orders will prove the test in Poland. Let's be realistic. We must be broad-minded, but we must be realistic as well. If we wanted to expand the scope of constitutional complaint in Poland to the extent it is available in Turkey, I'm afraid it would not work. I have some misgivings. Not that we should not discuss the case, but evidently, the Council of Europe is encouraging us to follow in the same footsteps, but will not impose any decision on us. This is very important, because there were legal remedies that were really virtually imposed on us by the court. We know about the complaint against the excessive length of proceedings, and we remember when first complaints were made available to the Polish citizens, we wanted to boast of the fact in the Council of Europe. Also, there was a new regime in place as for the claim for indemnity, Article 217, as Professor Dudek mentioned it, etc. And now, 10 years after, we may consider what proved the test and what was not really very successful. And we need to take a very complex perspective of it. If detailed remedies are effective enough, maybe we do not need a general effective remedy. So this is something to be considered, but I'm not going to speak about detailed effective remedies. I don't want to encroach on next speaker's time. So when we discuss general effective remedy, if it should take the form of changing the Polish constitutional complaint, maybe an idea would be not so much reopening of proceedings in such complaints, but rather providing an option to select the court which will adjudicate. For instance, if personal interest should be safeguarded and re-examined again by all courts, it would be virtually undoable. So the potential to file a complaint in Strasbourg is unlimited. Also, in terms of personal interests and the violation of personal interests. And if we want to afford real protection in issues that are crucially important to the observance of human rights. Well, not to say that excessive length of proceedings has not bearing on human rights, but if we wanted to make sure that we had a remedy against any possible violation, and if we should have an appropriate redress for each and every case, we should not think idealistically that we will really coin a general effective remedy that will be fit for all. No, we will need to select groups of cases and come up with remedies to respond to them. So on that note I wish to end. I look forward to a very interesting discussion. Thank you very much.
Panie profesorze, bardzo dziękuję za perfekcyjny timing. Myślę, że to było bardzo interesujące wystąpienie. Pan profesor w pewnym zakresie nawiązał chyba do historycznej tradycji tej sali wspomnianej przez pana profesora Garwickiego, mianowicie w swoim dialektycznym zajście wystąpieniu wskazał nie tylko i wyłącznie tezy, ale skierował pytania. Pytania adresowane do publiczności oraz do kolejnych prelegentek. Pytanie bardzo ciekawe dotyczące możliwości, czy możliwość powołania Europejskiej Konwencji przed sądem to jest ogólny środek, a także pytania i postulaty pod adresem polskiej skargi konstytucyjnej. Myślę, że te kwestie będą niezwykle ciekawe także w toku dyskusji przewidzianej po tym panelu. Natomiast w tej chwili chciałbym poprosić o wystąpienie panią dr Agnieszkę Dębczuk. To będzie pierwsze z dwóch wystąpień dotyczących właśnie skargi konstytucyjnej. Tytuł tego wystąpienia to: czy skarga konstytucyjna w jej obecnym kształcie jest skutecznym krajowym środkiem odwoławczym w rozumieniu konwencji? Bardzo proszę panią doktor.
Witam państwa serdecznie. Ja chciałabym tylko państwu się wytłumaczyć, właściwie miałam być tutaj publicznością, tak jak państwo, ale akurat tydzień, 2 tygodnie temu zostałam poproszona przez panią Magdalenę Krzyżanowską-Mieszewską, która nie mogła tu przyjechać, to właściwie jest jej wystąpienie i jej próba odpowiedzi na to pytanie. Więc poprosiła mnie, abym po prostu państwu odczytała, czy też wygłosiła ten jej referat, co z przyjemnością czynię i mam nadzieję, że oddam właściwie ducha, intencje autorki, odczytując ten referat. Jest dość taki objętościowo. Mam nadzieję, że w ciągu 20 minut się wyrobię. Proszę państwa, pani Magdalena Mierzewska miała odpowiedzieć na pytanie, czy tak jak pan Mirosław Wróblewski powiedział, czy skarga konstytucyjna w jej obecnym kształcie jest skutecznym krajowym środkiem odwoławczym w rozumieniu Europejskiej Konwencji. I tak też, proszę państwa, celem zasady wykorzystania środków krajowych jest umożliwienie władzom krajowym, w szczególności władzom sądowniczym, rozstrzygnięcia podniesionego zarzutu naruszenia prawa konwencyjnego oraz, gdy jest to oczywiście właściwe, zaoferowania możliwości usunięcia skutków takiego naruszenia, zanim zarzut naruszenia zostanie przedstawiony Trybunałowi Strasburskiemu. Artykuł 35 Konwencji, który statuje zasady wyczerpania krajowych środków, przewiduje rozłożenie ciężaru dowodu. To rząd, który twierdzi, że nie zostały wyczerpane środki krajowe, jest zobowiązany wykazać Trybunałowi, że środek ten był skuteczny oraz dostępny w teorii i praktyce we właściwym czasie, to znaczy, że był on dostępny dla samej strony, bez konieczności oczywiście uzyskiwania zgody na jego wniesienie. A za jego pomocą można było domagać się naprawienia szkody doznanej w wyniku podniesionych przez skarżącego zarzutów i że środek ten w świetle ustabilizowanego orzecznictwa sądów krajowych w podobnych sprawach miał szansę powodzenia. Jeżeli prawo krajowe nie stworzyło indywidualnego mechanizmu dochodzenia praw w drodze indywidualnej skargi konstytucyjnej, z postanowień konwencji nie można wyprowadzić zobowiązania do stworzenia takiego mechanizmu, np. jest to sprawa Polski przeciwko Finlandii z 2002 roku. Ani z artykułu 6 Europejskiej Konwencji, ani z żadnego innego jej przepisu nie można wyprowadzić prawa dostępu do sądu wyposażonego w jurysdykcję do uchylania czy też unieważniania aktów prawnych uchwalonych przez ustawodawca.
the laws
Skuteczność
enacted by the
polskiej
lawmaker.
skargi
The effectiveness of
konstytucyjnej
the
stała
Polish
się
constitutional
przedmiotem
complaint
oczywiście
became
wspomniana
the
tutaj
subject matter
sprawa rozstrzygnięcia przez
of
Trybunał dopiero w 2003 roku, czy sprawa
judgment
szachmedyjska przeciwko Polsce.
Szachmedyńska against Poland before the European
Uznał on,
Court.
że może być
The
ona
court
uznana
decided
za
that it
skuteczny
could
środek
be
odwoławczy w
considered an
rozumieniu
effective
konwencji
remedy
tylko
and
wtedy,
understanding of the
jeżeli
convention
łącznie
only when they're
wystąpią,
jointly
zostaną spełnione
the
następujące
following
warunki. Po
premises
pierwsze,
are met.
gdy
First,
decyzja
when the
indywidualna, która
individual
rzekomo
decision
naruszyła
which
konwencję,
allegedly
została
violated the
podjęta w
convention was
bezpośrednim
taken
zastosowaniu
in direct
niekonstytucyjnego
applicability of
przepisu ustawodawstwa
unconstitutional
krajowego
provision
oraz
of
po drugie, że
national law,
przepisy
and second that
proceduralne
the
mające
procedural
zastosowanie do tego
regulations applied
indywidualnego
to such
orzeczenia
individual
przewidują
judgment
wznowienie
provide
postępowania
for
lub uchylenie
reopening
ostatecznej
of
decyzji w
proceedings or
konsekwencji
setting
wyroku
aside the
Trybunału
decision as a result
Konstytucyjnego,
of
w którym ta
Constitutional Court decision when this
niekonstytucyjność została stwierdzona.
unconstitutionality was
Interesujące jest,
adjudicated.
że
What is
orzeczenie
interesting
to
is that
zapadło w
this decision
sytuacji,
was made in a
kiedy
situation when
zaobowiązywało jeszcze rozwiązanie
we had
przejściowe.
interim
Oczywiście
provision.
mam na myśli,
I'm thinking about
autorka miała na myśli to rozwiązanie przejściowe wynikające z artykułu 239
39, paragraph 1 of the
W
Constitution.
okresie 2 lat od wejścia
2 years
Konstytucji w życie
before
orzeczenia o
after the entry
niezgodności z
of
Konstytucją
the
ustaw
Constitution,
uchwalonych przed jej
if
wejściem
the
w życie
provisions
podlegało one oczywiście
are
jeszcze rozpatrzeniu
unconstitutional,
przez
then the
Sejm,
Sejm can
który mógł
review it
odrzucić
and
to
could set aside this by 2/3 majority
Trybunał
of votes.
Strasburski, odrzucając skargę w
Court
sprawie
in
szachmedyjska, w której
Strasbourg,
orzeczenie
by
krajowe
setting
zostało
aside the
wydane na tle
Konwencji,
dawnej
which was
ustawy
issued
karnej
in
skargowej,
light of the
powołał się na to,
former
że w praktyce rozwiązanie to nie zostało
fiscal
ani
law
razu
said that this
zastosowane,
has never been applied
ani
even
żadne
once,
jego
and no
orzeczenie w ten sposób
decision
odrzucono.
that was
Powołał się
decided
także na
also
zasadę, że
invoked
same
the rule
wątpliwości co
that
do
doubts as to the
skuteczności danego
effectiveness of
środka
a national
krajowego nie
domestic
zwalniają
remedy does not
skarżącego z
release the
obowiązku skorzystania
applicant
z
from
Orzeczenie to
exercising
można
this right. So
interpretować
this
jako ukłon
ruling
w
can
stronę
be
zasady
interpreted
subsydiarności,
as
skoro nawet
about
tak
towards
daleko idące
subsidiarity
ograniczenie skutków
if
prawnych
such
możliwej
a
skargi
far-reaching
konstytucyjnej nie stanowiło przeszkody
limitation
dla
is not an
uznania jej za
obstacle to
środek w
consider
okolicznościach
it
sprawy
to be an
skuteczny.
effective remedy
Podejście
under the
zastosowane w tej
circumstances.
sprawie
So the
okazało się
approach was
trwałe i jest do dzisiaj
permanent, and it
podstawą
is still
rozstrzygnięć
the
Trybunału
basis of
Strasburskiego dotyczących polskiej skargi
judgments of the
konstytucyjnej.
European Court
Tytułem
regarding
przykładu, na
Polish
przykład skarga
constitutional
polskiej przeciwko
complaint. For
Polsce
instance,
wniesiona przez osobę skazaną na
against
podstawie
Poland
ustawy
that
o
was raised
zapobieganiu
under the
narkomanii. Trybunał w Strasburgu uznał, że
Act
skazanie
against,
skarżącego nie zostało oparte o bezpośrednie
narcotics.
zastosowanie artykułu 32
Court
tej
said that it
ustawy,
was not based
penalizującego
on
nakłanianie do
penalizing
używania
the
narkotyków.
use of
Jego skazanie
narcotics.
było raczej
His
rezultatem
sentencing was
sądowej
rather an
interpretacji tego
interpretation of the
Zarzut
ruling, so
niewykorzystania
the
środków
charge of
krajowych
not
został więc odrzucony.
using national
Druga
remedies was
skarga Pawła
rejected.
przeciwko Polsce,
Another
kiedy
case,
to
Pawła against
skarżący został
Poland, when the
skazany na
applicant
podstawie
was
artykułu
sentenced
212 paragrafu
on
2
Article
kodeksu karnego.
212 of
Chodzi tu oczywiście o zniesławienie, a do
Code
Europejskiego
in
Trybunału Praw
and
Człowieka wniósł zarzut
he
naruszenia artykułu
applied
10
to
Koncepcji
the
wolności i
court
ochrony wolności
that he
wypowiedzi.
was sentenced
Europejski
under
Trybunał uznał,
Article
że
10.
skarżący
So the
winien
court
był wnieść
decided
skargę
that the
konstytucyjną, tym bardziej, że w chwili
applicant should
orzeczenia
have raised a
inna
constitutional
skarga
complaint, and
kwestionująca
more so
zgodność
than
tego
another
przepisu z konstytucją
application
zawisła przed
was
Trybunałem
pending
Konstytucyjnym.
before the Constitutional
Gdyby to
Court. If he
uczynił,
had done
mógłby
so,
następnie
and later he
skorzystać z
could
artykułu
also
240 paragraf 2 kodeksu
rely
karnego
on
i wnieść
Article
wniosek o wznowienie
540 and
postępowania.
resume proceedings.
Mogłoby to stworzyć
This
dla
could
możliwość
create the
ponownego
possibility for him
przeprowadzenia
to
postępowania i
again
ostatecznie wydania
bring the
wyroku
case before the
odpowiadającego
court and
standardom
to
wolności
bring about
wypowiedzi
a ruling
ustanowionym przez
that
Europejską
would be
Konwencję.
in accordance with the
Europejski
European
Trybunał miał także na
Convention.
względzie
The
podobieństwo regulowania
European Court
wolności
also take
wypowiedzi
into
przez
account
artykuł 10
Article
Konwencji
10
z
of the
tym
Convention
zawartym w artykule
in
54
connection
Konstytucji chroniącym również
Article
wolność
54
wypowiedzi.
of the
Powołał się
Constitution.
także
It
na
also
fakt, że
invoked
Trybunał
the fact that the
Konstytucyjny,
Constitutional
dekodując
Court,
treść norm konstytucyjnych
when
dotyczących
it
praw
interpreted
indywidualnych,
individual rights,
często odwołuje się
often
do orzecznictwa
invokes the
Europejskiego Trybunału.
European Court case law.
Ponadto na przykład
In
w
addition,
sprawie
in
Branduka
case Branduk
przeciwko
against
Polsce
Poland
dotyczącej dostępu
concerning
do akt
access
skarżącego
to
zebranych
files
przez
of the
IPN, Europejski Trybunał
applicant
również był zdania, że
collected by
skarżący winien
IPN,
złożyć
the
skargę
court said that the
konstytucyjną.
applicant should have filed
Należy
a
pamiętać,
constitutional
że
complaint. We
niewykorzystanie
should
krajowych
bear in
środków
mind
odwoławczych
that failure to
Europejski
benefit
Trybunał
from
bierze pod uwagę
domestic
brak na zarzut strony, a nie
remedies
urzędu.
is
Inaczej
a
niż na
failure
przykład
of
zarzut
the party,
złożenia
not
skargi
ex
z uchybieniem
officio, which is different from
6-miesięcznemu
as
terminowi do jednej
failure to meet the 6-month
A
term.
Trybunał Strasburski
The
odrzucił w
European
wielu
Court
sprawach złożonych
rejected
przez
many
rząd zarzut
cases
niewykorzystania
that
środków odwoławczych z powodu
government
niewniesienia
raised
skargi
that the constitutional
konstytucyjnej i
complaint was not
A
invoked.
w
For
sprawie
example,
RE
in RE
przeciwko
against
Polsce, to
Poland,
jest zarzut
this is an
opóźnienia badań
objecting
prenatalnych
that
w urodzeniu dziecka z wadą wrodzoną.
prenatal
Europejski Trybunał odrzucił
examination,
zarzut,
the
powołując
court
się na to,
rejected
że
the
skarga nie dotyczy treści
accusation, saying
przepisu,
that the
a także na to,
complaint
że
does
sądy
not concern
konstytucyjne
the subject matter of the provision
nie
and that
wydają się właściwym forum
constitutional
orzekania
complaints
w
are not the
przedmiocie
right forum
rozstrzygania
to
o prawnej
decide
dopuszczalności
about the
aborcji w
legal
konkretnej
right to
sprawie,
abortion in a
jako że
specific case,
sprawy te
because such
wymagają
cases
badania
need to
kwestii
be
medycznych,
examined
tak
on
jak
a
to
medical basis,
był uczynił
as it would
poprzednio
have
na
been
przykład
done
w
as
sprawie
it did
A, B
in
i C
A, B,
przeciwko
and C against
Irlandii.
Ireland.
A w wyroku
In
Moskwa
Moscow
przeciwko
against
Polsce
Poland, in
Europejski
its
Trybunał
judgment, the
orzekł o
European Court
naruszeniu
said that
artykułu
the
1
Article
protokołu
1 of Protocol
pierwszego do konwencji
1 to the convention was
ponownego
violated
rozpatrywania
because
z urzędu i na
ex
podstawie
officio
tych samych
examination
akt
was made of the
kwestii
same case
prawnych
files
skarżących doświadczeń z
of the
ubezpieczenia
rights
społecznego.
of the
Chodziło
applicants
o dużą
under
grupę matek, które zyskały te
security
uprawnienia, po czym
rights.
zostały ich
The mothers
pozbawione
were
w
deprived
drodze
of their
decyzji
rights
wydanych
by
na podstawie
decision
artykułu
based on
114
Article
ustawy z 1998 roku
114
o
of
systemie ubezpieczeń
98
społecznych,
on Social
przepisu
Security Law,
proceduralnego
a
pozwalającego na
procedural right
ponowne
that
rozpoznanie
allows
kwestii
to
uprawnień z
re-examine
ubezpieczenia
the rights
społecznego
to Social
na
Security on
podstawie
the
tych
basis of
samych
the same
dokumentów i
documents
dowodów, które
and
już
evidence
uprzednio
that
służyły za podstawę
used to
wydania
be the
orzeczenia
basis
korzystnego
for
dla
a favorable
ubezpieczonego.
ruling for the
W tej sprawie
applicant. So in
potraktowanej
this
przez
case,
Trybunał
the
Strasburski
European
jako legal
Court
case nie został zgłoszony
that
zarzut niewykorzystania skargi
the
konstytucyjnej.
constitutional
Jednakże
complaint
skarga
was
ta
not
stanowiła część
something
dużej
that
grupy
was a
skarg tego samego
charge, so
rodzaju,
it was a similar case
dotyczących identycznych
of
sytuacji.
similar
W sprawach
sort.
rozpoznawanych
In cases
później rząd
examined
zgłosił
later,
zarzut
the government
niewykorzystania
raised the
skargi
challenge that the
konstytucyjnej w celu
constitutional complaint
kwestionowania wprost
was not
przed
taken
Trybunałem
into account.
Konstytucyjnym przepisów mających
That was
zastosowanie
to
w sprawie.
apply to the case.
Rozpoznając
In
kilkadziesiąt
examining
spraw tego
several cases
rodzaju
of
w
the
roku
same
2012 i
in
2013,
2012
te skargi
and 13,
Europejski Trybunał
the European Court
zauważył, że rząd nie
noted
wskazał,
that
które przepisy zastosowane w ich sprawie powinny były zostać zakwestionowane. Na przykład wyroki w sprawach Lew, Kusina, Rzepek,
Ratkowski,
Radkowska,
and other
Durat,
judgments,
Szyfler,
Durach, Schiffer,
czy
were
Franciszek.
not taken
Niektóre
into
z nich
account.
zostały
Some of them were
odrzucone
rejected
ostatecznie jako
finally
nieuzasadnione,
as
ale we
groundless, but
wszystkich
in all
sprawach
cases,
zarzut oparty na niewniesieniu skargi
the charge that
konstytucyjnej
the
został oddalony.
failure that
Rząd
constitutional complaint
powoływał
was
się
not
na to,
raised
że
was
w
dismissed. The
2012
government
roku
said that in
Trybunał
2012 the
Konstytucyjny wydał
constitutional
wyrok o uznaniu za
complaint issued
niekonstytucyjny przepis
issued that
114 paragraf
Article
1a, który został
114
zmieniony w
paragraph
ustawie
1
z
and 2 was
1998 roku.
unconstitutional.
Zwraca uwagę
It
na
noted
podobieństwo
the
treści przepisu
similarity of
zakwestionowanego
the
przez
wording
Trybunał Konstytucyjny
that was
do
also
przepisu proceduralnego
challenged by the
artykułu
Constitutional
114
Court,
paragraf 1, na którego
on the
podstawie
basis of which
ZUS wszczął na
ZUS
nowo postępowanie w
reinstated
sprawach
proceedings
skarżących.
in the cases of the
Europejski
applicants.
Trybunał był
European
zdania,
Court
że sukces
was of the
odniesiony
opinion
przez
that the
rzecznika w tym
success of the
postępowaniu nie jest
ombudsman
wystarczający
in
do
these
uznania,
proceedings was
że
not
skargi
enough
wniesione przez
to
skarżących zakończyłyby się podobnym
determine
wynikiem.
that these cases would
Podkreślił
end in
także,
the
że
same
wyrok Trybunału
ruling. I'd like to
Konstytucyjnego
mention
został
that the
wydany prawie 10 lat po
European
zakończeniu
Court decision was
postępowania,
mentioned about 10
które było
years after the
przedmiotem
proceedings. That
rozpoznawania
was the
przez
subject
Europejski
that
Trybunał, a
was
więc
examined by
zrozumiany
the
sposób,
court, so
bo nie zostało to
naturally that
powiedziane
was not
wprost.
said
Uznał,
directly.
że
The
skoro
court
wyrok
said
ten
that
nie miał
since
wpływu na
this
sytuację
decision had no
skarżących, nie
effect on
mógł
the
być
situation of
skutecznie
the
użyty jako
applicants,
argument
it
na
could
rzecz
not have been an
skargi
effective
konstytucyjnej
argument
jako
in
środka
favor of
skutecznego.
constitutional
Orzekł,
complaint
że
as an
argument
effective
sądu oparty
remedy.
został
He
na
said that the
teoretycznym i retrospektywnym, a
argument was
także
based
wysoce
off very
spekulatywnym porównaniu
speculative
sytuacji
comparison of the
skarżącego do
situation of the
obecnej
applicant
sytuacji
with
w
the
polskim
present
systemie prawnym,
situation
wymuszonej
in
uchyleniem
the Polish legal
przepisów
system
na skutek
by
skargi
setting aside
rzecznika
a
i
decision
wyroku
on the
Trybunału
basis of a
Konstytucyjnego.
constitutional court ruling.
Można
It could
uznać
be
te
said
orzeczenia
that
za
these
nawiązujące do
judgments
zasady
refer to
skutecznej,
the rule of
rzeczywistej
an
ochrony praw
effective and real
indywidualnych,
protection of individual
jak na
rights,
przykład w wyroku
like
jej przeciwko Irlandii,
against
która jest jedną z
Ireland, which is one
podstawowych
of the
zasad
basic
interpretacji konwencji.
rules for interpreting
Interesujące
the
w tym
convention. What
kontekście
is
są dwa
interesting in this
orzeczenia, które
context are
zapadły w
two
sierpniu tego roku sprawa
decisions,
Sobczyk i
Sobczyk and Schlieva.
Skargi
These
dotyczące tych samych kwestii,
applications
co sprawa
concern the
Moskwa
same
przeciwko
things as
Polsce,
Moscow
zostały
against
odrzucone
Poland
z
were
powodu
rejected
niewykorzystania środków
because of
odwoławczych.
failure to use
Rząd
of
powoływał
domestic
się na wniosek
effective
o wznowienie postępowania po
remedies. The
wyroku
government
Trybunału
said that we need to
Konstytucyjnego jako środek,
reopen
który
this,
skarżące powinny
that the applicants should have used the
Europejski
constitutional
Trybunał
complaint. The
orzekł, że
European
powinny
Court
one
said
były
that they should
wnieść
have
wniosek o
lodged
wznowienie, bo kiedy Trybunał
a motion for
Konstytucyjny
reopening because
wydał
when the
wyrok
Constitutional
dotyczący
Court
przepisów
issued a decision
artykułu
of
114
resumption of
paragraf
Article 114,
1a,
paragraph 1,
Nie minęło jeszcze
Not
5 lat
5
do
years
wniesienia
have
wniosku o
elapsed
wznowienie
since
postępowania
the
zakreślone przez
motion to
artykuł 408
reopen
Kodeksu
proceedings
postępowania
under the
cywilnego.
same articles.
Wyrok w
So the
sprawie
judgment
pierwszej
on the
skarżącej
first
wydany
applicant
do
was issued on the
28 lipca
28th of
2010,
July
w drugiej
2010. The
sprawie w
second
grudniu
case In 2010,
Posłużył się zasadą, że
court said
ocena
that the
wykorzystania środków odwoławczych może być dokonana
assessment
także
of
dla chwili
effective
orzekania,
remedies
a
should be
więc
based on the
zastosował wyjątek,
situation,
bo
so
zasadniczym
it
momentem
said that the
relevantnym dla
relevant
oceny
moment
wykorzystania
for the
środków
elimination
odwoławczych jest moment wniesienia
of
skargi,
this
tak
is
jak
the
to czyni w
moment of
skargach dotyczących przewlekłości
application is filed,
postępowania.
as in the case of
To jest
excessive
podejście
head of
zapoczątkowane
proceedings,
orzeczeniem w sprawie
which
Polsko
was
przeciwko
started
Włochom.
by
Europejski
against
Trybunał
Italy. The
pominął
European
to,
Court
że skarżące w chwili
ignored the
orzekania
fact that
przez
the
Trybunał,
moment
to jest w sierpniu
the applicant
2015
left
roku,
was
nie miało
examined.
żadnej możliwości
The
wystąpienia z
applicant
wnioskiem
had
o
no
wznowienie,
possibility
także
to
dlatego, że
motion for
3-miesięczny
reopening
termin
because the
zakreślony przez
3-month
artykuł
period
407
under Article
paragraf 2
307
KPC
of
do
the
wniesienia wniosku o
Code of
wyroku Trybunału
of
Konstytucyjnego już
Civil
minął.
procedure has elapsed.
Europejski Trybunał
European
powołał
Court
się na
referred
orzeczenia
to
wydane w
rulings
sprawach
issued
np.
in matters
Broniowski
Wojewódzki
przeciwko
against
Polsce
Poland
czy Łatak przeciwko Polsce. Powstaje
and other
wątpliwość, czy
cases, so
istotnie
there's
są
a
to
doubt
sprawy
whether
służące
these issues
wzmocnieniu
really
rozumowania
strengthen the
Europejskiego
understanding
Trybunału, zważywszy,
and
że
the
w tych
rulings of the
wszystkich
European
sprawach
Court, especially
skarżące w
that in
czasie
all these
orzekania
cases,
przez
the
Trybunał
applicant,
Europejski
when the
mieli
court
jeszcze możliwość
examined
sięgnięcia
the
po
case,
środki odwoławcze
could
wskazane
still
w
rely
orzeczeniu
on
jako
the
relevantne.
measures that were
Podobnie było w
indicated
innej
in the
sprawie
ruling.
Polski
The same
typu Moska, to znaczy
can
sam
be
sobie
said
przeciwko
about Moscow
Polsce,
against
ale tam
Poland, but
wniosek
there
o
the
wznowienie w chwili
motion for
orzekania przez
reopening at the
Europejski
time
Trybunał
the European
został
Court
wniesiony
examined the
przez
case was
skarżącego i zawisł już przed
was
sądami
filed by
polskimi.
the
Miał więc
applicant
jeszcze
and was before
realną
Polish court,
możliwość
so
dochodzenia
he
swoich praw.
had real chance to
W sprawie Łatak przeciwko
assert
Polsce
his rights.
dotyczącej
In other
powództwa
cases, for
odszkodowawczego
license
za
for
przelepienie
damage
i
for
złe warunki
overpopulation
więzienne,
at bad prison conditions, the
Europejski
European
Trybunał
Court
ustalił, że od marca
determined that
2010
since March
roku
2010,
istniała w świetle
in light
orzecznictwa
of
sądów
the
polskich
Polish law
możliwość
and case
skutecznego
law,
wytoczenia
it
takiego
was possible
powództwa przez
to
osoby
bring the
pozbawione
case
wolności.
for
Wyraźnie
court by
wskazał on w tej sprawie,
Polish
że w chwili
individuals.
orzekania
The
przezeń,
time
że skarżący mógł
the
jeszcze wytoczyć
applicants could
powództwo
still bring the
odszkodowawcze, bo
case
termin do
for
jego wniesienia wynikający z
indemnity
przepisów odpowiedzialności za
because
czyny
the time has not
niedozwolone
lapsed.
jeszcze nie minął. W sprawach
In
Sobczyk i
Sobczyk
Zima
and Zima
intrygujący
against
rezultat
Poland, the
ostateczny jest
intriguing
zatem
result is
taki,
such that
że skarżący
the
nie mają
applicants
żadnej
have no
możliwości
possibility
kwestionowania
of
orzeczenia,
questioning the
które
judgment
zapadło
that
w
was
oparciu
made
o przepis
on the
uznany
basis
przez Trybunał
of a
Konstytucyjny za
provision that was
niekonstytucyjny i w
unconstitutional by
sytuacji, którą
Constitutional
Europejski
Court,
Trybunał uznał
and in
za
a
naruszenie
situation when the European
pierwszego
Court said
protokołu
it was a
pierwszego.
violation of
Podejście
Article 1 of
zastosowane przez
Protocol 1. The
Europejski
approach
Trybunał w sprawach Sobczyk i Zima wydaje się
to
zatem
Sobczyk
być
and Zima
bardziej
seems to be
restrykcyjne
more
i różni
restrictive
od tego,
and
które
different from the
cechowało
one
wcześniejsze
that
wyroki i
characterized
orzeczenia
earlier
wydane w sprawach
judgments
typu Moskwa co
issued
do
in
właściwego
cases
środka
of
odwoławczego.
judgment in Moscow that were concerned effective remedies. Constitutional
Skarga indywidualna do
individual
Trybunału wypełnia
application
lukę w krajowym
fills
systemie
the gap
ochrony
in the
praw człowieka
Polish legal
przy czym nie bez
system of
znaczenia
human
dla
rights
jej
protection,
atrakcyjności dla
and it is
uczestników
attractive
systemu
because
prawa jest, że
there's a
6-miesięczny
6-month
termin jej
period
wniesienia
for
jest
lodging
ciągle
it,
jeszcze znacząco
and it's
dłuższy
still
niż
longer than the
3-miesięczny
3-month
termin do
period
wniesienia
for
skargi
lodging a
konstytucyjnej.
constitutional complaint.
Granica między
The limit
sprawami,
between cases
których naruszenie
the
praw
violation
człowieka
of
wynikać
which
będzie z treści przepisu
arises
krajowego,
from a national
których
law
to naruszenie będzie
and which arise
rezultatem
as a
sposobu
violation
stosowania prawa,
of the application of law is very
konieczne jest więc jej
fluid, so we
określenie
need to be more
każdorazowo na tle
precise
okoliczności
when we
konkretnej sprawy.
determine the case. The
Europejski
European
Trybunał
Court
będzie także
will
zwracał
also draw
uwagę na
attention
argumentację
to the
skarżącego co do
arguments
tego, czy
of
w
the
danej
applicant
sprawie
whether in
naruszenie
a
wynikało
given case the
wprost z
violation
przepisu,
is direct
czyli organ państwa
the
nie miał
result
innego
of the
wyjścia niż
application of
zastosować przepis
a law that
w
the court
sposób
had no way
naruszający
of
konwencję,
applying it that
czy też
would not
źródłem
violate the
naruszenia
convention,
jest
or whether the
sposób
source of
interpretacji przepisu.
violation
Także
is
więc
the way
w tym sensie
the
ocena
legal
to skarga
provision was
konstytucyjna okaże
interpreted.
się w okolicznościach
So
sprawy
in this
środków
case,
odwoławczych, po którym
this
strona
determines
winna była
whether
sięgnąć, podlega ocenie
constitutional
zawsze
complaint
face to
is
face.
an effective remedy determines on a, can be determined on a case-by-case basis. This affects the persons who lodge such complaints. When the subject matter of domestic law can violate rights guaranteed under the Convention and the Constitution, the question arises whether the fulfillment of domestic effective remedies would require a prior lodging of a constitutional complaint if the applicant said that his rights were violated because in which the law was applied, not because of the subject matter of the norm, the constitutional complaint will not be accorded to him. So an individual application to the European Court can be filed without going to the Constitutional Court
skargi
and
do
by
Strasburga
maintaining
jest przed
the
upływem
term
6
of
miesięcy.
the 6-month period
Owa
of
trudność w
lapse.
określeniu,
This
do której z tych
difficulty
kategorii
to
konkretna
determine
sprawa może w
to
istocie
which
należeć,
category case
stawia
really
skarżących w trudnej
belongs
sytuacji.
puts the
Zmusza ich
applicants
bowiem
in
do
a
podjęcia
difficult situation
decyzji,
because
czy
they have to
powinni
make a
wnieść skargę
decision
do
whether they
Trybunału
should file
Konstytucyjnego
a complaint
zgodnie
with
z
the
wymogami prawa
Constitutional Court
polskiego,
under Polish
kwestionując
law, that
zatem
is
treść
questioning
polskich
the
przepisów
Polish
prawnych jako sprzeczne z prawami
provisions of law
człowieka
as contrary
i
to human
konstytucyjnym
rights in their
kształcie,
constitutional
czy też
shape,
raczej
or whether
skierować
they should
skargę
file
do
an
Trybunału w
application
Strasburgu bez
with
wszczynania
the European
procedury
Court without
przewidzianej
going
przepisami o
through
skardze
the
konstytucyjnej.
domestic
Osoby,
procedure.
której skarga do Trybunału
The persons
Strasburskiego dotyczy samej treści przepisów prawa, a które
who
skargi
file a
konstytucyjnej
complaint
nie
to
wniosły,
European Court
ryzykują, że ich
because
skarga
they
wniesiona
say
na
that
podstawie
the
przepisów
provisions of
konwencji zostanie
law
odrzucona z
violate their
powodu
rights will
niewykorzystania
be rejected
krajowych środków
because
odwoławczych.
on the
Osoby
grounds
zaś,
that they
które
did
podnoszą
not
skargę do
use
Trybunału
domestic
Europejskiego zarzut
remedies, but
naruszenia
if
i naruszenia praw człowieka
their human rights
na
are
skutek
allegedly
określonego
violated
sposobu zastosowania
because
przepisu
of the
krajowego,
interpretation
a
of
przedtem
Polish
wniosły
law,
skargę do Trybunału
and before that if they
Konstytucyjnego, ryzykują, że tę
file
ostatnią
a complaint with the
Konstytucyjny
Constitutional Court,
odrzuci jako
then they
niespełniającą
risk the
wymogów
Constitutional
określonych w artykule
Court
69
rejecting
ust.
that
1 Konstytucji.
complaint
Co
under
więcej,
Article
ryzykują,
89.
że również sąd
They also risk the fact that the European Court will reject their case because the 6-month period had lapsed since the date of the final judgment that was issued in a normal instance. But because of the fact that the proceedings before European Tribunal last not shorter than 6 months, this risk is more than real. Now, coming slowly to conclusion, on procedural grounds and cautionary grounds, we need to file a complaint to European Court, keeping the 6-month period and file to a complaint to the Constitutional Court, keeping the 3-month period. Given the fact that if there is no public judgment issued by bodies that may be questioned or challenged, the ability to use the constitutional complaint is not advanced. It's not always needed. Żelak against Poland on the teaching of religion in public schools is a case in point. A similar thing can be said about the Constitutional Court saying that the provisions were constitutional on the basis of which a decision was made for the applicant. There's no need to reopen proceedings. That is the case of Rosiński against Poland. There's a judgment about this called frozen lands under a Land Management Act of 1974. In cases which are challenged because the state has not fulfilled its positive obligations under Article 8 or Article 1, Protocol 1 to the Convention, the usefulness of a constitutional complaint as a legal remedy is small. The same can be said about the situation where the constitutional complaint is based on the charge there is lack of normative basis for some kind of an action on the part of public authorities to effectively exercise individual rights, and when there is a grounds, but it's not sufficient, as it was the case in the pilot case Broniowski against Poland. Approach to the role of constitutional complaint as a legal remedy, developed in Środków in 2003, turned out to be long-lasting. The European Court still examines where conditions are fulfilled that were indicated in this application when it issues its ruling. Between the Constitutional Court complaint and the application to European Court, there is no functional interdependence. The constitutional complaint cannot fulfill the same role. The fact itself means that the European Court has to rely on the Schott-Medyńska case. Only in a small percentage of cases, applicants said that their complaint results from the norm of law. The need to rely on constitutional complaint also supported by the fact of the identity of rights guaranteed under the Convention and the Constitution. There's an open question what would happen if this material relation were to be loosened by the European Court departing from the case law and decoding the material norms of the Constitution. analyzing the cases, we can say that very rarely applicants, even if they're represented by professional lawyers, they treat constitutional complaint as a measure that will effectively protect individual rights. Even though there were 4 conferences that dealt with the future of the European Court, the results of this say that the states look at the case law of the European Court in a subsidiary way. That means they can rely on them only when everything else fails. But this is a two-edged sword, because it means also that the responsibility for effective implementation rests on the state in the first place. It seems that we should not expect any basic changes in the approach of the European Court to the Polish constitutional complaint as an effective remedy, but we cannot exclude a more restrictive approach, as it was the case in the judgment of Sobczyk and Zima. One should not expect from the European Court any impulse that would lead to give the constitutional complaint a different nature than the nature that it has now, because, as it was said, the sole competence is in the hands of the lawmaker. This is Ms. Miszewska's text that I just read out to you. Let me just give you 2 minutes for my own reflections. I am reminded of 2 interesting cases and the correspondence between the Constitutional Court and the Strasbourg Court. The first case is a well-known case, Bizerkania against Poland, when the complaint was lodged with the Constitutional Court with a question whether the penal sanctions or criminal liability for failure to fulfill an obligation to authorize a text by the journalist is in accordance with the Constitution. Article 54, Constitutional Court said it's not unconstitutional. Mr. Bizerkaniów lodged an application with the European Court and the court's decision was different. He saw the legal fiction that we are under impression exists in Poland, namely that a quote, directly quoted, needs authorization. So if a journalist does not have this authorization, then you can really bring someone to court for this. And when you just refer to some statement, then it does not exist. So we can say that the provisions are unconstitutional in this regard. But there's another case which shows the context of the case. So the question is whether one should file a complaint with the Constitutional Court with a 3-month cut-off period, or whether to wait and have a 6-month cut-off period to wait and file it with the European Court. I'm reminded of a case of Robota Rabczewska in October this year. Robota Rabczewska filed a complaint about freedom of conscience, Article 196 of the Criminal Code, religious feelings. And I talked with people from the Helsinki Foundation of Human Rights, and they observe such cases as part of freedom of the media. And I think what we saw was a certain, maybe not calculation, but a reflection. We, just in case, in cooperation with the lawyers, we will try to file a case both here with the court in Strasbourg and the Constitutional Court, just to keep the time and see for the reaction of the Constitutional Court, and then we, just in case, also file a case with the European Court, and we'll have it registered. As you know, the European Court has not seen any unconstitutionality in this, so I understand the road is open to file to the European Court in Strasbourg. Thank you very much for your patience and for your understanding. Thank you very much.
Bardzo dziękuję pani doktor za przedstawienie tego frapującego zaiste wystąpienia.
Thank you
wrażenie,
very
że
much
tutaj
indeed
ustawy
for this
wykorzystane do
fascinating
dialektyki
paper
dialektycznej,
with
prawda,
electric
wskazującej na
dialectics
absurdy, pewne wewnętrzne
highlighting
sprzeczności,
absurdities
które
and
pojawiają się w omawianej
internal
kwestii. Ale
contradictions
mówiąc
of
serio,
various
chciałbym
issues,
tak zupełnie na
but
marginesie zauważyć, że
just
ponieważ Pani powołała sprawę, w której uczestniczył
marginally,
Rzecznik
because you
Obywatelski,
mentioned the
jeżeli chodzi o
case
wniosek do Trybunału
where
Konstytucyjnego,
Ombudsman
że
is a
w
party,
raporcie medyków
and
bodajże
in
przy
the
okazji
report
protokołu
of the
14 pojawił się taki
Wiseman
postulat, który
Group
był rozważany, ażeby
discussing Protocol
skarga do
14,
krajowego
it was
ombudsmana była właśnie
suggested that the
rozważana jako
complaint to
krajowy
Ombudsman
środek
should be
odwoławczy,
treated as a
którego
national
wyczerpanie
remedy,
jest konieczne do
which
złożenia
must
skargi
be
do
exhausted
Europejskiego
and
Trybunału Praw
made
Człowieka.
used of
Ten pomysł nie
before
uzyskał takiej
filing an
akceptacji,
application to the European
zapewne
Court.
też
It was
dlatego
not
z powodu
approved of,
pewnej
also
wielkiej
because of certain
dyferencjacji pomiędzy tego typu instytucjami
differentiation
całej Rady Europy i w ogóle istnieniem, brakiem
of
istnienia w pewnych krajach
traditions concerning
instytucji
an
rzeczywistych
ombudsman
na pewnym poziomie.
all
Tak na
across
marginesie
Europe,
chciałem
but
wspomnieć, że
just
taki
marginally I
pomysł
wanted to
padał.
say that there was
W tym momencie
such an
chciałbym poprosić
idea.
panią profesor
May I now
Monikę
hand
Florczak-Wątową
over to
o
Professor
przedstawienie
Monika
wystąpienia,
Florczak-Wątor
które
for her
brzmi
paper,
Skuteczność
Effectiveness
skargi
of
konstytucyjnej,
Constitutional
perspektywy zmiany
Complaint
jej
and
kształtów,
Perspectives of its
refleksje w związku z
Amendment,
zbliżającym się
Reflections
20-leciem
on the eve of the
funkcjonowania
approaching
skargi konstytucyjnej
20
w kierunku prawnym. Bardzo proszę.
years anniversary of the functioning of the Constitutional Court. Madam Professor, over to you. Well, thank you very much for inviting me to this meeting. It is a great honor for me to address this prominent forum among so many prominent and eminent panelists and the audience as well. My paper will be on the evaluation of effectiveness of a constitutional complaint in the national legal order, although I will also highlight to your attention certain liberty restrictions, because the very title implies that the constitutional complaint will need to be amended. So the underlying presumption would be that the constitutional complaint would be ineffective. However, I do agree with organizers. I don't have to question the appropriateness of the title of my paper. So the first point is the effectiveness of constitutional complaint, and what is it? It could be considered on two platforms where constitutional complaint exists, that is the scope of the matter and the parties involved. It is effective when its examination by the Constitutional Court results in a situation of removing unconstitutional provision from the legal order. Speaking about the situation of individual filing constitutional complaint, it is only effective if the decision pursuing from the filing will satisfy certain needs and certain injustice done to an individual. We know that Article 79 of the Constitution provides about the complaint as one of the remedies to protect liberties and rights, but on the other hand, this is also a way to question constitutionality of law. And it is fairly easy to evaluate the effectiveness of constitutional complaint in terms of the scope of application of Polish law, because indeed many illegal provisions have been removed from the body of law. But in terms of its effect on individuals, well, it is quite difficult to say to what extent it is effective. Never has it happened that the consideration of constitutional complaint has directly improved the situation of the applicant or the claimant. So it never leads directly to the attainment of the goal, that the applicant wanted to attain, that is to repeal decision that was issued in this individual case. So the constitutional complaint is a very specific remedy in that sense that an applicant, in order to have his rights satisfied, must first obtain a general benefit goal that will be removing of unconstitutional provision. In that sense, a constitutional complaint might be deemed to be entirely ineffective because the proceedings before the Constitutional Court will not remedy or change the situation of the applicant immediately. And in the proceedings of before the Constitutional Court, constitutional complaint will only be effective when it leads to the amendment of the law. Now, if it also triggers off proceedings under Article 190, Clause 4 of the Constitution, well, this is precisely the provision which may amend or change for the better or the worse the legal situation of the claimant, of the applicant. So only proceedings under Article 190, Clause 4 of the Constitution will serve the direct purpose of protecting rights of the applicant. So I don't want to put any revolutionary propositions and to defend such propositions that constitutional complaint is totally ineffective when it comes to protection of individual freedom. After all, it has been functioning for 20 years, so why don't we change the perspective? The effectiveness in terms of its effectiveness upon individuals can be only evaluated looking at its effectiveness under Article 79 and Article 190 of the Constitution. And only if we take those two into consideration we may speak about effectiveness of the constitutional complaint. This is nothing new. In fact, it has been already mentioned in jurisprudence of the court in 2006 in SK 10/06, where the court said that the applicant needs to have the option, the ability to positively enjoy the results of the application that has been filed and must have a decision repealed if needed, so from the beginning to end. And the interdependence between the opening and the end is indicated in the jurisprudence of the European Court. In certain cases, the European Court has noted that if it is known in advance that the finding of unconstitutionality of a given provision will change nothing for the applicant, then the application itself will not be admissible. And this was indeed in the case with the signature note SK 10/06. So there must be a presumption that there will be a positive and beneficial effect to the applicant if the European Court issues a decision. If an improvement in protection of constitutional rights will happen or not. And in this particular case, SK 10/06, the application was rejected because even if the demands of the applicant were taken into account, there would be no way to set aside and repeal the decision which was issued on the basis of another provision of law. So one of the preconditions to apply constitutional complaint is the potential and presumed effectiveness. If it is doomed to be ineffective, it will be rejected. Now, looking at the problem from another perspective. It is noteworthy to see that the two proceedings that I want to bring into one, that is proceeding under Article 79 and Article 190 of the Polish Constitution, well, they are not synchronized enough, and sometimes formal conditions for admissibility of constitutional complaint are the stumbling block, and this is why the final result will not be achieved by the applicant unless the Constitutional Court issues a decision in another procedure. For instance, you may only lodge your constitutional complaint if your constitutional liberties or rights were violated. So, if something is incompatible with general systemic standard but not safeguarded directly in the Constitution, then the applicant cannot possibly have his or her complaint examined by the Constitutional Court, and his or her rights will not be duly protected and the case will not be reopened. However, if the application is raised by the court or the Court of Appeal and will deem that the provision is incompatible with the constitutional law, then the decision of the court may help to repeal the initial decision and improve the initial situation of the applicant. So here we come to the conclusion that there is a stumbling block to protect duly individual rights and liberties if we initiate a constitutional complaint, and asking a question in law might be a better way. So the juxtaposition between Article 79 and Article 190 of the Constitution may lead to ineffectiveness of the constitutional complaint. Now, looking at the constitutional complaint from almost 20 years perspective of its operation, one can say that there are two reasons why the proceeding may be interrupted and may not allow the applicant to have the initial decision repealed. The first reason why it may not happen is that the court in law and the Constitutional Court may differ as to their evaluation of the effectiveness of constitutional complaint. And the other thing is that there may be no other remedy involved, and looking now at the divergence in the evaluation of effect of constitutional complaint by the Court of Law and the Constitutional Court. As we know, the courts have rejected the option of reopening the case on the basis of positive interpretation ruling. Although the Constitutional Court stated that there was also a positive element to it. So in negative cases, the Constitutional Court implies that there is also a positive indication in the ruling, but the courts do not want to reopen cases on that basis. Also, if in the ruling of the Constitutional Court there is no derogation, there is no change of the normative wording, and there are just explanatory interpretation rulings issued, and the courts are not willing to take on board such decisions either. Also, it is not that the courts of law and the Constitutional Court vary in their evaluation of the effectiveness of constitutional complaint. For instance, reopening of a case on unconstitutionality of an omission. Well, it is either there a ground for constitutional complaint or not? The same goes for adjournment and also there are three positions concerning suspense or adjournment of a ruling, and it is difficult to wrinkle out of all of those differences. All in all, the object that was initially pursued by the applicant may not be satisfied at the end of the day. I will not speak about the faulty wording of the law on reopening of cases following the decision of a constitutional court, be it in civil law proceeding or in criminal court proceeding, and sometimes interpretation was too narrow and the claimant or applicant could not ask for reopening of a case. For instance, there is a need to reopen cases, civil law cases, which were ended with court decisions on the basis of constitutional complaint. All in all, we may infer that there is a degree of ineffectiveness of constitutional complaint, and I have three demands or suggestions that I would like to formulate vis-à-vis effectiveness. The three demands or suggestions boil down to one thing, namely that complaint procedure should be broadly open to the application of law. So the Constitutional Court should have the right to appeal a court decision, a court ruling, if it was founded on unconstitutional legal basis. It may sound revolutionary, but on the other hand, if we look at interim injunction or adjudication, which was mentioned in the previous law and is also available in the present act of law, it allows the Constitutional Court to interfere into court proceedings, also completed court proceedings, and it allows to stop and to suspend the enactment and enforcement of a decision, especially if such enforcement would be reversible. So, and if it would produce valid public results. So the Constitutional Court interferes very strongly into court decisions which have already been taken and whose realization is ongoing. Whenever the charge of unconstitutionality of a provision has not been even fully grounded. So we should really not need to fully ground the unconstitutionality assumption. It is enough to have such an assumption. On the other hand, once the Constitutional Court states that the legal provision was unconstitutional and yet on its basis a ruling was issued by a court and the ruling was then stopped by the Constitutional Court, then starting from the entry into force of a new court decision, the previous one will lose its validity in 3 months' time. So it seems to me that this complaint procedure should end in affording full protection so that the legal situation of an applicant changes completely and the previous decision is fully repealed. And another option available to us would be to end the complaint proceeding by repealing the court decision which was issued on the basis of unconstitutional provision of law. And finally, we come to the court proceedings before the court, but where does it happen that the interrelation between the two proceedings must be interrupted, and where can we prevent such an interruption?
drugi postulat.
And my
Przyznania,
second
Trybunałowi prawa do
recommendation,
badania
the
prawa w kontekście
Constitutional
okoliczności jego
Court
zastosowania.
would really examine
Mianowicie, Trybunał ucieka
circumstances
oczywiście
for
od badania sfery
application
stosowania prawa i w takiej
of
sytuacji po prostu
law.
umarza
The
postępowanie,
Constitutional
jeśli
Court
dochodzi
doesn't
do
really
wniosku, że
want to
problem dotyczy
examine
sfery stosowania
such
prawa, a nie
conditions
sfery
and
obowiązywania
circumstances
prawa. Natomiast w
surrounding
praktyce
the
jest
application of
możliwe,
law, but in real
takie
life it is
konsekwentne
not
rozdzielenie
really
tych dwóch
possible to
sfer.
brush
Nie jest
aside
możliwa
the
ocena prawa
circumstances.
bez
If we
uwzględnienia
want
kontekstu
to
jego stosowania, tak jak
evaluate
Trybunał stara się
law
to
as it
robić. I tutaj
stands, we
trzeba było
need
zwrócić
to
uwagę na
look
to, że
into its
ten pogląd
consequences.
Trybunału, że on się w ogóle
And
nie
here
zajmuje sferą
Constitutional
stosowania prawa,
Court,
to
which
nie jest powodem
says
prawdziwym
that
w
it's
świetle
not
orzecznictwa
going to
Trybunału.
observe the
Co najmniej są
application of the
dwie
law,
kategorie spraw,
may
gdzie
not
Trybunał
be
się zajmuje się tym
true,
stosowaniem prawa i
because
ocenia,
there are
jakie
two
ono jest
areas
w ogóle
where
jest.
they evaluate the
Pierwsza
application of law.
kategoria spraw
The first
dotyczy
category of such
sytuacji
cases
kontroli przez Trybunał przepisów,
is
który nie
the
obowiązuje.
control
Mianowicie w świetle
of
orzecznictwa
invalid
Trybunału,
provision
żeby
of
ustalić,
law.
czy przepis
So,
obowiązuje,
to
czy nie
check
obowiązuje,
if a
podział
provision of
przepisów
law that has
trzeba
been
ustalić, czy on jest
repealed
stosowany,
is
czy nie.
still
Więc Trybunał tutaj bada, czy jest
valid
stosowany,
or
czy nie.
not,
Jeśli jest stosowany, to obowiązuje,
makes
a
it
zatem
necessary
przepis
for
jeśli nie
the
jest stosowany, to nie
Constitutional
obowiązuje.
Court if
Więc tutaj co najmniej
it's
badamy sferę
applied in
stosowania.
practice
I
or
po
not,
drugie,
to check if
jeśli
it's
chodzi
applied
o
in practice
ocenę
or not,
wykładów
and
sądowych, mianowicie
evaluation
Trybunał
of
bada, jak dany przepis jest
interpretation.
stosowany. Jeśli jest
The
stosowany
Constitutional Court
jednolity,
shows
utrwalony i
and
powszechny
checks
sposób, wtedy mówi,
whether
że
there is
to nie jest
a
problem
uniform
stosowania, tylko to jest problem
application
przepisu. Po prostu treść
of
przepisu
a
została,
provision. If there is a
zdeterminowana
uniform
przez wykładnię.
application, then
I teraz
the
wydaje mi się,
problem
że
must
gdyby
lie in the
dopuścić,
wording of a given
to, co oczywiście nie
provision.
wymagałoby,
And now, if we
zmiany
were
prawa,
to
ale raczej byłby taki
admit
postulat pod adresem Trybunału, że gdyby
a
dopuścić możliwość
situation
kontroli
where
prawa w tym aspekcie
the
właśnie, w którym
Constitutional
faktycznie prawo
Court
powinno być
can control
kontrolowane z
law
uwzględnieniem,
in this
z uwzględnieniem właśnie tej praktyki
area
zastosowania, gdyby,
where it should be subject to control, how it is applied. In many cases,
właśnie tego celu, do którego zmierza, a nie
applying
na to, że
individuals
wpada bardzo często
could
z
have
tego
their
typu
final
pułapka. Mianowicie Trybunał mówi, że on się sprawą nie zajmie,
pursuit
ponieważ to
fully
jest problem stosowania
satisfied,
prawa.
because very
Natomiast
often
to
they
jest problem
find
wykładni,
themselves in a
problem stosowania
situation
prawa.
that the
A z drugiej strony
Constitutional
właśnie
Court
sąd
says
nasz
they are
prawo
not
jest
in
jaki
charge
jest,
of
w związku z tym jest
observing
stosowany
the
tak, jak jest.
application of the
I
law,
tutaj nic więcej
and
nie
they
można.
cannot
Oczywiście,
change the
ten
practice
postulat
of
wiąże się
applying
z,
law. And
problemem relacji pomiędzy
this is
Sądem
of
Najwyższym,
course
Trybunałem i tak dalej, więc domyślam się, że również jest kontrowersyjny.
related to the
I trzeci
perplexed
postulat,
relationship
na sam koniec,
between the
który też
Constitutional
będzie
Court
właśnie
and the
dwuvariantowy,
Supreme Court of Law in
mianowicie
Poland.
rozszerzenia
And my
skuteczności
third
skargi konstytucyjnej poza realia
recommendation,
sprawy, na tle której
expanding
skarga
the
została
scope
sformułowana
of
po to, żeby
constitutional
skargę
complaint
konstytucyjną
on more
jako do
general
podstawy
issues,
konstytucyjnych praw
so
wolności
that
nie
it
były
is
tylko
a
środkiem ochrony
more
właśnie w
extensive,
indywidualnej
broad
sprawie,
legal
ale również
remedy,
właśnie w
not only
sprawie
in case, but
Mianowicie,
also in a
po
class of
pierwsze, w
cases.
procedurze
In the
skargowej
complaint
skutkiem
procedure,
orzeczenia
the
Trybunału jest
result
derogacja niekonstytucyjnego
of
przepisu, który był
the
podstawą
adjudication by the Constitutional Court
I bardzo
may
często jest to
bring
przepis,
to
który się bardzo
derogation
często, ale
of the
zdarza się, że jest
provision
to
of
przepis,
law
który
that was
nie
found in
obowiązuje, ale był
violation
podstawą
with
prawną do
Constitution.
rozstrzygnięcia
So
w sprawie
very often
oskarżonego,
such
obowiązując
derogated
nieszczególnie
provisions
przepisy, które mają
might have
identyczny
been the
normatywny jak
basis
ten,
for
który był podstawą
adjudications,
prawa
even if they were later
to
on
oczywiście wiąże się
changed
z
or
pytaniem, co
repealed.
kontroluje
So
ten
the question
przepis
is,
czy normę.
what
Niemniej
does
jednak wydaje się, że
the
jeśli
Constitutional
stwierdza,
Court control, the
niekonstytucyjność
provision
takiego
or
przepisu
the
i to
norm?
orzeczenie jest
If a
nieskuteczne,
provision
ponieważ
was
przedmiotowe,
unconstitutional,
ponieważ nie uda się
if
przepisu
the
usunąć z
ruling is
systemu prawnego,
ineffective in that
ta
sense
została
that
już
the
dawno
provision
uchylona,
has
to
been
tą
long
skuteczność w wymiarze przedmiotowym można
repealed,
byłoby właśnie
then
osiągnąć w ten sposób, żeby
effectiveness of
skutki
constitutional
orzeczenia właśnie na
complaint
inne identyczne
might be
przepisy o identycznej
achieved
treści
if
normatywnej,
we
mające inną
decided
formę,
to
ponieważ jest to
expand
przepis
the
w innym
force of
w innej ustawie czy
the
rozporządzeniu,
ruling
które
of a
obowiązuje dzisiaj.
constitutional court on
I po
all
drugie,
other
w procedurze
cases which are
skargowej zakres
similar to the
zaskarżenia
original
obejmuje
case.
te
In the
treści normatywne,
second
przepisy,
place,
które znalazły
the
zastosowanie w sprawie
normative
skarżącego.
contents
To jest
that were
widoczne w orzecznictwie
applied
Trybunału,
in
ale
the
również w sposobie
individual
sformułowania skarg
application
konstytucyjnych,
should be really
w
taken
którym
into
Trybunał
account
właśnie
in
czuje
its
się
in their
zobowiązany co
full
do
extension,
zakresu.
and
Mianowicie, że jeśli
if
postępowanie
the
dotyczy na
proceeding,
przykład, jeśli jest to na przykład
ongoing
postępowanie
proceeding is a
dyscyplinarne,
disciplinary
to wówczas zarzut
proceeding,
niekonstytucyjności
then the
wnoszony jest
unconstitutionality
co do tego przepisu w
complaint
zakresie, w jakim zawiera
will
on
be
konkretną karę
only
dyscyplinarną,
applicable to the penalty that was imposed on the applicant and not other penalties. And counter-argument that we hear is that the whole provision is unconstitutional and that also in other disciplinary penalties provided for in lower level acts like executive acts, they should be also seen as unconstitutional. So in conclusion, looking at those three possible changes in the use of institution of constitutional complaint, well, they would necessitate amendment to the Constitution and merging two provisions under Articles 79 and 190 into one. But this is not a really revolutionary proposition, and yet it would help us out to reinforce the effectiveness of constitutional complaint vis-à-vis individuals who are claiming. Thank you very much.
Bardzo dziękuję Pani Profesor za to niezwykle ciekawe i wielowątkowe wystąpienie w tym zakresie. Myślę, że tutaj wiele ciekawych uwag, także z punktu widzenia naszej pracy w Biurze Rzecznika Praw Obywatelskich. Pewnie Pan Rzecznik Kociuk mógłby na ten temat najwięcej powiedzieć, ale często Rzecznik stoi przed takim dylematem przystąpienia do postępowania wszczętego skargą konstytucyjną właśnie z powodu tych różnych wątpliwości, o których mówiła Pani Profesor, dotyczących dopuszczalności skargi, z zakresu powołanych wzorców, czy to z rozdziału 2 Konstytucji, czy też właśnie co do zasad ustrojowych, które czasem powodują konieczność podejmowania takiej trudnej decyzji, czy do tego postępowania przystąpić. Na szczęście Rzecznik Praw Obywatelskich dysponuje możliwością wniesienia wniosku abstrakcyjnego o kontrolę konstytucyjności prawa i czasem tą możliwość wykorzystuje właśnie z tego powodu, że w sposób skuteczniejszy można osiągnąć pewne efekty, także systemowe, niż za pomocą obecnie ukształtowanej skargi konstytucyjnej właśnie z powodu tych wielu
the institution of constitutional complaint, which is subject to so many restraints and limitations. And I think that the indication of this interconnection between Articles 79 and 190 was very interesting and valuable. Thank you very much, ladies and gentlemen. Thank you, panelists, for those papers and for very strict time discipline. Now, I would like to hand it over to you, ladies and gentlemen of the audience, and if professors allow me, I would like to invite questions to all the panelists. Vox Populi, Vox Dei. Madam Councillor, may I hand it over to you as first? Thank you very much, Professor. Thank you very much, Justice, for mentioning the role of lawyers of the litigant parties. In a nutshell, I can tell you that we have a constitutional power founded on judicial and prosecutorial independence. We also have an army of lawyers, counsellors, barristers, who are well prepared to represent the litigant parties, and the weakest link in the chain is lawyers. And I wanted to find out, Professor, how other countries in the Council of Europe carry out their obligations under Article 6 of European Convention on Human Rights on the equality of parties and Article 13, that is the effective general remedy. Are there any remedies that give arms to the army of lawyers, because our lawyers really ask for some weaponry to be used? I do hope that Professor Balcerzak, as a professional and practitioner as of 1991, educating others on human rights, will be able to help us in this respect. My appeal is that Strasbourg should not function as the third super instance. No, we, as lawyers for citizens, we are building democratic system of a just Republic of Poland founded on Article 2 of the Polish Constitution, and this is the only reason why we apply to Strasbourg. Thank you. Thank you very much. Why don't we pull up a number of questions? Chairman Wojciech Hermeliński has the floor, please. Instead of a question, could I present a short position, because I would like to make a short reference to the statement from the first opening session and the present session reopening of civil law proceedings following decisions of the court in Strasbourg. A few days ago, the court in Strasbourg issued a ruling on the case SK 27/11, and the main thrust was that there was an application of a lady who lost her case in the court of law in Poland, and she won in the court of first instance. Then there was an appellation, then the negative decision was taken in the court of appeal. The negative decision was sustained, then the cassation application was rejected by the Supreme Court, and finally, in the ruling issued in the Supreme Court of Justice, on the bench of judges, there was a judge who was also sitting in the Court of First Instance, and this was the basis for the questioning and challenging of a case on the ground of Article 379 about invalidity of a proceeding before the court, and in the court in Strasbourg maintained her rights, and she asked the Polish court to reopen the case, but the time lapse of 5 years has been exceeded by a few days. So the lady came back to the court in Strasbourg, showing that she had no access to court of law in Poland because of this time limit. And the court finally agreed with her. The ruling has been published on the website of European Court, and in the ruling the court invokes the Convention, but also, which makes me very happy indeed, opens up a new window for reopening of cases, namely states Article 408 of the law of 17th of November 1968 on civil law proceedings, in the scope when after the lapse of 5 years you cannot ask for reopening of the same case because of invalidity, and this is incompatible with Article 6.1 of the European Convention, and it would be in violation also with Article 77.2 and 451 of the Polish Constitution. So this is a new window of opportunity. This is only about time lapse and invalidity from the Article 379. Nevertheless, this is a window of opportunity, and even if this enforcement was adjourned and we don't know what legislators will do and whether we will be able to push it through in the last days of term in office or not, or whether they will adopt other premises, and we don't know if they are not likely to use 401 instead of the other article, as in case Podbielski against Poland, which involved the inability of reopening of a case. Nevertheless, anyhow, this is a new window of opportunity, breaking off from the old tradition. And I'm happy with this ruling, but unfortunately I cannot buy the arguments that were quoted here, where the Supreme Court of Justice stated, and one of the judges today also said that decisions are final and it is extremely difficult to repeal them once they have become final and set aside them once they have become final. But I'm not buying this argument because well, we can level the same charges towards the proceeding before the Constitutional Court. If someone won before the Constitutional Court and then someone says that this was founded on the unconstitutional provision of law, and in the adversarial procedure this is questioned and challenged, and even if someone physically is no longer pursuing this claim or this application, we land in the same situation that the other party will not know really. And Judge Nowicki is right. Maybe we should consider some restitution in terms of indemnity or other form. Thank you.
Bardzo dziękuję.
Thank you very much.
Pani profesor Nina Półtorak.
Professor Nina Półtorak. Thank you very much. I have a question to Professor Florczak, and I would like to ask about your postulate concerning increasing the competences of the Constitutional Court when it comes to the application of law. What would exactly this increases of competences of the Constitutional Court would involve? So there's a red light that comes to my head that maybe there's a confusion between the application of law, that this is a demarcation line between the competences of common courts and the constitutional courts. So when it comes to the application of law, courts are competent and then they can individually educate on the compatibility of Polish law and the EU law, which cannot not do in other spheres. So whether this postulate would not lead to a sudden exclusion of the competences of common courts with respect to the constitutional court. Thank you. Sorry, I don't know the name. The person who wants to ask that before. Michał Skarżyński, Human Rights Chair. I have also a question to Professor Monika Florczak-Wątor in relation to a train of thought that you raised. I do come into contact with such things. The Constitutional Court has problems with complaints that deal with legal ignorance. So when the person comes to me as a lawyer, I have no possibility of protecting his rights if the lawmaker, to put it simply, has failed to regulate. So the premises have been met, but then we come with a problem when we look at the court's case law. The models that they apply, they cannot be individually applied under Article 2 of the complaint. This is one thing from the practice of the court. So there is a sphere of complaints cannot be examined by the Constitutional Court because of the case law. And the second question deals with the situation relating to what Professor Helmeliński said, that there will be a negative effect of the offices of lawyers. So there's a constitutional complaint on the lack of indication of the offender. So I was a lawyer before the court, and I was in a difficult situation because in my case, first in chronological order, A question was asked by the Lublin court about the unconstitutionality of legal provision. Then there was a file, my constitutional complaint was filed, the right on different control models, and then the prosecutor was filed a complaint, then I was adjudicated in full composition, and then I have to fight with the opinions of the same marshal, speaker, and then the ombudsman, but I'll have to defend the rights against judges who will examine the case. So the question arises whether the case will be just discontinued because of the inadmissibility of passing a judgment, but I don't think that it's the case in both cases, because with respect to this complaint, my charges are a bit different, the perspective are different. So why do we have a constitutional complaint if the court addressed my complaint but did not give me the right to speak? It examined it twice, and now I am to represent a client whose rights were strongly violated. He cannot indicate who was the driver of the vehicle. In fact, he could not do this. And there was another subject of constitutional complaint. I know that the court will probably set aside that. I have a transport company that I represent. One Lublin court, the president of the Lublin court said my client was innocent because he could not indicate who was the driver, so he could not have committed an offense. At the same time, I had a case in Człoków, which lives from the photo writers, and the court there said, of course, my client is responsible, and the regional court said, I cannot invoke the Constitution, because in addition to rights, he has obligation, he has to pay traffic fines. Now I have to examine this case again and sort of go around the situation, because the court did not really address the practice that the photo writers are not installed according to the regulations of the producer, that the technical things have not, technical requirements have not been met in order to apply this to the law. So the question is whether a reaction on our side as academics, but also as practitioners to affect the law on constitutional court, a question of failure to act to be more precise, and what to do when a case was examined and it's been lodged. For instance, in one complaint, I motioned for a joint examination, but it was dismissed by the court, unfortunately. Thank you very much. Thank you very much for this important thing, that for all the drivers who were driving from Warsaw to Lublin, this answer will be very important. Professor, the floor is yours. Thank you very much. I have to correct, I am just a doctor. Paweł Dąbrowski, I am from the Refugee Council. I would like to ask a question to Professor Balcerzak. The question is as follows. Professor, let me start by the introduction. While fully agreeing that Article 13, when it comes to effective remedy, is general, to the extent that it does not allow to identify specific standards in a systemic respect. But don't you think, Professor, that the case law to Article 13 builds certain standards with respect to certain types of acts? I'm referring especially to administrative proceedings, to administrative cases, where a certain clear standard of protection of individuals is being constructed. And to continue my question and opinion, if we agree that such standards with respect to specific acts are being developed regarding this ability to suspend a remedy, the possibility to execute judgment, and de facto state that is considered in adjudication, the date of that act, whether this does not bring about certain risk of decodification, the fragmentation of the system of human rights protection, because soon we may find ourselves in a situation when it comes to administrative proceedings. In specific proceedings, the standard either will be very high, because it will be developed by the Strasbourg case law, or it will be much lower, as developed by the domestic case law. So this is what I am afraid of, such developments. Thank you very much. If there are no more questions,
to ja pozwolę sobie
permit me to
jedno, jeżeli mogę sobie udzielić
briefly,
głosu.
if I may give myself the floor as a
Do pana profesora
questioner, I would like to pose a
Garlickiego,
question to Professor
odnośnie,
Garlicki
poglądu, możliwości
on the opinion
odmowy
of refusal
zastosowania
to
przepisu prawa krajowego
apply
sprzecznego z
domestic provisions of
Konwencją
law
praw
which is
człowieka,
contrary to the
chociaż może
European
należałoby powiedzieć
Convention,
sprzecznego z
or
orzecznictwem
rather
Europejskiego
contrary
Trybunału
to the
Praw Człowieka.
case law of the European
Pan
Court.
profesor poczynił pewną
You
paralelę do prawa
set
Unii
this in parallel to
Europejskiej,
the EU law and
obowiązującej od co najmniej orzeczenia
and the
Zimental.
Zimental
Moje pytanie jest,
judgment. My
w
question
prawie
is,
Unii
in EU
Europejskiej,
law,
co najmniej od orzeczenia
since the
Konstanca, mówi się także o
Constanza judgment,
możliwości
there's talk
odmowy
about the
zastosowania czy
possibility to
powinności odmowy
refuse, or the
zastosowania przepisu
duty
prawa
to
krajowego
refuse to
sprzecznego
apply domestic
z
law
prawem Unii
if it's
Europejskiej
contrary
przez
to
organ
EU law
administracji,
by
przez
administrative
na przykład
body
toku procedury administracyjnej.
in the course of
Moje pytanie jest, czy pan
administrative
profesor
procedure.
byłby
Professor,
skłonny przyznać
question
takie
is,
prawo
would you
odmowy
grant this right to
zastosowania
refuse
przepisu
the right
sprzecznego z
to
konwencją
apply
także organowi
domestic law
administracji, a nie
to
tylko sądowi? Ja sobie zdaję sprawę
the
z trudności, które
administrative
mogłyby się z tym
bodies, not
wiązać.
only to court?
Nie
I
tylko
understand that there may be some
prawnych zapewne,
questions,
ale
some difficulties involved
myślę,
with
że to
this,
byłaby
not
bardzo
only legal
ciekawa
problems,
kwestia.
but I think it's an
W tym
interesting
momencie
issue.
poproszę Państwa Polaków o
I would
odpowiedź. Nie wiem, czy w
ask the
kolejności możemy
speakers to
wystąpić
respond.
także. Pani profesor,
Professor, the mic is yours now. Yes, thank you very much for the questions. When it comes to the question asked by the lady lawyer, I think a large part of Strasbourg case law concerning Article 6 is a part that deals with guarantees the rights of the parties to proceedings, especially when it comes to criminal proceedings, guarantees for the person who's accused. The court is in favor of strengthening the duties of the domestic lawmaker, and I think this also strengthens the position of the lawyer or the defender. I've never had the impression that this Polish lawyer is completely defenseless, and in any case, if he was weaker, then the case law tried in a way to compensate or reduce his position. Whether that was successful, it's difficult to say, but in my remarks that the lawyer is needed as an ally of the judge in invoking convention arguments, I can only add that it's up to the court to assess whether the argument has grounds or not, but it should be the duty of the court to give its opinion or in its judgment, in its grounds, not to just dismiss it as non-existent, and that could be expected from courts, and that could be one of the elements that lack of such address of the issue should also then bear upon the reliability of courts. Now, the second question about the Polish constitutional complaint, I think we should see it in three aspects. First, we have to see the rather deficient point of departure. Constitution was based on a certain compromise, as they say, but this compromise really consisted in the fact that at the time, first president of the Supreme Court won a case against others, and he just was able to defend his argument of the vision of the Constitutional Court. It wasn't a vision that was friendly for the Constitutional Court, so That was the reason why we have this creature now, meaning that we have a very limited version of the constitutional complaint. It was further reduced or limited, and it was done by the civil chamber of the court, which sabotaged the effectiveness of the constitutional complaint for the whole full term of the beginning of the 2000s, and the Constitutional Court was not too expansive when it comes to extending the scope of constitutional complaint. So that's why we have the constitutional complaint in the shape that we have it now, although the situation is different than in 2002 when Szot-Medinska was examined, and it wasn't sure how it would develop in the future. Today, the scope is modest, even though the complaints that are filed with the court and are examined on their merits, they sometimes bring very interesting solutions. And last but not least, the question of how far we should proceed in admitting, setting aside Polish laws. I would be happy today if the Polish judge would consider whether to apply the convention by refusing to apply the law. That would already be a very revolutionary approach. But I would have a lot of confidence to the judge in the sense that the judge has been trained to apply law and to apply and to evaluate the hierarchy of the different sources of law, whether an administrative officer has developed this ability to a sufficient extent. That I wouldn't be so sure, and I wouldn't start from that part. The Strasbourg court had to wait a while before it developed its mental case, so maybe we should also wait. But the idea itself has not seen sort of any proof in fact. Thank you very much, Professor. Professor Balcerak. Maybe very briefly. It wasn't a question that you asked. I think I don't recall questioning the goodwill of lawyers before the court. So that sounded that way, but I am deeply convinced that you act in the interest of your clients and that this is natural. Let me only say that, to be honest, I'm also an advocate of having a duty to have legal assistance with cases filed with the Strasbourg court, so I'm not an enemy of lawyers before the European Court, but the question whether case law does not build standards on specific proceedings, yes, it does. Because I said that case law does not create a universal standard of a general legal measure. But Article 13 does give us some specific standards on effectiveness, but it's not a guarantee of a remedy before court, but national authority, the word is used. So, yes, by all means, I share your opinion. I would say that I appreciate what the Refugee Council is doing when it comes to relying on Strasbourg standards. From well-informed sources, I know that despite administrative court, in your activity you do apply Strasbourg standards. Now, Professor, maybe you could address. Thank you very much. There were two questions asked. I'm happy that only two questions were asked to my paper, so it means that my thesis points were not too revolutionary. Nina Półtorak's question regarding that. Let me say that when it comes to the demand
w zakresie większego otwarcia postępowania skargowego na sferę stosowania prawa.
Nie jestem
zwolennikiem tego, żeby Trybunał w ogóle się tworzył, żeby zaczął
an advocate of having the
stosowania
court
prawa.
controlling application of law. That would be just the control of how the laws are made, taking into account the context of how the law is applied. And the court is afraid of this because we all know about the disputes between the Constitutional Court and the Supreme Court. And since 1997, we cannot interpret common law. So I think we have made sort of a very sort of limited model, and it's different to have a general determination or interpretation, and it's different when we have an interpretation which is not determined, and it's not set and does not determine the subject of the law. And for the applicant, what is important is how, in his case, whether this was a uniform, not uniform interpretation, how, in his case, this provision of law has been applied, which he is now challenging. So my postulate for the court to open up to the sphere of how law is applied involves such cases. So we would like the court not to be afraid to control such provisions in the context of the practice, irrespective of whether this is consistent or not consistent practice, because this is the practice that has determined the judgments affecting the applicant. As you know, the court asks the Supreme Court and the Supreme Administrative Court question whether there was a violation. So this means that he doesn't know whether it's consistent or not. The court cannot control all case law, and if the court says it's not consistent, then unfortunately the proceedings are discontinued, and the applicant is not to blame for the fact that in his specific case this interpretation is not consistent. So, in other words, in this very narrow scope, the act of establishing law would be subject to control, but taking into account the practice of how the law is applied. I would not call it the control of interpretation, it's control of the norm of law. But as to question asked by the lawyer, why the court doesn't want to control failures to act, because we have a sort of a confusion of terms, but maybe that's good that it is so. Why? The court may control what exists. It can examine what has been said, what the lawyer did. So a lawmaker did make a decision as expressed by an act of law. We can check whether this is a full or not full regulation. But if there's no political decision, if we're dealing with what the court is trying to say as failure to act on the part of the lawmaker, then the question is why the court cannot control this. If it did that, it would have to make a political decision how this regulation would look like. It would have to make a choice which is the prerogative of the lawmaker. So even though I have a negative assessment of the case law of the court, whether this is an accusation of the doctrine of law, because we are now trying to differentiate, but not very precisely, this failure to act and this neglect. But when we have a lack of pronouncement on the part of the lawmaker, then the court should not really express its position. And I think that this is what what should be, and we should have the right to debate on neglect. Because we are waiting for lunch, I will not sum up, but thank both speakers and persons who asked questions and congratulate the organizers for good choice of subject and speakers. And I have two pieces of information. First piece of information, the lunch will be served on floor 1 on the left-hand side between the staircase, and we would like to ask you back at 2:20, and bon appétit.
Słychać, słychać.
Tak, no?
Słychać.
Słychać.
Co, wyłączył się?
Teraz jest okej.
Dobra,
Nie ma
to
tych trzasków.
powiem coś. Nie, bo tu trzaski. Raz, dwa, trzy, 0, 1. Dobra.
Szanowni Państwo, serdecznie zapraszam do zajęcia miejsc.
Ladies and gentlemen, by way of housekeeping, at the request of a moderator and the speakers, the panelists, there has been a change, and now we will embark on panel 3, and panel 2 will be organized after coffee break. May I now hand over to Professor Lech Papszycki, President of the Supreme Court Criminal Chamber. Now it's operating. So I want to thank you for inviting me to participate in this conference. And I must admit that if it wasn't for the order from Madam Director Justyna Chrzanowska, I would not be here, but I recall how many courtesies the Ministry of Foreign Affairs has effected on me, so it was virtually impossible for me not to accept this invitation. Looking at the title of this seminar and the further proceedings behind the seminar, I feel more and more concerned. Dysfunctionalities of the Polish law. Well, 5 decades of my dealing with law and sitting in office for 47 years, you may be amazed, ladies, to look at such an elderly gentleman, but you, young gentlemen, you will find yourselves in my age one day, so you must look at my historical ancient presentation through the prism of the law on protection of historical monuments. So, the third panel, if we look at it and the subjects to be visited, we can say that what we are going to discuss beyond dysfunctionalities of the Polish law. But my only prosecutorial on-the-job training was 3 months of internship 47 years ago, when I was still doing pupillage in the prosecutor's office, so I would not say that I had extensive experience on the prosecutorial side. So when I look at my panelists, Prosecutor Janusz Śliwa, with whom we will be confronted very soon, and when I think about the word dysfunctionality, shivers go down my spine. I'm almost at the retirement age because the legislature decided that as of 28th of August 2016 I will be forced to retire unless I am removed from my position of a president of the court even earlier, when they decide that I've been 17 years in office. Maybe some reshuffle would be welcome, even if not at the expense of retirement. So, panel 3 is very far away of what I was doing, just my short memory of pupillage I have done, visiting various detention centers and prisons, accompanied by Justice Wierzbowski, the late Justice Wierzbowski, father of Professor Wierzbowski, and he was a penitentiary judge, which back then was quite a challenge, more of a challenge than it is nowadays. Now, without any further ado, to embark on the presentations which are the core of this panel, the first panelist will be Prosecutor Janusz Śliwa, Deputy Appellate Prosecutor in Krakow, member of the Codification Committee for Criminal Law, and we may have legitimate associations with Madam Prosecutor, so maybe from prosecutor we will find out what the amendment process is about, at least from the prosecutorial point of view. Over to you. Thank you very much, Mr. Chairman, ladies and gentlemen. Thank you for inviting me here. It is a great honor and a pleasure, especially given that I'm placed in this panel among such prominent members of the academia. I hope that this invitation to participate in this discussion speaks volumes about your conviction that there is a role to play for prosecutors in enactment of decisions of European Court of Justice, of European Court of Human Rights, excuse me. I want to thank Mr. Chairman for recalling all the Śliwa family. Małgorzata Śliwa attended classes here 25 years ago, and she was very warmly taken here, so warmly that I bear the name of Śliwa. 20 years ago I started working in the district prosecutor's office, and the jurisprudence of the Court of Human Rights was like science fiction knowledge to us, and how to apply this knowledge and how to apply convention in our day-to-day work. This was quite a vague subject. Nowadays the perspective is altogether different, and the jurisprudence and discussion and interpretation of jurisprudence is amply available. More and more often in justifications of individual decisions we read invocations to the Convention. From the practitioner's point of view, what is extremely important is what Mr. Nowak-Far mentioned in his opening remarks, namely how standards of protection evolve in time and must be adopted to the new changes. As for the question that was directed to me, well, I take it as a question about the amendments introduced into the Criminal Code in September 2013, and also this year when it comes to the Code of Criminal Procedure. And I would like to predominantly focus in my paper on the problems with implementation of new procedural provisions. If you remember correctly, the whole effort to codify criminal law started in a very dramatic diagnosis of a Polish criminal trial 2010, and three assumptions were adopted back then to indicate in what direction work should go. Is the change needed in order to remedy ill-functioning regulations or practices? Well, Yes, certainly, and the Codification Committee drafted changes which as of July the 1st became legally binding. What needed to be streamlined was the Polish criminal trial, reasonable time for resolution of cases. Well, this sounds familiar. One assumption was made here to apply amicable solutions and mediation. The second priority that was charted out by the Codification Committee was a new preventive approach to preventive measures. And here the intention was to limit prevention measures and applicability of prevention measures, but also, given that in the initial preparatory stage the scope of evidence has been limited and the adversarial procedure has been introduced accordingly for the benefit of a judicial process, the limitation of burden of evidence allows to prepare preparatory proceeding quite differently. Finally, in the assumptions that were taken back then, it was also stated that the code should be fully streamlined with the jurisprudence of the Constitutional Court in Poland and the European Court of Human Rights. In order to emphasize the importance of this situation, I would like to refer myself to the conference dedicated to the subject of excessive length of pre-trial detention. It was also attended by Madam Renata Degener and Madam Generek-Wąsek also attended, and on the basis of her research we found out what were the reasons behind excessive pre-trial detention. It was stated clearly that the Polish legal provisions allow to limit the period of detention in line with Strasbourg indications, but the practice is failing, and that's why changes were submitted to the Codification Committee. And now I would like to highlight to you a very specific situation in which we find ourselves. Those provisions of law have been in place for 3 months only, so practitioners know how they operate and why the legislature decided to roll them out in this point in time, but there is no fixed practice for the application of those provisions, so theoretically one knows how to apply pre-trial detention, but there are no practical examples and there is no solid jurisprudence, case law, and no uniform doctrine for such a newly adopted provision. So there is a question. If the reason behind the change was to upgrade our standards to the Strasbourg standard, the Strasbourg standard will stabilize jurisprudence and practice in Poland. Ladies and gentlemen, it seems to me that Mr. Chairman smiled at those changes intentionally, because if you ask about the effect of the changes, you may ask yourselves whether we are not confronted with a solution that is called lost in translation. Maybe we should dedicate our discussion to this end, whether the intentions of the Codification Committee were sufficient and whether the wording of the newly adopted provisions will really have any practical sense and practical bearing. Let me relate myself to one of the points which were made during the conference attended by Mr. Jasiński as well. What is the difference between practitioners and theoreticians in looking at various stages of the proceeding? Theoreticians see woods and practitioners see trees. So the trees that I have seen myself as a practitioner are the ones that I'm going to highlight to your attention as well. Not to exacerbate the evils and to point to new changes to be further needed, but just to show you that the interpretation in favor of the Convention helped to wrinkle out certain doubts which I have seen myself, also as a lecturer at the National School for Judiciary and Public Prosecution, who lectured on the adoption of those new provisions, and doubts were often voiced during my lectures. So, coming to the practice, the first set of provisions I would like to mention Article 156A, which is about the access to evidence material and the principle of internal availability of materials, which was mentioned in 249A and 252A of the criminal law. So what is this rule about? If we remember correctly, the person who is going to be deprived of liberty has the right to familiarize oneself with the evidence on the basis of which the prosecutor will present his case to the court. And in this respect, there was a controversy among professionals, and bearing in mind the dynamic Strasbourg standard, we may wonder whether this is preemption on the evolution of a standard. Should we go ahead of the Strasbourg Convention? So, coming back to the trees that I have spotted in the wood, what is the question about the standard which has been invoked? Is it clear? Is it obvious? Does it have? Is it clear-cut enough not to give room to any doubts? For instance, a suspect who was subject to pre-trial detention asked the prosecutor to make available evidence and files of the case again in order to justify his complaint against detention. Another case, someone who was not subject to detention but who decided to appeal against the decision of the court of the first instance, and then the public prosecutor asked the court to reverse the decision and to deprive the person liberty. So here we have again the question of the quality of a preparatory material, which should be open internally so that all eligible persons should have access to them. And after the extinction of a period of eligibility for complaint against pre-trial detention, we have a turnaround. And here we have a situation where a suspect familiarized with himself with all the aggravating materials, and the new lawyer of defense has had no access to those materials. And strangely enough, most of my trainees in the training session that I ran spoke against making such materials available. The fewer group of them said that under Article 156 they should be made available, so this is a greater openness. Nevertheless, mind you, This is in 5A, this is an obligation, unquestionable obligation. In 5, we have recognition, discretion. So we have premises on the basis of which access to materials can be limited, and there's also a time limit. And if also the deadlines for appeal to the court have been changed, well, time is running, and with open deadlines for submission of all complaints, this may be a problem. I want to state clearly that, in my view, all those components, even if they are not literally to be derived from the provisions of law, but in the sense of a convention, they can be interpreted in such a way so that the people who applied for access to material should be granted such an access. Effectiveness of the right to defend oneself and the real availability of remedy against decision on deprivation of liberty. In the second case, this was the effort to reverse the decision in favor of the suspect, and finally a new lawyer of defense. In all cases, access to materials is a must, and availability of evidence materials is absolutely essential. Also, for the application for repealing of precautionary measure, and here the difference of knowledge of the incoming lawyer and defense lawyer is very much significant. So I hope that after some time, pro-convention interpretation of the new provisions will be really taking root, and prosecutors will be persuaded about the merits of the new solutions. And what about other remedies which are less painful than detention, but maybe also irreversible and unpalatable enough? To quote Michał Kurowski, who wrote a paper for the students from the Public Prosecution School on preliminary proceedings, well, focusing on SK 13 May 2014, and in the context of 156.5, access to files and to materials was discussed for people under police surveillance. And at present, in light of the newly adopted code, it should be really presumed that such materials would be generally made available. Nevertheless, I share a diagnosis of the author of a situation where making materials available will be an accustomed practice, also if someone was subject to some precautionary measure like the detention. And if we rely on the jurisprudence of the Court of Human Rights, this is going to be even more beneficial to prosecutors, because if we want to have access to evidence material in order to launch the arrest warrant or any other operation, it should be only beneficial to us to have access to such materials. So it is obvious for me, and it was obvious for most of us students, that if on behalf of a suspect the defense lawyer turned up to speak to us, he or she should have access to evidence material, and the basic answer would be not immediately. Such a person, a defense lawyer, will have access to evidence material, but the convention and its jurisprudence doesn't speak about the potential deprivation of liberty, but real, actual deprivation of liberty. So once the suspect has been detained, defense lawyer will have access to materials. Not that I'm advocating ban on accessing materials, no, because equality of parties, etc. are very important, but this is very much discretional, and such an application to see the materials may be positively taken depending on the merits of a case. Now, effectiveness of preventive measures 288.2 came under heavy critique. This was under discussion today as well, and briefly to refer myself to this point, the very amendment that has been introduced says that imposition of the precautionary measure may be well justified by the potentially severe penalty to be given in the court decision. And how do we refer this principle to the principle of subsidiarity that has been mentioned also today? And what is very important is that the principle of subsidiarity in this particular sense is the description of a legal basis for imposition of pre-trial detention, and it doesn't apply to the normative sense, because in the normative sense the national norm is sufficient to decide on pre-trial detention. So there is no need to quote Article 258a, because the whole burden of proof has been moved to the justification. For instance, we must show what kind of threats will arise for the court proceeding if the suspect remains scot-free and is not in detention center. So in this particular case, this refers to potentially heavy penalty. 258.4 Strasbourg rulings observers will know how to read out and interpret this new provision, what kind of penalties should be subject to detention before trial. Last year in Kraków there was a complaint against imposition of pre-trial detention, and the court, examining the complaint, decided that detention was justified, but since another suspect was caught in the meantime, whose free status might lead into some disorder and distortion of a court trial, 258 was invoked again, and changing circumstances were taken into account, so the first suspect was set free. I understand that my time is up, so very briefly, my second point, in a nutshell, very concisely. One speaks that adversarial principle is now taking prevalence in Poland, and those amicable models have also their role to play, because certain cases may end up quickly given the emergence of a new institution, 299a of the Polish Criminal Code, clause 3, when we speak that there is an obligatory effort to start amicable proceeding or to dismiss the case. Well, criminal purposes and objects belong to the court competence, so any decisions before the process finds itself in the court, before the case lands in court, is a kind of a parajudicial decision. So very briefly, 3351, 3352, and distinction between two courses of procedures. In one case, there is the obligation to provide explanation, and that's why there is no reason why we should not go for consensual completion of a case if the suspect pleads guilty and is ready to use such a solution. Otherwise, we may come to a solution where the agreement between the prosecutor and suspect will be seen as something vulnerable and questionable. So the use of explanations of the culprit offered by the person who pled guilty and wants to voluntarily subordinate oneself to penalty, well, it presumes the need to run consultations with the injured, with the wronged party, and how explanations should be offered. So certain informal initial agreement will need to be reached between the two parties, including the wronged party. And at this stage, the suspect may offer no explanations at all and may not plead guilty, but what is important, if we want to apply paragraph 2, is that he doesn't make any statements to evidence that would be contrary to the prosecutor's application. Otherwise, the case will be landed in the court again, and there will be a limited accusation filed. I am really trying to hurry up, Mr. Chairman. Just the last point about 279 clause 3, about the arrest warrant and the deadline for detention. The court, after speaks about 70 hours from the wrongdoing, and in Poland, as we know, the conditions for bringing before the court of a suspect when there is this presumption of 70 hours, the provision says that one should be immediately presented to the court, but the real-life practice is altogether different. So in conclusion, I would like to invite you to monitor the practice of administration of justice in those areas where the changes suggested by the Codification Committee and adopted by the legislator in their justification invoke Strasbourg standards, because we must really look into the practice and make sure that it takes root in Poland. Finally, the shortest digression from me, Mr. Chairman. In preparing myself to this paper, I had the pleasure of reading the paper edited by Jan Owsiński about the standards of human rights protection, and Piotr Turek suggested the following reflection that I want to share with you, which is maybe wishful thinking, or maybe this is like an introductory indication that there is a vault or a safe which has never been opened here. But if there is a heirloom in this safe, one thing I should mention, I would like to live long enough to make sure, to see that fair trial involves also the positive obligation to the existence and operation of independent and fully objective prosecutor's office, both for its accusatorial functions but also as guardians of rule of law. I hope that step by step we'll be able to amend the situation, so that's why I'm mentioning this before you, ladies and gentlemen. The role of jurisprudence from Strasbourg has been growing year in, year out, and has a great impact on the jurisprudence in Poland. So let us hope that also my wishes will be granted and appropriate systemic solutions will be adopted, which is needed. That's why consensual settlement of dispute is admissible where prosecutorial independence is the guardian of such an arrangement. No matter how courts proceed with the applications for voluntary submission to penalty, but no matter what kind of penalties will be awarded as fair and just penalties, they will be always in agreement with defense lawyers and prosecutors. So please remember about it and speak in favor of independent prosecutor's office, because only independent prosecutors will be guardians of rule of law. You sometimes tend to forget about it. And we also have this function of guardians of law-abiding state. If we are granted independence, I can assure you that we will be more responsive to any instances of violation of law, and also in line with the spirit of the jurisprudence from Strasbourg, and this will be all the more needed given that the prosecutor will need to resist pressures of the people who are not concerned with human rights protection. Thank you.
Dziękuję bardzo. Na razie bez komentarza, ale ponieważ pan prokurator posłużył się określeniem wierzę, no to przypomnę, błogosławieni ci, którzy nie widzieli, a uwierzyli. W takim razie proszę pana profesora prawa Lepińskiego. Uruchamiam kolejne 20 minut. Jest 10 po godzinie 3. Czyli proszę o tę wzorową syntetyczność. A w razie czego przypomnę się. Proszę bardzo.
Własny miernik czasu, ale zawodny niestety, jak wiem z praktyki. Szanowny panie przewodniczący.
Ladies and gentlemen, first of all, I would like to thank organizers for inviting me to this conference. It's a great pleasure and honor for me to speak, and also a bit of a problem because the subject, amendment of legal codification and dysfunctions of law and practice, is manipulating, because it just identifies the dysfunctions of law and practice. So what Wątr wanted to defend, a thesis that were asked for us to defend here at this conference. I understand that most of you're not specialists in criminal law, and perhaps there are people here who are not very much interested in criminal law, which is probably not very likely, but still. So I'll try to present a perspective that perhaps will not go into the nitty-gritty of criminal law, especially when it comes to amendments that Prosecutor Śliwa mentioned before me. So I am afraid I am the second speaker. The prosecutor always comes first. What I will talk about will be said in a perspective that, in the European perspective, may be important. And also I would like to tell you that it is not true that when we reform criminal law, that we fail to see this perspective. we do see it. The subject of my speech, dysfunctions, that is an inability to fulfill a function. The functions of the law and practice, that is their inadequacy. Criminal law obviously provides a larger subject for debate and discussion when it comes to courts, both national courts and international courts, and specifically the Strasbourg Court. However, when we speak about these dysfunctions, we first have to differentiate between situation of dysfunction and intentional ineffectiveness. I understand that intentional ineffectiveness of law, which is a well-known phenomenon and is justly criticized, will not be the subject of my address, although you can also look at law from this perspective. If law is a legal instrument that is to shape social relations, then it is also an expression of the way we represent and are represented. Professor Galicki beautifully unveiled this, that why 79 is not sufficiently extensive as you would expect. Unintentional ineffectiveness is not the subject of my paper. I would like to talk about dysfunction and say how and if we can identify problems. Professor Balcerzak said that we can, and I agree with him, that the problems that were identified 10 years ago and still are identified today are classic. Author said that our law, like a spider's web, will let through a bumblebee but will not let through a small fly. This is a bittersweet expression expressed by someone in the 17th century, and it's still topical today if you look at today's press and our media. It's not what it should be. The most important thing, ladies and gentlemen, are the dysfunctions that we see ourselves and that we experience ourselves. If we have contact with practice, if we're lawyers representing our clients, that these dysfunctions are very painful, and the same can be said about judges and prosecutors. So I think there's a bit of a subjectivism here. When we do our selections, we have certain set canons of subjects with respect to which we agree that these are dysfunctional structures, but the selection of dysfunctional subjects really leads us to a discussion that tries to reconstruct the problem again and again. We come back to the same conclusion. What is the problem? Maybe this is easier, but still, I think that we should go much further than that, and we should start discussing from the end. That's discussing the state where the problems are reconstructed, and proceed to a state how we can affect, how these problems affect the law. When work has started and continues on the newest changes of criminal law, there were 4 especially important perspectives when it comes to directions of changes. First of all, the rationality and effectiveness of these amendments, but there were also 2 other strong levels, the constitutional and so-called Strasbourg level. This is a sort of court level which limited many solutions in criminal law because of the need to understand that individual rights and community rights are always in a conflict. We try to resolve the conflict in order to maintain the social discourse that we still can bring about an agreement. I think this is a universal problem, not only a problem of how to amend criminal law. for sure, most of the institutions that were designed to reflect and take into account the Strasbourg perspective. This very strong imprint of a hoof, maybe not hoof, but the hand of Strasbourg is very visible in all these institutions. Prosecutor Sliwa mentioned them in connection with pretrial detention and access to case files. This is nothing less than the implementation of Strasbourg judgment and the Constitutional Court judgments. Now I have to address the chairman. What time did I start? I think, is my time up? I have 7 minutes, okay. I agreed that I'll have my watch, but I forgot to see the time I started. So, ladies and gentlemen, I'm deeply convinced that there are permanent and temporary dysfunctions when it comes to criminal law and all fields of law. I will not talk about permanent dysfunctions, and they are irrespective of the current shape of law, and they are not the subject of this conference. I'll talk about those who are very painful. First, do not be cross with me if I mention this permanent dysfunction, which is the cause of all identified dysfunctions, is the low legal and social culture of our society, and this translates into all stages of law, of drafting, implementing and executing law. We often think about this at the very end, but the enforcement of law, bad enforcement of law leads to the lack of implementation of law and leads us to conclude that we'll deal with it anyway. But talking about enforcement of administrative fees, adjudicated damages in the narrow sense, but also in the wide sense, the ineffective allocation of resources. Look at the problem of experts, court experts. It was mentioned 500-600 times, million times. That's nothing, because we said that the appointment of experts extends the length of proceedings. These are small elements of the whole process, which means that the whole system works ineffectively, and the consequence of conflict of interest, that a dispute is a dispute of adversarial parties. If we do not take that into account, that all the answers of the dysfunctionality will just lead us to nowhere. And I think also the Strasbourg Tribunal should also take that more into account. Now, when it comes to changeable dysfunction of criminal process law of procedure, which originate from procedural law in the short-term perspective. If we look at them, they are the result of transformation, not so much systemic transformation, but the way we think about law, how we think about law. That law that should be effective and law that should extend elements of security and guarantees. I'm not saying which is more important, whether effectiveness or guarantees, but if we look at the way our law evolves, that we will see that there were shortages of guarantees of law at the level of drafting of law and execution of law. But they do come from how we have been thinking about effectiveness as ultima ratio and the approach to guarantee. And the second element, that is different ways and means of developing the criminal process. And I'll devote the last 2 minutes of my presentation to the discussion we had about the constitutional complaint. whether we should develop the constitutional complaint so that the applicant can achieve his or her objective. Now, is it really the aim? Or should the aim be that the legal system functions properly? When it comes to the constitutional complaint, 50 years of the functioning in the court and work with the constitutional court gives me a rather different point of view from the one that we had in discussion. I understand the postulates discussed by Professor Frączak-Wątor that the court should have the ability to set aside decisions, that should be able to examine cases outside the scope of the complaint. But each time we're talking about amendment of the Constitution, and in such case we depart from individual complaint and go towards an abstract complaint. I'm not saying that because I do not identify myself with this perspective. I'm saying this to drive the point that the criminal process is exactly the same. The thing for the right interest of the person to be subject to protection, no matter the form and the instruments that should be used. However, I do not agree with the fact that the result of a constitutional complaint should be setting aside a judgment. Although this is a beautiful perspective, but in our legal culture and in our social culture, this would mean that despite what we said, the constitutional complaint would be another instance, would be the 5th, 7th, or 10th instance of proceedings, and constitutional complaints would be flowing in. Not 600-700 a year, but 76,000 this year and more next year, and everybody would file such a constitutional complaint. So we have to ask ourselves, what is the purpose of the constitutional complaint? I'm afraid that today it's just cut out to the possibilities offered by the state if the average length of examination of constitutional complaint is more than 6 months, as it was said today. Sometimes it's longer. Then it all means that perhaps this legal instrument should not be a general instrument. 3 years ago, in the same group, I also raised the question, how can the constitutional complaint be a filter with respect to the Strasbourg case law? Please look into the documents that were published after the conference, and I feel that it has been no follow-up to that discussion. Now, Professor, I'm not looking at you, but still I think I have a moment left. We know what happens. 4 minutes. So the biggest dysfunctions that have been reconstructed, identified, we try to answer. And I'm talking about those that are seen in the perspective of our conference subject, the European perspective. So excessive length of proceeding as a systemic feature of the process for sure is one of them, but not only in the worst consequence, that every excessive length of proceedings leads to excessive length of the application of measures like coercive measures. We are slowly healing from that, but the baggage we still carry, and we are still identified as those who have this feature, even though the latest data do not confirm this thesis. This is only the result of the structural excessive length of proceedings. The excessive length of proceedings is also due to the fact that pre-trial and trial proceedings in a way are copies of each other, and we have not only 2 instances, but it's sequentially 2-instance process. So far it's been so that the second instance usually set aside the judgment and send it back to the lower instance court, and then it went back to the Supreme Court, and it went back to the first or second instance court. but this has been happening for long years, and this injured party has not been able to receive redress for what happened. Pre-trial was imposed on someone who has been not tried. So this is all the effect of the systemic excessive length of proceedings that this reform that we're now witnessing is trying to redress. When it comes to the first and second element, when it comes to the remodeling of the appellate proceedings, and also with respect to pre-trial proceedings, as mentioned by Prosecutor Śliwa. I would like to also mention the right to defense and legal aid, extended beyond the Strasbourg standard. We are much above the European standard. Article 81 that everybody criticizes us, why we have given so much, or why so little in pre-trial and preparatory proceedings. That I don't know. The same is true about the costs of proceedings. Moving from page 3 to page 11, I would like to address the issue of extending the scope of instruction, which in the perspective of the implementation of Strasbourg standards is a very important element that changes the criminal process. The instructions have been extended to such an extent that if bodies were able to aptly use them in a way that people would understand, which many people appeal for, then I think that would be very good. But again, I would like to draw your attention to a simple fact. The obligation to hand any judgment, every judgment, a evident thing that was so strongly fought for in this reform, which allows us to close many problems when it comes to compatibility with different standards and trial in absentia and other process institutions. A defender for the person who was arrested. This was part of the directive of the European Council. We have time to implement that until 2016. I would like to let you know that there were proposals to implement this directive. Were drafted, decision decided not to implement it, but our codification committee have drafted them, and authors of these drafts are here with us, and they realize the standards that we need to reach. And to conclude, let me just say that with respect to criminal law and consensual, refer to Ktogoshvili, Ktogoniga's judgment last April. The European Court said that when it comes to process agreements where we have no fully adversarial process in a trial that leads to a sentence, but they're just a sort of agreement between the parties, and the court examines and issues a ruling, and in this respect the court in Europe said two things are admissible: the relinquishment of the accused person of the right to examine the merits of the case if he agrees to consensual things, and the thing is relinquishment of appeal of such a decision. And this standard was introduced to all consensual procedures, the scope and quantity of which was introduced in this amendment. Ladies and gentlemen, I cannot really now address many reconstructed dysfunctions of criminal law at this moment, especially when it comes to criminal process law, not to exhaust your patience, but also because it's more to show you the different perspectives of how to look at the same thing from different points of view, the clash between rights and guarantees, with the understanding that the guarantees of individuals are also guarantees that affect the whole society, and some moment in time we have to realize that soon the bigger problem was not to develop individual guarantees or add additional instruments that are to allow the operation of earlier instruments, but rather to make law more effective and efficient. I'm confident that introduction of additional institutions so as to enable the functioning of earlier institutions is not a remedy, but is a sort of a band-aid. And then we'll have to add another band-aid and another band-aid on that wound. So I think that permanent dysfunctions are a problem, not the changing dysfunctions, because the changing dysfunctions, as the name implies, will change.
Dziękuję bardzo, panie profesorze. Jednak trochę przewlekłości było.
Thank you very much, Professor. There was some lengthiness to be traced, but in relation to this 8 bands that you have mentioning, I'm not an expert in laying out streets, but I know that a well-placed patch serves a road much longer than even expected. Another 20 minutes, Dr. Piotr Kładoczny. Distinguished Chair, ladies and gentlemen, I'm quite stressed out because the swap of the panel between panel 3 and panel 2 made my situation all the more awkward, because I hope to be the last panelist and I'm not. So please bear with me. I'm not speaking about dysfunctionalities and dysfunctions, but I will speak about remedies that are made available to inmates when they serve their sentence and also after the end of the sentence. So an inmate is a human being, a citizen, so I'm not going to speak about ordinary safeguards that are made available to an inmate, but let me mention certain additional entitlements that are available to inmates. Also, looking at the operations of the Helsinki Foundation for Human Rights, I also work in the Clinic of Criminal Law, and the problem is that we should focus our attention on 2 things only: the right to file a complaint and the operations of penitentiary courts and penitentiary judges. I'll try to make it brief. The first thing is complaints. Constitution provides for the right to complain, Article 63. We also Code of Administrative Procedure 271, and we have Criminal Code Article 272. And when I speak to prison wardens, they really complain that inmates abuse of the their right to file a complaint. And in 2013, altogether, the total number of complaints and suggestions was 131,000, and the problem consists therein that inmates say that their complaints are of no avail at all, and that the percentage of positively taken complaints is about 0.7%. So the question is whether our inmates complain because they are bored and they have nothing to do with their time, and this is one of the suggestions, or is it that complaints are not examined properly, or is it so that the perspective of some people is entirely different than the perspective of other people? Maybe the truth is somewhere in between those extremities. Nevertheless, it seems to me that 0.7% of complaints that were really accepted, or 1.41 in the regional penitentiary court, well, all the more no matter how we take it, this percentage is very unsatisfactory. So this is the permanent dysfunctionality that is with us to stay, as Professor Bieliński put it. So my other concept is maybe not that revolutionary, but the more inmates we have, the more complaints we have. The more convicts we have, the more convicted we have, the more complaints we have. And what has been provided for in the amendment of the criminal code in order to reduce the numbers of inmates, well, maybe they will help to reduce both inmates and complaints in their numbers. So what to do? What else to do? We have Article 6 of the criminal executive law. And 2 days ago, an ombudsman applied to the Constitutional Court to check constitutionality of those provisions because they limit the right to file a complaint, and the way I see it, that this was an idea to abstain from examining certain complaints which are either written in a dirty language or in a jargon or on the basis of the same legal premises that were quoted before, or are simply not eligible to be examined. On the other hand, more than 8% of complaints were not examined on those grounds, so far penitentiary courts were not really abusing this path. Nevertheless, if the percentage of complaints which were dismissed unexamined was 8%, maybe this tendency will grow in the future, and this has been preemptively diagnosed by the Ombudsman. Let's see what the Constitutional Court will say, because limiting the right to file a complaint may be unconstitutional. And also the use of jargon, of dirty language, vulgar language, well, produces certain doubts. Does the language make complaint groundless? Of course, we do not have to examine a complaint that is written in a way that is unacceptable to us. And in the letter of inmate Gertner to the family, the inmate wrote that the principle of the prison was always under influence, and the letter was intercepted, was deemed to be offensive to the functionaries of the prison. The inmate was additionally punished, disciplinary punished. He applied immediately to the court, and he also said that his letters should not have been read and scrutinized if they were private, not meant for the public. And the penitentiary court sustained the same decision, and the Constitutional Court dismissed the complaint as ineligible. That's why Patriciusz Gerter filed a complaint and to the European Court of Human Rights, and a unilateral declaration was adopted with a value of 1,500 euro of indemnity. So, if I remember correctly, so this is one of the cases But if a complaint is well justified, like in Mr. Gärtner's case, the language and lack of documentation should not be treated as a ground to dismiss the case. Also, we have foreigners in Poland who do not speak Polish, and using the language they have learned here, they may involuntarily fall into jargon or into dirty language or offensive language. So it seems to me that the application from the Civil Rights Ombudsman is more than justified. Although in this room we have well-qualified people who will decide about the destiny of this application. But coming to the mainstream of my presentation, inmates have been and will always be in prisons, and in European Observatory of Prisons a kind of a soft law was devised, as Professor Balcerzak mentioned it. Would it not be better to reduce the number of complaints, because dysfunctionalities, some of them may be permanent, but some of them may be limited in a new way. In the first place, there was an idea which didn't take root everywhere, so it is taken experimentally. Collective evaluation of detention conditions. According to the Council of Europe and the European Penitentiary Observatory, inmates have the right to discuss the general conditions of serving the sentence of depriving liberty and may complain about various facets. They do complain about everything, but their complaints about living conditions like accommodation, like access to medical services, etc. Well, these are very frequent stop complaints. So if so, one can imagine that it is easier to sort things out if there are clear-cut communications channels. And in Italy, by way of an experiment, Article 27 provides that recreation, sports and culture event will be organized by the committee on which both wardens, rehab experts and inmates will be sitting. Inmates will stay in this committee for no longer than 4 months, but all in all, such mixed committees may work out certain channels of communication in order to minimize or reduce substantially the number of complaints that would be filed to penitentiary courts. Penitentiary councils, for instance, in the United Kingdom and in Wales, in England and Wales were launched, and in Albany the number of complaints fell by 37%, more than 1/3. Cooperation of inmates with penitentiary personnel and rehabilitation experts, like in penitentiary councils, which also included ex-inmates, NGOs, psychologists, etc. And in Camp Hin, Council decided to reopen university, order the list, set into order the list of availability of visiting rooms for family visitors, re-equipment of a playground for children visiting their parents, And as you can see, many things might have been sorted out and were sorted out without writing to the Helsinki Foundation. So this is an instance of good practices which needed to be worked out and made available in moderation, but helped to reduce the level of dissatisfaction. Of course, some inmates will complain not because there is a reason, but they are simply naughty and they like complaining, but there are some reasons as well. And if some of inmates came to agreement with penitentiary services and found out about the possibilities and limitations of functioning of penitentiary services, the volume of complaints might have been lower, and we would not so much need to focus on complaints, but to be able to jointly think about the problems of penitentiary institutions at large. And the second case, and I have a few minutes left to me, no supervision of penitentiary judges. I do apologize all of those negatively affected, because many of you supervise penitentiary judges in an excellent way. But as a visiting judge in prisons, I heard myself from penitentiary staff that there is a prison where a penitentiary judge never decides on the conditional earlier completion of sentence. And I didn't ask inmates if it was really the case, because I heard it directly from the penitentiary services. So no matter what happened, no one would be released conditionally. So this is one of the signal I received. Tomasz Kalisz, writing about judicial penitentiary supervision, and wrote about it more extensively. And my point is not so much to say that all penitentiary judges do not work correctly, but what to do to improve the situation. There are foreign practices, maybe not so good, but there is separated penitentiary justice or interdisciplinary councils where judges, rehab experts and curators sit together, and they can together try to decide on such conditional release. Of course, there are excellent penitentiary judges in Poland as well. They are the ones who attend those conferences, and they are very nice, decent professionals. But all we know, summarizing on the results presented in the paper by Professor Kalisz, we can say that most of penitentiary judges said that they are under sufficient supervision, and that the usefulness of official supervision over them is questionable. So the differences between the declared opinions and the post-visit protocols the judges filled out are substantial, and the quality and final reports are very general and sometimes are limited to one sentence of evaluation of a prison without arguments. Half of them did not present any recommendations or remedial actions to be completed after in-site visits. and some of them mentioned them only very generally without checking up their implementation. So without being too critical, I want to suggest how to streamline the supervision of the penitentiary judges. On many occasions has Strasbourg decided that if something is to be subject to court supervision, it should be under decent and reliable supervision. So is it the case when penitentiary centers are evaluated? Well, let me quote from the ruling that made me really irritated. I'm after lunch, so we have digested our lunch a bit. There was a gentleman who was convicted for rape, so not a minor offense. He served 3 years in pre-trial detention. We know what the situation was, and then was sentenced for 6 years of deprivation of liberty. Then he was released for 7 years, so he had various deferrals, etc. And for 7 years he was asking for conditional release because he served half of his sentence and he believed himself to be eligible. And on the 6th occasion, when he was refused, the court put it as follows, one off. From the last refusal on your request on conditional release, the situation of the convict has not changed. After repealing the pre-trial detention, the convict completed secondary school, completed vocational training, is paying for his parents, and is community active, supports his elderly parents, etc. But the court is against. And in this case, the convict has served only one half of the sentence, which is not fair, in line with the sense of justice, because he was temporarily detained and therefore was not subject to due rehabilitation. So, ladies and gentlemen, needless to say, one cannot blame someone for keeping him 3 years in pre-trial detention, and we cannot really say that this was his fault. On the other hand, and to end on an optimistic note, in the last 30 seconds that are left to me, there are cases, and there is case law which is probably founded on Strasbourg and English cases, the right to hope, to make conditional releases available in positive cases. So when we think that an inmate is likely to be positively streamlined in the social life, the judge should decide in the favor of the applicant who seeks conditional release. Maybe there is a new sentiment among judges to change something, but maybe legislation should be changed as well, because it has not had taken place in the recent amendment of the criminal code. So maybe it should be obligatory, and maybe we could decide on conditional release and termination of punishment unless it is proven that it would not be justified. Otherwise, we will be far away from the proper standards of right examination of cases. This is all from me. Thank you. Thank you very much. Right to hope. Well, Roman law, this is what I recall. Emptio spei, emptio re sperate. But it was such a long time ago. So from dysfunctions, we spoke amply about the dysfunctions with great persuasion too. And in line with our program, we will have 20 minutes time left for discussion while listening again about the importance of this amendment, the grant amendment that may not be capitalized always. Well, dysfunctionality of law also applies to dysfunctionality of new amendments. The provision of Article 167. Well, what has legislator had in mind providing for in Article 167 and also smaller dysfunctionalities? Quite recently, I completed my paper to the 7th volume on the system of criminal code about precautionary measures, especially for people with psychiatric problems and conditions. And Article 93A to G lists a very reasonable array of conditions. Unfortunately, the legislator forgot that there is a code of criminal procedure in place which is also subject to amendment. In Article 93, there was an old norm about the obligation to hear the party and to impose safeguards, psychiatric safeguards if necessary. So in Article 354A on the application of precautionary measures before the main trial as a result of a session or in-camera session of the court, well, it is mentioned in executive part of the law, and the members of the codification committee forget about it and say that this principle in applying precautionary measures is binding if there is a main principle trial. Yes, that is right, but the legislator forgot about 354, and out of the second dysfunctionality you could disentangle yourself fairly easily, but as for the first dysfunctionality, interpretation on 167, well, this is a challenge. There will be tens of interpretations between district courts and regional courts, and then, without any assistance of a Supreme Court of Justice, we will raise whole generations of lawyers. So now 4 o'clock is striking. We have 20 minutes for brief questions, brief comments, and brief answers in order to make everyone, to grant everyone the availability to ask questions and have your queries explained. Over to you, madam. Well, thank you very much for this very interesting session. I would like to add one more comment, associating myself with the pessimistic tone of Dr. Składoczny's paper. There was no reference whatsoever to Resolution 275 of the Parliamentary Assembly of the Council of Europe, the Committee for Human Rights and European Affairs, about the enforcement of the decisions of the court. In the report, we read that there is a vast problem in the Council of Europe, 11,000 pending verdicts which have never been executed. In the second place, red card, penalty card for Poland, Bulgaria, Romania, Turkey, Russia, Ukraine, Italy, the countries where those rulings are not enforced at all, and there have been pending structural problems in the pipeline for 5 years. And additionally, we have a review of countries where excessive length of proceedings, conditions in penitentiary centers, and abuse of pre-trial detention tend to be a common practice, and also access to not so much to justice but to medical services. Well, this is well in line with letters that we receive every day as the Office of the Council of Europe, because we also obtain and receive complaints. And these are indeed our problems. And the following question: what kind of avail are we going to make of this report and the resolution? Is it going to be business as usual, something that should only preoccupy the Parliamentary Assembly of the Council of Europe, or should we really take into account the vast effort of Madam Chrzanowska's and the whole team in the MFA, who have been working with full passion to enforce the rulings of European Court? So I would like to invite and call on everyone to have this report translated, resolution translated, sent out to prosecutors and penitentiary judges. Thank you. Thank you very much. Next point, please. I will just indicate you by pointing out, because I don't know you. Chair, I intercepted the mic and I have one question and one comment. I was following the previous debate with somewhat anxiety, and now I have a question to Prosecutor Mr. Śliwa. Would you please say yes or no, and nothing less? Because maybe I misunderstood you, but this was the justification for draft amendment of the Code of Criminal Procedure. A very short quotation. What the applicant wrote and what you, as a member of Codification Committee, must take notice of the basis in 258A. Is it a self-existent or self-evident basis or not? Because this is not to employ the measure because of the possibility of severe punishment of the defendant, or should it be in preemption of the punishment to be awarded? And here, Professor Biliński, who is the best criminal lawyer among constitutionalists and best constitutionalist among criminal lawyers, the constitutional complaint, the first one, was filed in December 1997, in the third month of Constitution, about unconstitutionality of pre-trial detention, which was as it used to be before in the old code. In the summer, the court first opened this case and then dismissed the case, and it stated that once the new code has entered into force, the whole complaint is groundless, and
A zatem to tymczasowe
This
aresztowanie było w istocie
pre-trial
wykonywane
detention was historically the first constitutional complaint, and I had the honor of representing this case. And I wrote a paper about it. The late professor, or the absent Professor Garlicki commented this, that he, as a judge of a constitutional court, cannot refer himself to unconstitutionality of those provisions, but he also said the constitutional solutions are somehow parallel to the Constitution. And so, Mr. Prosecutor, do you think that this is a basis in itself, a self-existing basis or not? And quite recently, when there was a consensual decision reached between the prosecutor and defense lawyer, the judge agreed to it, but very unwillingly and ironically. Well, back when the first complaint was lodged, I was very frustrated. I said that this was like the constitutional wailing of the applicant, but I don't say this was a systemic problem, the systemic problem of regulation of liberties and rights. No. If an institution has certain problems in it, this problem may be solved out for the public benefit, like with Prometheus. And the claimant or the applicant represents himself, but anyone who is in a similar legal situation may potentially benefit from the positive resolution. So, as Madam Florczak-Wątło mentioned in her paper, lack of harmonization between more far-reaching results and the macro result is obvious. I don't know how to reinforce the interests of the applicant, but my one suggestion on the margin: do you think that the interest of applicant is absolutely superseding other interests or not? Ladies and gentlemen, while listening to many of you, maybe a conventional complaint should be instituted. The Constitutional Court doesn't want to have it. Maybe there should be a special chamber, fifth chamber, if the Supreme Court or some ad hoc benches to examine conventional complaint when someone believes that his conventional standards have been not duly heard. I don't know if this is a good way. So may I maintain the question to prosecutor?
Kiedy w ciągu ostatnich tygodni słyszę propozycje kolejnej izby w sądzie.
I'm very concerned with a proposal about another chamber. Maybe this is a fashion, but now on a serious note, going back to the past when I sentenced someone to pretrial detention, then I had a simple recipe. I remembered Article 249. If you remember Article 249, then no matter what the lawmaker does, also in 258, for sure it will be implemented with high standard. But okay, the answers will come. No, the floor is yours. Piotr Turek, I'm a prosecutor. I would like to refer Piotr Turek, prosecutor. I would like to refer to Kładoczny's disturbing justifications by judges. And my question is addressed to judges present here. To what extent, in whole categories of cases, the administration of justice is exercised by judges, and to what extent by assistant judges? Because as a prosecutor, a line prosecutor, especially in execution proceedings, frequently I have dealt, maybe not as disquieting as the one mentioned here, but sometimes I deal with decisions on the grounds that do not reveal the requirement of life's experience ascribed to judges. And off the record, I would ask a judge who issued a ruling whether this is done by the judge, or the ruling was written by the judge or by the assistant, and the answers were often along the following lines, that the assistant wrote the grounds and the judge just signed his name under it. Thank you very much. I'm sure the answer will come, but I immediately thought about myself. I was 25 years old when I became assistant judge, and nobody sort of had it against me when I adjudicated on labor law issues, when there was no labor code at the time. So youth has nothing to do with it, I know. Judgments, but very, very experienced judges that may raise serious concerns. Not only judges' decisions may raise concerns. Ladies and gentlemen, Director, please take the floor. Ladies and gentlemen, I would not introduce myself. I've been welcomed very warmly because Director Machińska referred to the problems of execution of European Court judgments. I would like to suggest that because we have an exceptional guest, the representative of the Council of Europe, of the Secretariat of the Council of Europe, Zoe Crowes-Bryston, I would like her to address, if she would like to, of course, to indicate to all of us present here some of the most important problems that the Committee of Ministers of the Council of Ministers sees when it comes to the execution of the judgment of the European Court. I think this will be most valuable because it will be a perspective of the international body and look out from the outside, and I think this would be very useful to all of us if she could take the floor. I'm sure I would be willing to. I don't hear as the classic of parliamentarism of the Second Republic, and then please, the floor is yours. The guest, please take the floor. Jak się zmienia głos? Na angielsku. Będę na polski tłumaczyć. Dzień dobry. Oczywiście będę musiała mówić do Państwa po angielsku, więc nazywam się Zoe. Nazywam się Zoe Bryston-Quence, jestem szefem sekcji w Wydziale Wykonywania Wyroków Europejskiego Trybunału Praw Człowieka w Radzie Europy i razem z moim zespołem pracuję nad polskimi sprawami, oczywiście też innymi. Jeśli koledzy wspomnieli tutaj o ostatnim raporcie Zgromadzenia Parlamentarnego Rady Europy, które mówi o sprawach przeciwko Polsce, słusznie, ale jeżeli spojrzymy na szersze tło i Państwo wiedzą, że w przeszłości 3-4 lata
being satisfied that Poland has taken all the measures necessary to execute the judgments of the European Court. In fact, one of those instances was the group of cases we had concerning excessive length of pretrial detention. We called the Traska group. So I was very interested to hear your comments about this earlier. We see in the statistics that there is a big improvement in the reduction of time that people were spending in pretrial detention and the use of measures alternative to pretrial detention. Of course, pending in the list of Polish cases at the moment is a question of excessive length of criminal and civil proceedings, something that has been mentioned today, and the point has also been made by the European Court of Human Rights in the recent Rutowski judgment. This is an issue that concerns many states in the Council of Europe, and I'm sure we'll continue to work closely with Poland on this topic. Director Ciernowska asked me to highlight some other elements in the Polish list of cases which are particularly interesting. I think we have many cases concerning freedom of expression. This is Article 10. The Committee of Ministers has closed ones concerning civil judgments for freedom of expression, but where there have been criminal convictions, these cases are still being examined by the Committee of Ministers. Turning back to questions of detention, we also have the questions concerning Horych and Piechowicz, which I know are pending before your legislative bodies at the moment. This is just a brief highlight of some of the things that our Committee of Ministers has seen for Poland and will examine in the time to come. I would underline the excellent work of Justina's team in reporting to the Committee of Ministers on the measures taken by Poland to execute the judgments of the Court of Human Rights.
Of course, if someone, I'm sure there are no one here, but if there's a person here, then of course another thing, this was also said here. Now, if there are no other questions, then in order of appearance, starting with Prosecutor Janusz Śliwa, in connection with what was said and asked. Thank you very much for your question, Professor Dudek, for outlining the form of answer. This is how much I've learned, that the lawyer will say yes or it depends. This is what I've learned from today's proceedings. Now, trying to sort of subscribe to the convention and not to see any devil's questions, why there should be questions that would come from the sort of bad guy. I think in normative sense, 258, 249 article, this is a self-standing reason for applying them the way that the premises were formulated. It refers to the fact that it has to be linked to a specific type of threat for proceedings where we have pre-trial detention, so there is no blanket that only the threat of a serious penalty is the premise for applying pre-trial detention. I think that this way of reading 258 paragraph 2 was possible earlier. What is more, it found its expression in the Supreme Court's case law and for sure in Kraków, where I come from, Krakow's appellate court. But if you were to look for reasons for what was written in the grounds written by our commission, that is the Criminal Law Codification Commission, when it comes to preventive measures, that if I recall exactly, there's an excellent material prepared by Professor Kardas for a conference organized by the Codification Commission in 2010, where it gives a lecture about the dysfunctionality of 258 paragraph 2 when it comes to pretrial detention. Thank you very much, Professor. I'm not sure whether my answer satisfies you. Yes, I subscribe to what was written in the grounds. I'm convinced, Professor, that I have not submitted
Dzisiaj o tym łatwiej mówić, ale znów
It's easier for me to talk about it, but I remember a time when the accused was totally paralyzed. I was the last roach in the Polish People's Republic who operated nearby in Biała Podlaska, and for me it almost ended with disciplinary proceedings, because at the time it seemed if someone who, when he was a thief, he used a machine gun. It was an awful thing, but he was 100% paralyzed. The idea for him to be in a normal hospital is a civil hospital, because he needed to be taken care of medically, but that was amended and that was changed, and he returned to hospital in a pre-child detention hospital. Professor, the floor is yours.
Chciałem powiedzieć, że w wielkopolskim województwie też, panie
In the Wielkopolskie voivodeship, situation is similar, answering to Professor Dudek's answer about acceptance of pre-trial detention proceedings. From what I hear from prosecutors, they have been accepted. But on a serious note, this is what we wanted when we were introducing new standards for the application and extension of pre-trial detention to obligate all bodies, courts and prosecutors to demonstrate what is the gist of the matter. So this is the application of standards that we are becoming more and more familiar with, thanks to Strasbourg Court and our case law. Professor was right to ask about constitutional complaint in the context of pre-trial detention. He was modest not to mention the fact that he was instrumental in this regard. So, Professor, the best criminal law lawyer, please do not take that credit from yourself, because I don't think it was so. I remember that this work made a great impression on me, and many of the arguments that you raised are now becoming common. Now, to answer your question, I think briefly, or maybe I was misunderstood, complaint as interest in the system, yes, but in short, constitutional complaint is something more than just a representation of one's individual interest. It is, but it is also something more. Not only the subjective conviction of the applicant provides the grounds, but also the systemic context when rights or liberties were violated on the basis of a ruling, on the basis of a legal provision, the constitutionality of which we are challenging. That is the fact. Now, just to add one more sentence to that, and Professor said I could, so with not to leave an impression that suggestions that we heard earlier about changing constitutional complaint, I'm just rejecting ad limina. Nothing inspires more than drive to change something, and there's something that I like there, and I would like to say this to Professor Florczak-Wątor, the possibility to suspend the execution of judgment, to have the possibility after judgment is passed stating unconstitutionality when we're doing with deferral of the implementation of such a judgment, and some judges say yes, some say no, depending on their practice. Maybe this norm should be made more precise in this regard. I like this idea very much, but I think that if the court were to set aside the judgments of common courts, not to mention Supreme Courts, then again we would realize that in our system we should have either one court that covers the competences of a constitutional court and supervision over courts of law, or we should stick to the division of competences between them, which is sometimes very painful. If I may, let me say something about which I have no competence to speak, referred to by Professor, about the failure to implement judgments. I think for sure they should be disseminated, but the problem lies with politicians. Politicians resist that, and only if we put pressure on the politicians and our community put pressure on politicians, they will do that. Today, as you know very well, financial reasons, budgetary reasons prevail. In our Commission's work, we have come across situations whereby we wanted to introduce many decisions to implement Strasbourg decisions. They were blocked by the Minister of Finance, saying that there is no money to do that. If we want to introduce the changes, then the reform will be blocked. I think Professor Hermeliński left, but Professor Wyszykowski is here with us. I think he will agree that the implementation of Strasbourg judgments is a matter that sometimes is seen in the context of what we can or cannot afford. But I believe that we should pursue this path. This is just my personal opinion, but since I'm here, that I guess you will just take this as such. Professor said that certain things seem to be impossible in terms of control of judgments. I think your intuition is right, and this is so. But we don't know the future. Ladies and gentlemen, it would be ideal, and you were complementing each other, so I will compliment myself that I have moderated the session in a model way. I'm sorry. Yes, still, we have you ad vocem about myself, about arrest, pretrial detention. I don't think the situation is not as good as you say. Maybe in Małopolska, Wielkopolska, but in the Helsinki Foundation, I have arrests 6-7 years long, mostly motivated by Article 258, paragraph 2. I have them on my desk, and it's not as good as you say. Professor or Chairman said that it was bad in the past. Jan Erb, he was totally paralyzed, and he was arrested, and compromise was reached. So paralyzed are also being arrested and put in pretrial detention. I think in this microclimate, I'm sure there are cases that do not come from Wielkopolska, Małopolska. Thank you very much. Professor Biliński, with him I always agree too. Now the opinion about why, it will be short. Professor Mosińska for many years is running courses for judges in which I participated have been participating from 90-something, I as a lawyer, and a group of judges from my city comes to those trainings, and a judge congratulates me. It was Kurłowicz, 2000, Article 220. He congratulates me and says, "Oh, well, I would like sometimes you to listen to us." And the judge just looks at me. But you know, I think I was right anyway. This is an answer. It's not about means. Administrators that they lack money. I don't know what it's all about. I think Professor Biliński will change his diagnosis, and I will find out once he does that. Thank you very much. Ladies and gentlemen, then with thanks and also with encouragement for next year, when I retire as Supreme Court judge. I was 41 when I became a Supreme Court judge. So I look at you. There are many candidates for next year. There will be several retired judges next year. So I encourage all of you to apply. Yes. Yes, there will be one chamber, there will be other chambers. If we live long enough, then we shall see. Thank you very much. And now organizers would like to say something. I would like to invite all of you for a coffee break and then invite you to our last panel.
Teraz znowu włączyłaś.
trzecim myślę, że będzie dla Państwa niezwykle interesującym, ponieważ naszymi panelistami tym razem są przede wszystkim osoby, które stosują...
Ladies and gentlemen, welcome on the last panel. The panelists in the last panel will be the people, practitioners, who either use recourse or apply for recourse as justices and lawyers. So we will listen Dr. Przemysław Feliga, justice from the Regional Court in Warsaw, who will speak about the recourse implementation of decisions of European Court of Human Rights. Then we will have Bogdana Słupska-Uczkiewicz, who will speak about the application for cassation as an effective remedy. She is a very well-experienced practitioner. And then Grzegorz Borkowski, justice in the District Court and member of the National Judiciary Council, will speak about complaint to decide incompatibility with law of a verdict that has been reached. And then Nina Półtorak, who is both practitioner and theoretician, will tell us about the jurisprudence of the administrative court and decisions of administrative courts, and she will speak about legal remedies such as reopening of proceedings or stating the incompatibility. Since our panel is the last one and we are much behind the time, we will limit ourselves in our statement, but I hope that we will stick to the substance of the same. So without further ado, over to you, Dr. Feliga. Good afternoon, ladies and gentlemen. At the beginning, I would like to very warmly thank the National Judiciary School and the Ministry of Foreign Affairs for organizing the seminar for us all here, especially to the staff of the stakeholder institutions, and my special words of thanks to Director Justyna Chrzanowska, who invited me to sit on this panel, and I can for you run such a short panel session in such a respectable community. So the position I'm going to present to you is about the legal recourse and implementation of European Court. So I will basically limit myself to showing you those beautiful pictures of European Court of Human Rights. So very briefly, the thing I'm going to highlight has never been worked out in the doctrinal interpretation. It is also absent from operational interpretation. So as a practitioner, as the person who applies law in practice, I can see certain options for taking or not taking into account of legal recourse. Nevertheless, taking into account the legal recourse stays very close to the implementation of the decisions of European Court of Human Rights. So, it is not that every ruling of the European Court that has bearing on the subject of my presentation. No, only the one that has been implemented. And again, legal recourse will not apply to all implemented decisions. No, only those rulings which generated some benefits to the claimant, and certain penalties have been paid out by way of just satisfaction of doubts. Article 91 says that if the convention or its protocols were violated, and if the internal law allows only for partial removal of the consequences of violation, then just satisfaction should be paid to the wronged party. And then we come to the verdicts and rulings of the European Court. They take various forms and shapes. In this case, what I'm referring to is the verdicts where just satisfaction has been adjudicated. So there are three implications of such an adjudication. First, a certain measure that came under evaluation was deemed to be legal. In the second place, the party which infringed on certain provisions must carry out redress, and this is always the state as the signing party to the convention and all entities that belong to the state, and the adjudicated amount of money which in the event of enforcement of a verdict may be subject to recourse action, and the exercise of the legal recourse will always have bearing on state treasury in the understanding of internal law, because all the monies will be paid out from the state budget via Ministry of Foreign Affairs, and the appropriate body to represent state will be also state treasury. This is why, from our perspective, the existence of the institution of legal recourse may serve the implementation of European Court. If I need to pay some money by way of penalty as a result of my liability, it is an excellent instruction, so it is of great educational value for the future. If I violated the letter of the convention once, I will try not to do so in the future. So this is like an educational aspect. State treasury, in the sense of national law, can it seek recourse, legal recourse? Do we have in our substantive law basis for seeking legal recourse? Well, there are two entities where state treasury may seek legal recourse. This is theoretical assumption. The first group is the responsibility of state treasury for its own units, and the other group is responsibility for other entities not belonging to state treasury if the European Court decided that the treasury is liable for the actions. So in the first group, where treasury is in charge of its own units, underlying units, common courts of law belong to this category. And for instance, in the events of excessive length and violation of Article 6.1 of the Convention and the flagrant violation of law, when the excessiveness of length is so striking and obvious in the jurisprudence of European Court that it goes beyond any doubt, can state treasury seek legal recourse against the Polish common courts of law? No, because then the counterparty would be state treasury, and it would be also represented by the common court of law. And there is a confusion of parties to the litigation, and the defendant and claimants are very much the same party in the proceeding. That's why, on the basis of the legislation right now, we may consider another situation of the liability of state treasury for the wrongdoing of other entities, not state treasury entities, if the court deems them to be liable. The decision from October 2012, PIS against Poland, provides that liability of state in the face of making it difficult for a woman victim of rape to perform an abortion, whereas in line with the national law she was eligible for such an abortion, and the problem which emerged was the number of state entities that were found accomplices to this infringement, and I will describe to you the situation in a moment. But those entities, they have their own legal personality. They are legal persons, and therefore there is no confusion of parties in the litigation. As for the legal basis, I think that the provision of Article 441 of the Civil Code, the one who redressed the wrongdoing on injury which resulted from some failure to act, has the right to recourse to the original culprit. So this is how the originally guilty party who infringed on the convention will have to be the subject of recourse action. In practice, this means that sometimes such a lawsuit may be ineffective in that sense that the number of problems that are generated here is so high that I can only highlight the most basic rudiments. To what extent the European Court's decision is binding? It is still down to discussion in the doctrinal and operative interpretation. What is the application of the decision by the European Court? Are we only bound by the very verdict or the verdict and grounds? This is the question. I would say that we are bound by in issues where a verdict was issued, we are bound by the verdict of a sentence, but not necessarily the grounds, because common courts of law, when they write their grounds on other issues, do not mean those grounds to be of direct effect. But in decisions taken by the European Court, we can speak about prejudicial judgments which will be binding upon next cases. Well, this is a practical and also a theoretical consideration for the future. Another atypical problem that we have to face is that very often cases pending before the European Court show the situations where evidence is supplemented, additional evidence is presented, and this additional material is not taken into account when issuing the final decision. The third point is the scope of liability. Very often the European Court states that a whole state party is liable without indicating who in particular infringed upon a convention norm, and this makes it difficult internally to define who is finally liable for an infringement of the convention norm if the European Court put the blame on the whole state. Of course, this problem may not emerge always, but in P and S case, this will be a pending problem on how we are going to proceed with litigation. The burden of proof from Article 441 of the Civil Law Code. Well, the burden of proof will stay with the state treasury, and there is a whole scope of premises to be taken into account. The burden of proof is very ample and very exhaustive, and it does require in-depth examination because it takes into account the guilt, the delict, the wrongdoing, and the scope of recourse. Which entity and to what extent is going to be liable and to what amount? Because last but not least, the decision of a national law and recourse, legal recourse in Poland will have also contained a component of guilt, and guilt must be determined by the court, and recourse doesn't have to be proportionally the same for all parties guilty of wrongdoing. It seems to me that the lege lata, the exclusion recourse is possible in the first instance of entities. However, the lege lata, the scope of recourse is possible and available for those other entities, provided that the scope of recourse is well defined and the appropriate collection of evidence material and formulating positions will be necessary. The lege ferenda, it seems to me that in order to steer clear of the risk of escalation of recourse, it would be appropriate to take into account the situation of a state treasury and to define what entities belong to the state treasury and are liable vis-à-vis state treasury. And I would say that agreements should be set up between individual entities, because we cannot arrive at a situation where the claimant and defendant will be the same person. It is inadmissible in a civil law proceeding. Additionally, it seems to me that it is possible to divide liability in terms of percentage, in terms of lump sum payments, but this is down to be debated in the future. So let me end with my brief presentation. Thank you for the time given to me, and since there was no opportunity to do so, I want to thank Dr. Machińska, because it was her who engrafted in me the question of observance of human rights when I was a court assessor, and through a number of seminars she shaped me as a justice sensitive to human rights in issuing individual rulings. Thank you very much, Madam Doctor. Let me thank you, ladies and gentlemen, who survived until this very late moment of the seminar. The last panel, this is not the end. This is not the end. Madam Machińska, it is a pity you cannot take care of our penitentiary judges. It would have an excellent influence on them. Yes, penitentiary judges. Thank you. Thank you very much for your time, discipline, and may I now hand it over to Madam Bogdana Słupska for the next presentation. Good afternoon, ladies and gentlemen. Let me associate myself with the words of appreciation to justice. My encounter with European Convention was very much in the same circumstances as justice before me. Justice Feliga presented it. And I'm very grateful to organizers for inviting me here and for the ability to present a handful of comments on this very challenging topic of dysfunctionalities of the Polish law. And since I can present my comments from the perspective of a barrister who, by virtue of profession, is in the first line of defending human rights and protecting human rights. And this perspective makes it incumbent on me to see dysfunctionalities through the prism of functioning and effectiveness of law, availability of legal remedies, effectiveness of those remedies, and ability to provide effective legal aid. In discerning those dysfunctionalities in legal practice when we operate on behalf of our clients, we are really left stranded. That's why it is extremely precious for us to see the jurisprudence of the European Court of Human Rights in their statements. starting from not only rulings, but also whenever they communicate and notify cases to the attention of the government, they signal that there is a presumed infringement of the Convention, and what I find particularly welcome and precious is the methodology which has been adopted by the European Court, namely examination of an individual complaint and individual violation, and checking if a violation really took place. From that perspective, the Court tries to embark on a more general reflection, having examined the case in all its merits and having heard the parties. And for those of you who know this procedure, you will know full well what it looks like. So the role of a court, European Court of Human Rights, is very important as an institution that monitors the national legal system and diagnoses any systemic infringements. And this is the source of knowledge for us, barristers, a very precious source, because the court often says that the rights safeguarded in the Convention should be effective, not only in theory but also in practice, so that they exist materially in real terms. Ladies and gentlemen, coming now to the difficult topic which was formulated in the question whether proceedings security in civil law proceeding, and especially cassation appeal, and whether they are an effective legal remedy in situation of violation of human rights. Well, I will have to refer myself to the model of cassation appeal as it has been shaped following the amendment of the Code of Civil Law Procedure back in 2000, when the central institution was the pre-court proceeding, which is a kind of a barrier for parties who want their cases to be substantively heard and examined. So much depends whether a barrister in the course under 3984 will submit an appropriately substantiated appeal invoking such public law principles and premises as mentioned in 398.9, if I remember correctly. So arguments in favor of the public law interest prevails in this model, and at this stage it is the only argument to be examined by the Supreme Court of Law, and this is stated in case law, in doctrine. Nothing needs to be added here. Ladies and gentlemen, the Court of Human Rights, in cases that were submitted for examination, Siałkowska and Starowicz against Poland, and Justice Hermeliński is with us today, who represented, as a lawyer back then, Mr. Staroszczyk, whereas I acted on behalf of Krystyna Siałkowska in a case which really changed the legal system in country after dysfunction has been found out. And the case was on access to Supreme Court of Justice in a situation where an ex officio appointed barrister denied the applicant the right to cassation appeal, and has done so 3 days before the lapse of eligibility time, without informing the party about his position and about the options still available to the applicant to get another legal aid. In line with Article 6.1 of the Convention, a barrister instituted by the court may refuse to launch a cassation appeal following the decision from September 2000, but such a refusal must meet certain standards in order not to leave the parties stranded with a situation of legal uncertainty. So this jurisprudence resulted in the amendment of the Code of Civil Law Procedure 2009, which entered into force in April 2011, Article 118 of the Code, Article 118.6, 124, 124.4, all of the Code of Civil Law Procedure. And I have no time to quote those provisions verbatim, but through providing about the access to barristers and to legal aids, barristers are now disciplined. They know in what conditions they can refuse to file a cassation appeal, and they know what their deadlines are available to them and how new deadlines are fixed if the case is reopened and if a new legal aid has been appointed. So this is a major revolution. Does the practice change? Well, courts of appeal react to such applications from claimants who want to apply for cassation appeals and appoint new ex officio lawyers if requested to do so. And now let me tell you about an issue which illustrates to you full well the immensity of problems related to the cassation appeal, its caveats. This was the case of Adam D., whom I was defending ex officio in a case of, as he put it, he was an inmate, of redressing his injuries due to inhumane conditions in the prison where he served his sentence. This was his suit that he filed with the court, and as his agent, I lost my case in two instances, and being impressed by what the European Court of Human Rights stated in Siałkowska case, where we were made sensitive to the right to have access to court and to defense lawyers, I decided to opt for cassation in the Supreme Court of Justice on behalf of Adam D. And the Helsinki Foundation acted as amicus curiae in this particular case, and on the 28th of February 2007, the Supreme Court of Justice in Poland ruled out as follows. For the very first time, decided that an inmate deprived of his liberty may file a civil law suit in the face of violation of his personal interests, especially disregard of his dignity and intimacy due to overcrowding of prisons and overpopulation of prisons. Also, under Article 24, the State Treasury has a liability, financial liability in this regard, and there is also an assumption that there has been a violation of personal interests, so the burden of proof is on the part of the defending party, on the side of the defending party. Before the case landed in the Supreme Court of Justice, in the grounds, there was a statement saying that inhumane conditions or dire conditions in Polish prisons And the situation where there has been a flagrant and constant violation of square area available to inmates. This is especially painful for those serving long sentences. Well, this is extremely painful, but maybe someone who commits a crime should really take this into account. But this decision of European Court of Human Rights started retracking and regression from this tendency. On the 17th of March 2010, this idea was sustained and developed. What is important is what is happening in the meantime. In the meantime, there is a systemic problem, overpopulation of Polish prisons, as indicated in Orchowski and Sikorski case against Poland. And here again, the European Court provides a diagnosis for the condition of the Polish legal system and says that this is closely connected to overpopulation and the excessive use of pre-trial detention, and this problem must be resolved. We know that there is a ruling of the Constitutional Court. It introduces appropriate regulations to the Criminal Procedure Code in 2010. Human Rights Court in decision Latach against Poland decides that Latach's complaint is inadmissible. It is dismissed as inadmissible. And this is a pilot case, pilot decision because it leads in a way to a situation where the systemic problem has been somehow handled as in Orchowski-Sikorski against Poland. So cases pending in the European Court about inhumane conditions in prisons, more than 200, must be divided into two categories. Those eligible to be examined in the national courts because there has been no time prescription, as in the case of Adam D, and the defendants are no longer, or the applicants are no longer subject to overpopulation, because in the meantime appropriate corrective measures have been adopted by the government. And the second category of cases where the European Court of Human Rights left some time margin to the government to settle cases amicably. Coming back to the original case of Adam D, whose complaint and application, as the court said, this was like a landmark ruling which initiated a new situation and helped to usher in the new legal remedy, that is protection of personal interests under Article 24 for inmates who find themselves in prisons. Adam D, who after the ruling of the Supreme Court on the 23rd of February 2007 had his case heard by the Court of Appeal. His case has been additionally examined. Prison wardens were examined as well, and his case was dismissed, and everything was considered to be not that painful, not unpalatable, and my cassation appeal that I wanted to file again was dismissed, not to be examined. So here we landed with a paradox where an institution of pre-court proceeding produced a result, but without improving the situation of this particular applicant. In the case Latach against Poland, there is yet another important formulation to be found on the criteria of effectiveness of a national remedy, namely, it must be available and it must be effective in practice, but it must also provide financial compensation. And one can say that Adam D, in a way, brought about a revolution. He himself had not his rights safeguarded, but obtained the safeguard from the European Court and the Polish government, which in the pilot decision Latach against Poland granted him two sources of satisfaction or redress, and in the meantime Adam D. applied to the European Court on various periods of his stay in overpopulated prisons, and the government granted him several thousand zlotys or euro of legal redress.
Myślę, że ta sprawa pokazuje wszystkie problemy związane ze skargą kasacyjną.
I think it highlights the problems relating to the appeal and cassation. Sometimes individuals receive this protection from Supreme Court, but the criteria that were set for the claimants to fulfill are excessive. In conclusion, I see a conflict in the model of the appeal and cassation itself. It is a conflict seen through the eyes of the lawyer, a lawyer that does it for free, because they're also lawyers by choice or legal advisors, and it's different if I'm a court-appointed lawyer, because this court-appointed lawyer, of course, can bring appeal and cassation like I did, and with the support I received, I succeeded, but he may also decline, and it's very, very important to have the guarantees of independence for lawyers which are expressed for the systemic independence of the lawyer who cannot be swayed to act in this or other way. So in conclusion, I see this model of the appeal and cassation. There's an inherent conflict. Theoreticians say there's no problem because it's always linked to this interest, individual interest, but there's also the barrier of this prejudicial pre-court procedure, and this lawyer who acts ethically when he declines to lodge an appeal and cassation, he in a way substitutes the court, and this is not our role to substitute the court. Thank you very much for your attention. Thank you very much for a very interesting and motivating presentation. The next speaker is Dr. Grzegorz Borkowski, and he will also talk about a very important measure, which is a complaint to find final judgment inconsistent with law.
The floor is yours.
Thank you very much. Despite the fact that we are ending, and though you've introduced me in English, I will speak in Polish. I was asked to be brief, so I understand, because you want to take a walk and do some sightseeing in Lublin's old town. I'm either in Strasbourg or Warsaw, but I was born in Lublin. I very much would like you to see the beauty of Lublin's old town, so this is my motivation to be brief and to quote Professor Wyrzykowski and to remember that there's a clock in front of me, not a calendar. So I'll start with the following point. I will talk about complaints that exist in civil proceedings. We also have complaints in administrative proceedings, but Professor Nina Półtorak will talk about that. I like her presentation, so that's why I'll be brief. So, as to the introduction, most important provisions for us is the Constitution. So we have Article 9, which says that the Republic of Poland abides by international law. The next article that judges
Nie jest
are
specjalnie
independent
kontrowersyjną
and
tezą,
they're
chociaż
only
również
accountable to the Constitution, of course also accountable to international law. Article 77, this article will be the most important one for us. As we go along, everyone has right to compensation for damage that was rendered to him by inconsistent with law act of public authority. Inconsistent with law acts of public authority implies also court judgment. We'll see this norm specified in Civil Code 417 paragraph 2. If the damage was rendered by issuing a final judgment or decision, its redress may be demanded after proceedings are accorded, adequate proceedings are conducted to see that they are inconsistent with law unless specific provisions state otherwise. This is also true in the case of the final issued unconstitutionally, and I think we have that and the law. So in KPC we have regulations from 421 prim on with all these marks. So, we can demand that the final judgment is determined to be inconsistent with law if party was injured, and this is another important element. And in paragraph 2, we also have a specific information that the court of first instance, if this inconsistency of law results from violation of basic order and human rights violations, and the question arises at this point. Inconsistency with law. The question, what is law? I know with this question the vision of the walk sort of fades away. So the question whether the European Convention on Human Rights Protection, can that be a basis for this complaint? That is, violation of this convention, can it be grounds for this complaint? When I was asked to prepare this speech, I got scared because I couldn't find any case law or any doctrine, and Director Szanowska convinced me to saying this is the more reason for talking about this, but I did find, so maybe it will not be interesting, but so fortunately in 2008 the Supreme Court pronounced itself that indeed conventions provisions are not only an indication how to interpret domestic law, which is self-evident, but also can be a direct grounds for decisions, and they take precedence over a law, as Article 91.2 of the Constitution says. In 2008, the Supreme Court, from that moment on, the Supreme Court has taken more interest in this issue, because it not only takes into account the position of the court, but it also spoke about taking specific action to implement European Court judgments. Further on, the state has freedom and discretion to choose how to implement that judgment, but the basic obligation is to stop that violation and to remove its consequences. And what are how can it be done according to the court in 2008? Either it can be done through a complaint to find final judgment in consistency with law, or have a complaint to reopen proceedings, or to have a case to make the judgment unenforceable. It also stresses that it needs specific analysis of the court's judgment. Full agreement on that point. When it comes to reopening of proceedings, as we know, in 2010, the Supreme Court held that unequivocally, and there's a resolution of 7 judges of 2010 that reopening of proceedings, it set that aside, we're not interested in that, but in this resolution, the Supreme Court distances itself from its previous opinion expressed in 2008, saying that, well, that judgment was issued before a change of the civil code, and that needs to be taken into account when we analyze the institution of the institute. But it does not say definitely what it thinks, because it addresses the complaint to reopen proceedings in its resolution. These doubts can be dissipated by another decision of the Supreme Court. There, the Supreme Court said that a human rights judgment issued against Poland by the European Court finding violation of Article 1, Part 1 of Protocol 1, that is right to property, is not tantamount with saying that a normative act is unconstitutional, an act that was enacted as a result of adoption of an international agreement. It says there are no grounds to ascribe to the judgments of the European Court of Human Rights prejudicial questions the same rank as judgments. I wasn't entirely in agreement with this line of reasoning, and fortunately, the Constitutional Court recently, on the 22nd of September, sort of supported my opinion. I'm not sure whether the Constitutional Court said exactly what it wanted to say, because it addressed the issue of the running of the time limit, but when we read the grounds for the decision, the Constitutional Court states as follows: proceedings before the European Court ending with a final judge on the violation of Article 6.1 of the Convention can become grounds for adequate proceedings under understanding of Article 417, paragraph 1 of the Civil Code, but it will not always be considered as a prejudicial as with regards to judgments issued in violation of that law and the Convention. Not in every case the European Court judgment will open up the path for procedure for damages. What it means to me means that this will have to be found in proceedings on complaint to find final judgment inconsistent with law. Of course, I may be wrong. So, further, the Constitutional Court says in the present situation of law, it may be possible for the European Court of Human Rights judgment not to be enforceable in the process and through the complaint to find final judgment inconsistent, or in the procedure to claim damages from the state treasury. On contrary, when there are situations when it is not possible, then as a rule, it's possible. So either reopening or claiming damages from the state treasury. Is it always so? Well, that I don't know, but the judgment itself said that the court said that a 5-year term for lodging complaint to reopen proceedings is an excessive burden for the applicant, and the European Court said something needs to be changed in this respect, that 5 years is too little. As I said, this is a sort of a side thought, but assuming that the negative lawmaker, as the Constitutional Court is sometimes called, that they have right, then considering that the procedure of indemnification that can be addressed to the court is applicable. This, indeed, it means that this is a measure that can be effectively implemented. There are some problems with regard to this. It cannot be applied to all judgments, because Here we can speak only about judgment where there is damage. There is damage that needs to be proven because in proceedings on complaint it has to be made probable. But what the judgment speaks of is a violation. We're only halfway through. And when we have that, we can bring action against the regional court. And there, we need to prove damage, specific damage. So it will not be just a measure that is used to implement the convention in a situation when there was a violation and there was no damage. It will not be applicable also, I believe, to situations where the Human Rights Court says that there's a need to change the law or to change the practice. Then absolutely such a complaint will do nothing for us. Another issue that eliminates this complaint is that time. A complaint is lodged with the court within 2 years from the date of it becoming final. In the majority of cases, a party is not able to get a judgment from the European Court of Human Rights within the 2 years time frame. But in the context of a constitutional judgment, we can hope that we can interpret this provision differently, or someone will challenge it to the Constitutional Court. And the last issue that I see a problem is an issue that deals with a provision 4112 that second instance judgments and Supreme Court judgments are not appealable, and in order to file an application, an applicant must exhaust domestic measures. The European Court of Human Rights finds a violation, a party returns and says, I want to file a complaint, and the Supreme Court dismisses it, saying that we've already dealt with that issue or case. Whether we will find any points, we will find such points in the system of civil law, the newest ones, the only volume that has been published, talking about applicability or appealability. So the assumption is the following. Here I quote a view of the doctrine, I'm not quoting a Supreme Court judge. One should assume that Supreme Court judgments are ex definitione consistent with the law. Maybe this is out of context, maybe this deals with internal proceedings, but further on, this author says, exclusion of the complaint to find final judgment inconsistent with law caused some doubts in writing about its compatibility with EU law when it comes to violations of EU law, especially when violation of law was found by the European Court of Human Rights or the European Court of Justice. The doubts are excessive and they are the result of uncritical and overcorrect acceptance of all court pronouncements, which not always take into account the specific nature of the court system of the respective members of the European Union. The critics will not give us an answer how to control Supreme Court judgments issued as a result of control of earlier decisions of the same court. And if that decision is to be admissible, then why? There's also no reflection on the hypothesis that when we look at this problem in this way, also the court's decisions have no patent with compatibility with law, including EU law. So this leads us to another question: which body or organ should or can control it? So what, Professor, what about your idea to create a chamber in the Supreme Court?
czy choćby kompletnie.
or just, additional lessons. Okay, this is a quote from the system of civil law procedure. This is not such a minor article, as director said, so we're still a long way, ahead for us. But a Supreme Court judge, but yes, no, I've underestimated your astuteness, Professor. From my experience, it expired. I've spent 5 years in those beautiful buildings, but it wasn't so beautiful because there was repair and I left them and now it became beautiful. From my experience as a person who dealt with trainings of judges and prosecutors, I believe there's still a lot to be done. Director Machińska's role cannot be overestimated. I believe that cooperation with the National School of Judiciary and Public Prosecution will be only to the benefit of the persons who will be trained. I've had Supreme Court judges from different countries, and they discussed that they can be wrong. The Cyprus judges said, Cipriano against Cyprus, excellent judgment. I will not cover that judgment because I promised to be brief. Anyway, ladies and gentlemen, answering your question, because my presentation was in the form of a question in the present shape. This complaint, on account of the time frame, requires, it seems, a change of law because it cannot be interpreted otherwise unless we accept a wide interpretation in connection with what the Constitutional Court said in account of this provision on inadmissibility of filing a complaint against judgments decided by the Supreme Court. Here I would see as an possibility in connection with the provision of law which says that in final judgments which are not appealable, I think it can be said in that way, then damages for the damage is rendered by final judgment can be asked for unless the party declined to use its rights under the law. Even if we consider that at this moment the complaint is not useful, for sure it has potential to become a measure that will serve to effectively implement the convention. Thank you very much.
Dziękujemy bardzo za niezwykle ciekawe wystąpienie oraz
Thank you for a very interesting paper and your eagerness to engage in polemics. May I hand over now to Madam Professor Nina Półtorak. Thank you very much, ladies and gentlemen. General comment as for jurisprudence of administrative courts. Well, the organizers gave us just one paper to be presented at the end of a conference. How to interpret it? Maybe jurisprudence of administrative courts does not leave room for any criticism. Maybe we handle convention very well. And I will stick to this line of thinking in my presentation. Ladies and gentlemen, it has been stated for a long time, both in EU institutions and in Polish courts, that the Polish courts are European Union courts, so they need to enforce EU law and apply EU law in resolving various cases. Recently, in its report, the European Commission stated that courts and judges are the most basic actors in safeguarding rights contained in the European Charter. Of course, it has become a binding instrument only as of the adoption of the Treaty of Lisbon, but the application of the Convention is a story of much longer standing, and the application of a charter and the operation of the courts vis-à-vis the convention may be both discussed through the prism of Polish courts being EU courts or Polish courts being a convention courts to be bound by the convention in line with subsidiarity principle and Brighton Declaration 2012. Among the jurisprudence of European Court on Poland, the case law from administrative courts is hardly ever present, so hardly ever the decisions of the European Court have bearing on administrative courts. It happens much more rarely than in the case of civil law and criminal law courts. Whatever pertains to administrative courts, these are one-off isolated cases. Of course, there are also systemic problems like excessive length of proceeding. Nevertheless, those systemic problems are enforced on the case-by-case basis, which is confirmed by the reports of the Council of Europe and the Ministry of Foreign Affairs. My report is on the role of administrative courts in the securing of observance of a convention, and speaking about dysfunctionalities of Polish law, I must ask a question. Do administrative courts treat the convention as a legal instrument that allows to alleviate certain dysfunctions or remedy certain dysfunctions? So in that sense, I want to say in what format the convention is applied in the administrative courts of law and how we get involved and how the Supreme Court of Administration participates in legislative processes, lawmaking processes, in order to make sure that obligations arising out of the Convention and the jurisprudence of the European Court are duly met. What kind of forms of adjudication appear when convention is cited? The basic tendency to be seen for many years, typical not only for administrative courts but also other, is to invoke the convention and the case law in a subsidiary manner vis-à-vis decisions and provisions of Polish law which are the legal basis. So this is the legal standard to invoke Constitution, Convention and Charter of Fundamental Rights. Sometimes we as administrative courts are accused that the invocation of a convention is just for decoration purposes, ornamental purposes, to make our rulings more colorful. And indeed, this is a charge which may be to some extent justified, because in many rulings that are issued, there is an attempt to derive the standard of protection of fundamental rights from various sources, which is not evil in itself, because this way a court constructs a kind of a standard of protection of fundamental rights, but it may be incorrect if the invocation is only an invocation for invocation's sake, without any in-depth analysis, without getting deeper into the jurisprudence of the European Court. And this is what we see in the complaints filed with the administrative court. Very often the courts apply the convention standard without any analysis, and among many charges and criticisms that are leveled at various bodies, there is also a charge that a convention was violated without any solid grounds to justify this assertion. There are also certain decisions where the convention is the direct basis for a resolution, and on the basis of a violation of a convention, the administrative courts decide to appeal a previous decision or a previous ruling. As an example of this, we can indicate, for instance, rulings concerning the property rights, expropriation and indemnification. And here, both on the regional and central level, administrative courts quote Utaina case of the European Court of Human Rights and state the violation of Protocol 1.1, that is right to property. And this is happening both on the regional and central level. In the Supreme Court of Administration, in one of the rulings of 2009, the Supreme Court of Administration mentioned that Article 1.1 of the Protocol to the Convention provides that every single person has the right to own private property, which should be respected, and this is part of legal order of direct application in the internal system. So this is the repetition of Article 1 and statement that this provision is of direct effect and that decision may be founded only on the direct effect of the convention. Similar rulings apply to aliens residing in Poland. Here we quote convention and jurisprudence of European Court very frequently. And in our decisions in administrative courts, we directly found parties guilty of violation of Article 8, the right to protection of family life and family unity, referring also to Article 91 of the Polish Constitution. A question that is pending in this connection, when the violation of a convention was confirmed, so why was there no constitutional implication? Why would administrative court choose to adjudicate on the basis of the convention and not Polish constitution, which safeguards similar measures to protect property and family life? But the absence of constitution may be accounted for. There may be doubts whether those two standards are going in the same direction. I think that one of the basic reasons why it was rather convention and not constitution that was eagerly quoted was that the administrative courts have more problems with direct application of the Polish constitution in a case and not so much the convention, because the convention, the international agreement, gives us direct right in Article 91 of the Constitution, and the case law of the Constitutional Court and Common Courts of Law indicates this direct effect may be games of fortune from an exemption here, because the Constitutional Court's approach was somewhat different in that particular case. Nevertheless, we can see that Polish courts can directly apply international agreements and make them supersede existing national regulations. And as for the direct application of the Constitution, we have many statements of the Constitutional Court saying that this competence to direct application of the Constitution is not vested in courts. Other cases where administrative courts would invoke the Convention for the purpose of providing a verdict is when questions were sent to the Constitutional Court by administrative courts. And, for instance, Article 1 of Protocol 1, the property right, or Article 6 of the Convention, access to justice was taken into account, and our administrative courts asked about constitutionality of certain provisions, and quoting the Constitution, they also quoted Convention with various results, as we know, because the Constitutional Court not always believes that Convention should act as a constitutional model. Another form in which administrative courts refer to Convention and invoke Convention, because from my analysis follows that it is not very often applied, is Article 272, Clause 3 of the law on the proceeding before administrative courts, which allows to reopen a case after an international court issued a verdict. And this was added to the Code of Administrative Proceeding, and this was modeled after Article 540 of the Code of Criminal Law Procedure, and in grounds to this provision, the right to appear before administrative courts, it was stated that this is done in order to carry out the recommendations of a committee of Council of Ministers in order to reopen certain cases following a decision of European Court of Human Rights. So, from the perspective of legislative solutions, we have a clear-cut legal provision on the reopening of administrative cases following a decision from the European Court of Human Rights. But this decision has not been used frequently. The very requests to reopen the case are very rarely landed in the administrative court, and the only substantive decision that I found in the case law of administrative courts in Poland on reopening the case following the decision was the decision of the Supreme Administrative Court of October 2014, when the request to reopen the case was dismissed, even if the premises were fully satisfied, because the application to reopen the case was filed after the decision of European Court of Human Rights. So, on the basis of that decision, the applicant reached an agreement with the Polish court, obtained an indemnity, and administrative court that it should be Article 278 of the right on proceeding before administrative courts that should be applied here. And here we have a provision containing also time prescription. The decision of the Supreme Administrative Court was controversial in itself, especially in the light of a decision of European Court of Human Rights that was mentioned by Mr. Justice here from 2015, decision in which the Constitutional Court also believed that the provision instituting 5-year time prescription is unconstitutional in itself. Article 408 of the Code of Civil Law Procedure have very much the same wording, and the institution of reopening in the administrative law and civil law are very much the same. And the pending question is what is the impact of the decision of the Constitutional Court on the actual practicality before administrative court. Nevertheless, bearing in mind what decided the European Court in September on the time prescription, we should also take into account certain propositions that were contained in that decision on the necessity to exercise the Convention on the Protection of Human Rights. And Article 91(1) of the Constitution grants special legal status of a convention, so it is an instrument of direct effect in the Polish law, doesn't require any act of law, and supersedes national national acts of law. So we really know how important Article 91 is for application of a convention. Article 46 of a convention is the implementation of the constitutional rule of being bound by international law. So here a constitutional court clearly stated that in the Polish constitution there are ample bases for why decisions of the European Court should be fully executed. So, the obligation to carry out decisions of the European Court are fully constitutionally mandatory under Article 91. They must be enforced, they must be executed in Poland. What is also important from the point of view of application to reopen the case is the decision of 2013 of the Supreme Administrative Court, which did not pertain to reopening of cases after decisions of the European Court of Human Rights, but after the decisions were taken by the European Court of Justice. And here similar logic has been applied for reopening of cases. So it is not only for reopening of cases as adjudicated by the European Court of Human Rights, but also European Court of Justice in Luxembourg, and only the party which was the party to the proceeding before an international court may be eligible. The question was whether any other party could be also eligible if the decision of a court was impacting legal situation of a party. We know that the provisions about the reopening of cases provide that such an application may be filed within 3 months from being notified about the decision. So only the party who received this verdict, who was the party before an international court, would be eligible to ask for reopening of a case. So the Chief Administrative Court in its decision of 2013 stated that the regulation on the deadline for the proceeding should not limit the notion of a party eligible to ask for reopening of a case. And who is the party? Well, this is a separate story on the basis of general provisions on reopening, and the deadline should be defined in such a way so as to make it possible for all parties to ask for reopening of a case, not only the party which appeared before the International Court, but also other affected parties. And also those other affected parties have the right to submit their claim within 3 months from the publication and announcement of the decision of an international court. Yet another form in which administrative courts can refer to the jurisprudence of the European Court of Human Rights is the complaint requesting to state incompatibility with a binding law. In PPSs, in cases pending before administrative courts, this institution was set forth in 2010. And as it is the case in the civil law procedure, also in administrative procedure, you can say that the decision reached by the lower ranking court was incompatible with law, and the Supreme Court of Administration can state so. However, we have an exemption from this rule, that incompatibility of the law can be requested at the level of a regional court. Namely, it is stated that also against the decisions of Supreme Court you can appeal, provided that its decision was in flagrant violation of EU legislation, which was in the Fraghetti case, where member states were considered to be responsible for making it possible to appeal against decisions of the Supreme Courts of Justice in those respective states. So the question was, in cases pending before the administrative court, whether the flagrant violation of EU law, as mentioned in 285A, would be also stated if the convention was flagrantly violated. And here, in the decision of the Supreme Administrative Court of 2014, it was stated that the notion of the European Union law does not include convention law. Of course, Article 6 of the Treaty about the functioning of the European Union provides that EU should really observe convention law as well, but it doesn't mean that the convention is part and parcel of the EU law. It is not. And here the administrative court referred to the decision on Camberite ruling, where similar proposition was formulated, and also stated that the European Union has not acceded to the convention. The open question is also whether upon its accession to the Convention, the European Union will need to change its position, and the Supreme Court of Administration should change its position as well. As for the scope of invoking case law of the European Court of Human Rights and the Convention itself, well, I have no time to mention this, but let me just limit myself to describing to you two types of cases where the convention is invoked, and this had bearing on amendments, especially in cases involving aliens, as I mentioned to you before. Here, on many occasions, Supreme Administrative Court interpreted family life, the notion of family life, differently than administrative organs, broadening the notion of family life. For instance, in its decision of 2011, it also covered out-of-wedlock relationship, and this interpretation was then quoted in many new cases, and legislative changes were adopted in the law on aliens from 2013. In its new wording, the law on aliens directly invokes the notion of family life in the sense of Article 8. Each time they regulate the residence permits to be granted to aliens, and looking at the legislative track, the legislator doesn't say that the amendment is needed because of case law of administrative courts, but because the law itself calls for an amendment to make it fully compatible with case law of the European Court of Human Rights and administrative courts as well. The other example I want to quote to you is assemblies. As we know, Human Rights Court in Bączkowski case stated that Poland violated Article 13 and 11 of the Convention, not allowing to appeal in a due time against a decision violating the right of assembly. The law on assemblies entered into force only on the 13th of October 2015. It fully reforms the appeal procedure for assemblies. It introduces a new rule, new jurisdiction of common courts of law in an appropriate mode, fast-track legislation, when the courts are supposed to examine cases extremely quickly. And this change enacts the decisions of European Court of Human Rights, but this is also a bow in the direction of the Constitutional Court 2014, when Constitutional Court believed that the law on public assemblies is unconstitutional in its then existing shape. As for the forms of invocation of a convention and the case law of the European Court of Human Rights, well, I have highlighted all the points that deserve your attention, but let me briefly tell you about the impact that the Supreme Court of Administration may have on amendments of legislation on the basis of the proceedings before administrative courts. We had also the problem of lengthiness of cases, so Fuchs class cases, where the court stated that administrative procedures do not satisfy the necessity to warranty full effectiveness of proceedings. This was implemented by the Polish legislature by rolling out many legislative changes, including complaint against excessive lengthiness, launched in 2004, then complaint in 2011 against lengthiness of administrative proceedings, but always there were certain decisions where Court of Human Rights believed the Polish remedies would not finally turn around the situation, and the timing of decision was reasonable. So, bearing in mind this case law, the most recent amendment was rolled out in proceedings before administrative courts. It entered into force in August 2015, and this amendment has been dictated by the necessity to end administrative cases as quickly as possible. Because the problem that administrative courts had was not that they were really prolonging of the proceedings unnecessarily, but that an administrative case is not handled properly because administrative organs do not respect the decisions of the court and do not respond quickly. So the solutions which were put in place in this amendment reform also this issue, allowing the courts of first instance, voivodeship courts, to order to administrative bodies to issue a decision in a certain deadline, and if they fail to do so, the party may complain against failure to enforce the decision of the administrative court, and if we find that this complaint was legitimate, a kind of an indemnity may be awarded. It is not called indemnity in the body of law, but this is a kind of redress for failure to carry out the decision of the administrative court.
Także odszkodowanie w cudzysłowie na rzecz strony. I proszę Państwa, już zupełnie na koniec, także sądy administracyjne prowadzą szeroko zakrojone działania
Administrative courts carry out certain educational activities when they analyze jurisprudence of European Court and their decisions, and in the course of this analysis we make available to justices or administrative courts as much of knowledge as possible so that they could draw on what has been produced. One of such forms is an agreement signed between the Ministry of Foreign Affairs, and here I want to bow to the Ministry of Foreign Affairs for their involvement in promotion and spreading the word among administrative judges, We translate decisions of European Court of Human Rights and we cooperate with MFA. We know that some of jurisprudence is not available in the Polish language version, so this is an obstacle to benefit fully from these verdicts. We have many analytical documents as well. I cannot quote them for the brevity of the time that has been left to me. And finally, it seems to me that the provisions of law that I mentioned indicate that administrative courts tended to treat the convention as a way to do away with all dysfunctionalities of a Polish law, which doesn't, of course, mean that everything has been perfectly regulated. Much remains to be done in this respect, but it seems to me that the most basic problems which are related to the attitude of administrative courts of law to convention has been overcome.
To oczywiście stosowanie konwencji jest rzadsze, ale to wszystko jest usprawiedliwione poprzez
administrative court do not really apply European Court of Judgment to such a large extent. But the basic problem which I see here, or the dysfunction in the convention in this respect, is the fact that courts, any court, cannot ask the European Court of Human Rights how to interpret convention in a specific case. They may ask the Constitutional Court, they may ask the court in Poland, but they cannot do that with respect to European Court. But I hope that Protocol 16, that I hope Poland will soon sign, will give us this opportunity. Thank you very much. Thank you very much, Professor, for your presentation. First of all, question to the organizer. Do we have a time for discussion or are we closing? I think, let me just thank very much our panelists for sharing their very interesting experience and thoughts on the effective remedies when it comes to human rights violations. At the same time, if any of you have any questions or would like to discuss the papers, I encourage you to discuss. I think we have exhausted our audience. So thank you so much for your participation. I think we've been very exhaustive. I think this exhaustion will be just momentarily. Excellent panelists, thank you very much. I also would like to extend my thanks to the participants and the previous speakers. I would also like to thank everyone who attended the seminar and would like to extend my special thanks to Director Justyna Chrzanowska and her team from the Ministry of Foreign Affairs. She was the heart of this event. With her participation and her input, we would not even could imagine to host such excellent speakers and excellent guests, whom I thank once again for being with us for so long. The program includes a sum up. In one sentence, I will try to sum up, and I will refer to what Professor Balcerzak said. He referred to the first Warsaw seminar that took place in Strasbourg, and he said that everything is still topical. I hope that on the 18th Warsaw seminar, the post-conference materials will have not only merits as to their value, but also the value will be historical. Thank you very much for your presence again. Just for the sake of order, guides are waiting for you in the lobby. If anyone is interested in winning, I would ask you to come with us to take a walk through the streets of Lublin, and perhaps you will see the climate written in the poems of Józef Czechowicz.
Pozostałych państwa, którzy
Those
nie
of you
są
who are not
zainteresowani
interested
spacerem
in
po
taking
Londynie,
a walk,
zapraszam do
please
pozostania,
stay
ewentualnie
and
również
continue the
tutaj w
discussion
budynkach szkoły będziemy państwa
here.
często gościć.
We'll be happy to welcome
Porządek
you.
kolacji jest przewidziany na
Dinner
godzinę
starts
20,
at
ale
8
jeżeli
p.m.,
spacer
but
rodzinny się
if the
przeciągnie,
walk
też nie będzie
takes
problemu.
longer, there will be no
Szkoła dzisiaj
problem.
jest dla
The school
dla
is
państwa
open
otwarta całą
for you
dobę.
24
Dziękuję bardzo.
hours. Thank you very much.
Szanowni Państwo, jeszcze z mojej strony
I would like to, on behalf of the Ministry of Foreign Affairs and the Minister, to thank Director,
wszystkim pracownikom
all
szkoły za podjęcie tego
schools
wyzwania, pewnej ekwilibrystyki,
staff
organizowania seminarium
for
warszawskiego
organizing the
w Lublinie,
Warsaw
ale
Seminar
szczególnie
in
cenne,
Lublin,
dlatego,
but
że
this
dało
was
szansę
very
innemu
important
regionowi
because it
Polski
gave a chance for another
prowadzić
region in
tutaj
Poland
lżej
to
i naprawdę
come
porozmawiać o
together
tak
and to
praktycznych
talk about
tematach
such practical
dotyczących
issues
nas
which
wszystkich
affect
jako
all of us
praktyków od
as
różnych
practitioners
stron.
from different walks of life. Well, I would like to extend my warm thanks to all moderators, all panelists, for their excellent preparation, for devotion, for taking up the challenge to discuss issues that have not been dealt with so much in Polish doctrine, and thank all of you who have come here and been with us all day during the debates, which have taken longer than the agenda provided for, and we hope that see you again, and I hope to see you again at the next Warsaw Seminar.